them as soon as you direct, my lord.
My lord, with your kind permission, that will answer, appearing for the Law Society of Kenya and also for Wiper Democratic Party or interested parties. My lord, if the orders are to expire today, then that will be at midnight. My lord, the day is not yet over. We have applications in the afternoon. We are also affected by these orders. And my lord, I suggest after the applications today, then we can discuss that matter before the court adjourns. I thank you, my lord.
My lord, giving on behalf of the petitioners, there are two issues. You can see the senior, the leader of the Forum, which is not last in the answer. That is the first thing that we do in the afternoon. And as far as we are concerned, the matter is premature, and the hearing and determination of that applications for the simple reason that the issue and another had already been made that will be first dealt with by the court at yesterday. There's an application for recusal. The other matters that relates to how we shall deal with the petition, and we shall deal with all the applications, including the first application for conservative orders. Those are matters that, as far as we are concerned, are supposed to be dealt with by the directions. By this bench, it continues, or by any other bench. And therefore, the issue might not over back and forth, or what is to be heard first. The court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here, because we have started a little bit late, there is some work we still needed to do with regard to the applications for the afternoon. So we would like any other businesses that is supposed to be done when, for example, one meeting is in the afternoon, we don't do the afternoon. But my lord, on the directions, the actual directions that have been given by the court, there are three things actually that we would like our reactions on behalf of the petitioners. Number one, my lord, is that within these directions, we are understanding that the directions are being made pursuant to the rules of procedure that are applicable. And the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday are the ones that were filed even on Friday last week are maturing their last dates for responses. Now, as we sit here, we are yet to receive any substantive responses to all those petitions in either hands from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So, my Lord, I would be expecting that as a further direction, everybody would be required also to comply with the rules to the full. Now, the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating the impeachment that was done last Thursday, and the facts as they happened on Friday. A lot of these petitions will require some amendment so that they conform with the last petition, so that they are not termed as academic. So that may not towards that, the petitioners, including the petition they are participating, we have requested formally that we would want 3 days to ensure that any amendments are carried out. And then the respondents will indicate they have been saying they can do things within a day or two. They will indicate how much time they need to do the responses. Because that would assist in ensuring that whichever bench is going to hear and determine this matter will be able to give final directions, because as we have said, these are interim directions. And number 3, in order to be able to determine issues for determination, these are issues that we deal with when we are doing pre-trial. Issues for determinations that are essential in the matter with so many parties, that would require close of pleadings. And the close of pleadings means that all the responses must be given. So that, my Lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses, in accordance with the protocol, should complete that journey. My Lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my Lord, unless there is any other matter, because there was no other matter that was to be dealt with in directions, we will be happy to leave this place as soon as possible so that we are ready in the afternoon. We are not so ready.
Just before leaving, because I want the same side for absolutely I have some response on it. Your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of Counsel for the Senate to the process of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kilgore, Your Lordship, was categorical that he granted prayer number C, even as we await Senior Counsel Paul Mojo to come. Good afternoon. The wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner. That pending the hearing and termination, of this application inter parties, this honorable court be pleased to grant the order that was granted. That is therefore to bring Your Lordship that question that Senior Counsel has not sitting in the pleadings before you. Number two, Your Lordship, since we are here for mention and in the afternoon we are coming for the application for Recusal, and I have the advocates for the respondents insisting on the urgency to hear the application for setting aside. Your Lordship, it is important for the court to note that that application is not predicated on the evidence house. And therefore, if I were there, I would be seeking guidance on how to find the replies. Your Lordship, I hope you are following. It doesn't seem to be following. Why do you say that? Why would you say that?
Thank you. I think that is, sorry, Judge, you cannot talk forever. On a very small issue, we do confirm that for His Excellency, the Deputy President, Gachagua, as the petitioner, we have not received responses from the respondents. So it is important that first of all we get directions for filing of responses, because as we speak now, we have not received those responses from the respondents. The number two, my colleague Senior Kibe has raised issues on filing of responses, so that in 522 we have given an indication that we might require to amend our pleadings, so that before the ruling that was delivered by this bench, there was indication that we might require to amend the pleading. That is in petitions in cohort number 1, so that if the court can grant us leave within 3 days, those amendments can be done. And thereafter, this can also probably affect in some petitions, cohort number 2. So it is important that we get that particular direction. Finally, my lords, this proceeding, because of the nature the way they are proceeding, we request that probably we be provided with sequentially the transcribed proceedings, so that in case we require the proceeding at any time, those can be availed for purposes of good order. That is all.
With due respect to Counsel, we do not intend to make today this hearing a long hearing. We have been courteous enough, we have read our directions, think you should let us wait for proceedings in the afternoon.
Sir, I have something to say. Number one, the petitioners cannot approbate and reprobate at the same time. They are calling upon the respondents to file their responses. At the same time, they are seeking leave to amend the petitions. How would petitions that are to be amended be responded to when actually it should be the amendments that should come first and then the responses follow? Number two, we brought to the attention of the petitioners that the interim order, one of the interim orders expires today, and the other one is the one we are complaining about, that it is actually aggrieving the respondents and should be set aside, the Kiroya order. Therefore, we shall be delving into that as soon as it is practicable. And number three, the reason why we are here and from the day before yesterday is due to the applications that were filed on the 18th of October to set aside the ex parte conservatory orders. Therefore, that urgency cannot be lost or cannot be clouded in whatever else they are saying. It is our position that we should actually proceed and be heard on why those conservatory orders should be set aside. Thank you.
Which cohort? In your own name. So you are petitioner number 8? No. Interested party number 8?
Thank you, my Lord. We just want to restate the position that the urgency in this matter cannot be gainsaid or cannot be lost in alone. Under the condition that the replies have not been made, that we have not made the replies is not correct because we have filed our responses. And my Lord, at the end of the day, the very essence that led to the empowerment of these churches will actually be lost, because then we will be going back and forth, and at the end of the day, my Lord, we will not have served the greater public interest or the greater public good that led to the empanelment, which you made a determination yesterday, my Lord. We would urge that we be able to proceed and argue this matter conclusively and rest it once and for all.
Thank you. We are no longer accepting any further submissions. I'm saying this, that it is not for court to direct parties when to respond to pleadings. It is not for court to direct parties when to respond to pleadings, but one thing which I can assure you that this bench will not allow anybody to take the process of court in circles. So if you have been served the document, whether a petition or an application, if you don't respond, the court is allowed to infer that you have no response. If a petition has been filed and you have not responded to it, the court will make inference that you have no response to that petition. And by the very nature of these proceedings, we all acknowledge that they are public interest proceedings. Nobody will be allowed to take the court in circles. So I ask you, respond to the pleadings, file your petitions, respond to them. Don't come and ask for leave in a manner to suggest that you want to take this court in circles. We meet at 2:30. Thank you.
was categorical that he granted prayer number C. Even as we await Senior Counsel to come in the afternoon, the wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner. That pending the hearing and termination, of this application inter parties, this honorable court be pleased to grant the order that was granted. That is therefore to bring your lordship that question that Senior Counsel has not sitting in the pleadings before you. Number two, your lordship, since we are here for mention and in the afternoon we are coming for the application for Recusal, and I've had the advocates for the respondents insisting on the urgency to hear the application for setting aside. Your lordship, it is important for the court to note that that application is not predicated on any response. And therefore, if I were there, I would be seeking guidance on how to find the replies. Your lordship, I hope you are following. It doesn't seem to be following. Why do you say that? Why would you say that?
Thank you. I think that is... Sorry, gentlemen. You cannot talk forever.
On a very small issue, we do confirm that for His Excellency, the Deputy President, Gachagua, as the petitioner, we have not received responses from the respondents. So it is important that first of all we get directions for filing of responses, because as we speak now, we have not received those responses from the respondents. The number two, my colleague Senior Kibe has raised issues on filing of responses, so that in 522 we have given an indication that we might require to amend our pleading. Before the ruling that was delivered by this bench, there was an indication that we might require to amend the pleading. That is in petitions in cohort number 1, so that if the court can grant us leave within 3 days, those amendments can be done. And thereafter, this can also probably affect in some petitions, cohort number 2. So it is important that we get that particular direction. Finally, my lords, this proceeding, because of the nature the way they are proceeding, we request that probably we be provided with sequentially the transcribed proceedings, so that in case we require the proceeding at any time, those can be availed for purposes of good order. That is all.
With due respect to Counsel, we did not intend to make today this hearing a long hearing. We have been courteous enough, we have read our directions, and I think you should let us wait for proceedings in the afternoon.
Sir, I have something to say. Number one, the petitioners cannot approbate and reprobate at the same time. They are calling upon the respondents to file their responses. At the same time, they are seeking leave to amend the petitions. How would petitions that are to be amended be responded to when actually it should be the amendments that should come first and then the responses follow? Number two, we got to the attention of the petitioners that the interim order, one of the interim orders expires today, and the other one is the one we are complaining about, that it is actually aggrieving the respondents and should be set aside, the Kiroya order. Therefore, we shall be delving into that as soon as it is practicable. And number three, the reason why we are here and from the day before yesterday is due to the applications that were filed on the 18th of October to set aside the ex parte conservatory orders. Therefore, that agency cannot be lost or cannot be clouded in whatever else they are saying. It is our position that we should actually proceed and be heard on why those conservatory orders should be set aside. Thank you.
Which cohort? In your own name. So you are petitioner number 8? No. Interested party number 8?
Thank you, my Lord. We just want to restate the position that the agency in this matter cannot be gainsaid or cannot be lost, my Lord. Under the condition that the replies have not been made, that we have not made the replies is not correct because we have filed our responses. And my Lord, at the end of the day, the very essence that led to the empowerment of these churches will actually be lost, because then we will be going back and forth, and at the end of the day, my Lord, we will not have served the greater public interest or the greater public good that led to the empanelment, which you made a determination yesterday, my Lord. We would urge that we be able to proceed and argue this matter conclusively and rest it once and for all.
Thank you. We are no longer accepting any further submissions. I'm saying this, that it is not for court to direct parties when to respond to pleadings. It is not for court to direct parties when to respond to pleadings, but one thing which I can assure you that this bench will not allow anybody to take the process of court in circles. So if you have been served the document, whether petition or an application, if you don't respond, the court is allowed to infer that you have no response. If a petition has been filed and you have not responded to it, the court will make inference that you have no trust of that petition. And by the very nature of these proceedings, we all acknowledge that they are public interest proceedings. Nobody will be allowed to take the court in circles. So I ask you, respond to the pleadings, file your petitions, respond to them. Don't come and ask for leave in a manner to suggest that you want to take this court in circles. We meet at 2:30.
Katika kipindi tunakuletea wasanii.
What's up my guys? I go by the name Rejoinders.
Eti nikipita kwa macho na nipimia, na kama sina pesa unguwezi nipimia. Hapa Shensta the poet manze.
Ngoma moto moto.
If you wanna show some love, but don't fake it. Ida kumenya mawazo makuu. Nani anadera shida? Oh, utani waku.
Vichekesho mkisongaza, mahojiano moto moto, stori za wasanii pamoja na talanta za wasanii.
Fiki wa kasi gani kama wapatikani wakati wa shida.
The way forward depending on the outcome of the proceedings before the Senate. As it is, the Senate proceedings ended with the impeachment of DP Gachagua. As a result, several other petitions challenging that process were filed. We shall hereinafter refer to such petitions as those in cohort 2. Those are the petitions that were consolidated, and Constitutional Petition number is 565 of 2024 became the lead file. Having considered the nature of the petitions before us, and with a view of conducting those proceedings in an orderly manner, we hereby issue the following further directions. 1. All the petitions shall forthwith be dealt with as those in cohort 1 or cohort 2, respectively. 2. Courts shall, pursuant to Rule 17 of the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedures, Rules 2013, on its own motion, consolidate any other petition, refer to this bench either into any of the two cohorts. 3. For clarity, the petitions are hereby consolidated under the two cohorts as follows. Petition in cohort number 1, Nairobi petition number E522 of 2024, that is the lead file. Then we have Nairobi petition number E506 of 2024, Nairobi petition number E509 of 2024, Nairobi petition number E525 of 2024, Nairobi petition number E528 of 2024, Nairobi petition number E537 of 2024, and Nairobi petition number E541 of 2024. The petitioners in those consolidated petitions are as follows. 1. Regarding Gachagua. 2. Obulu Namea. 3. Kennedy Kamiki Gachagua. 4. Dennis Okumu. 5. Simon Mchangi. 6. Peter Maina. 7. Gema Watho Association. 8. John Nubo Kiragu. 9. Njomu John. 10. Caroline Wambui Mwangi. 11. Dr. Clarence Eboso Mwaresa. 12. Wanjiru Mwangi. Those are the petitioners in cohort number 1. Respondents in that cohort are 1. The Speaker of the National Assembly of Kenya. 2. The National Assembly of Kenya. 3. The Speaker of the Senate of Kenya. 4. The Senate of Kenya. 5. The Deputy Speaker, National Assembly. 6. Honorable Moses Masika Watangula. 7. Honorable Amason Kingi Jeffa. 8. Honorable Attorney General. The interested parties in that cohort are 1. William Samuel Ruto. 2. Law Society of Kenya. 3. Mount Kenya Juris. That is cohort number 1. Petition in cohort number 2. Nairobi petition number E565 of 2024, that is the lead file. Nairobi petition E550 of 2024. Nairobi petition E570 of 2024. Nairobi petition E572 of 2024. Karigoya petition E013 of 2024. Karigoya petition E014 of 2024. Karigoya petition number E015 of 2024. The petitioners in those cohorts. Chori, Kamotho 6, Grace Mdoni, Mangi 7, Clement Mchiri, Mreki 8, Edwin Munene Karoki 9, Sharia Mtani na Shadrach Wambui 10, Father Eddie Waiguru. From time we know that Father Eddie Waiguru is in the list of E570 of 2024, and there are 32 petitioners. So from Father Eddie Waiguru, we add all the petitioners in that petition, which come to 32 and ends with Gema Wato Association. Respondents in the court are as follows: Speaker, National Assembly of Kenya; 3, Speaker, Senate; 4, Senate of Kenya; 5, on Attorney General; 6, H.E. William Ruto; 7, Clerk of the National Assembly; 8, Deputy Speaker of the National Assembly; 9, on Mwengi Mthwe; 10, United Democratic Alliance; 11, Orange Democratic Alliance; 12, Kenya Kwanza Alliance; 13, Ford Kenya Party; 14, Amani National Congress; 15, Rejoinders Political Party; 16, Independent Electoral Boundaries Commission. In that cohort, the interested parties are follows: the Law Society of Kenya, Professor Kithure Kindiki, Wiper Democratic Party, Jubilee Party of Kenya, Katiba Institute, Mount Kenya Jews Association. And then let's be Kithure Sharia. And through those we direct that all filings and service of documents shall be done electronically through the court's electronic portal in the respective court's lead files. Parties shall accordingly ensure that they are duly marked into the system. The Honorable Deputy Registrar of this division shall assist if need be. Any counsel or party appearing in these petitions shall, before the start of any court proceedings, record such appearance in the quorum forms that shall be provided by the court assistants in this bench. Those appearing virtually shall as well log in and register their presence through the court assistants. As directed on 23rd of October 2023, any application in either of the cohorts seeking the recusal of the judges in this bench shall be heard today at 2:30 p.m. Those directions can be accessed in this court's electronic platform. These directions can be accessed in this court's electronic platform in the respective lead files. This court shall give further appropriate directions in the respective cohort's lead files as and when necessary. Thank you very much. The directions subject to amendments which have come from you will amend it and then upload it.
My Lord, with the kind permission, if we may be allowed to address the court. My Lord, we are guided by the directions issued by the court. We however have one concern from our side, my lords. My lords, there are interim orders that were issued in Kerugoya, and in our understanding, from our interpretation, once the file was referred to this court, the orders expire today. That's our understanding. And my lord, we are going to seek the court's guidance on the hearing of our application dated 18th October. Of course, we understand there is a recusal application today. But given the fact, my lord, that our interpretation that those orders would expire on the appointed date, which is today, when the matter was meant to be mentioned, our colleagues' understanding, my Lord, is that the application, in the public interest, be prioritized so that we are able to hear the application for setting aside of those orders. In any event, my Lord, the orders in question were issued by one judge. The matter has now been referred to a 3-judge bench. And their nature is problematic, as mentioned by the court. And we would pray that in terms of aligning the hearing or scheduling the applications to be had in cohort 2, that if possible, my lords, we do not want to do anything outside the law. We would request, my lord, that we be had today if it's possible, because the orders expire today. I think my lord, friend Gungo, we just want to add something on that.
My Lord, very briefly, I would want to repeat what my Lord, I just wanted to indicate that I would not like to repeat what learned Senior Counsel Professor Tom Ojenda has indicated, but just for completeness of record, there are 2 applications. There is one by the Honorable Attorney General and one by the National Assembly dated the 18th of October 2024. We are ready, we will be there for them as soon as we direct, my Lord.
My Lord, with your kind permission, Gabriel Manzi, appearing for the Law Society of Kenya and also for White and Democratic Party or interested parties. My Lord, if the orders are to expire today, then that will be at midnight. My Lord, the day is not yet over. We have applications in the afternoon. We are also affected by these orders. And my Lord, I suggest, after the applications today, then we can discuss that matter before the court adjourns. I thank you, my Lord.
My Lord, keeping in mind on behalf of the petitioners, there are 2 issues. You can see the senior, the leader, of the level of one which is not that's in the answer. That is the first thing that we will reach in the afternoon. And as far as we are concerned, the matter is premature and the hearing and determination of that applications for the simple reason that the issue and another had already been made that will be first dealt with by the court at Counsel yesterday. There's an application for Recusal. The other matters that relates to how we shall deal with the petition and we shall deal with all the applications, including the first application for conservative orders. Those are matters that as far as we are concerned are supposed to be dealt with by the directions. By this bench, it continues or by any other bench. And therefore, the issue by order of back and forth or what is to be had first, the court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here because we have such a little great, there is some work we still needed to do with regard to the applications for the afternoon. So we would like any other differences that is supposed to be done when, for example, all meetings in the afternoon, we don't do the afternoon. But my Lord, on the directions, the actual directions that have been given by the court, there are 3 things actually that we would like our reactions on behalf of the petitioners. Number 1, my Lord, is that within these directions, we are understanding that the directions are being made pursuant to the rules of procedure that are applicable. Under the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday are the ones that were filed even on Friday last week are maturing their last dates for responses. Now, as we sit here, we are yet to receive any substantive responses to all those petitions in either hands from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So, my Lord, I would be expecting that as a further direction, everybody would be required also to comply with the rules to the full. Now the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating with the impeachment that was done last Thursday, and the facts as they happened on Friday. A lot of these petitions will require some amendment so that they conform with the last petition, so that they are not termed as academic. So that my Lord was that the petitioners, including the petition they are participating, we have requested formally that we would want 3 days to ensure that any amendments are carried out. And then the respondents will indicate, they have been saying they can do things within a day or 2. They will indicate how much time they need to do the responses. Because the Lord that would assist in ensuring that whichever bench is going to hear and determine this matter will be able to give final directions, because as we have said, these are interim directions. And number 3, in order to be able to determine issues for determination, and these are issues that we deal with when we are doing reach out, issues for determinations that are essential in the matter with so many parties, that would require close of pleadings. And the close of pleadings means that all the responses must be given. So that, my Lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses in accordance with the rules will complete that journey. My Lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my Lord, unless there is any other matter, because there was no other matter that was to be dealt with some directions, we will be happy to leave this place as soon as possible so that we are ready in the afternoon. We are also obliged.
Just before leaving, I think because I'm on the phone, so perhaps I have some response on it.
Your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of Counsel for the Senate to the notice of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kilgore, Your Lordship, was categorical that he granted prayer number C. Even as we await Senior Counsel Paul Mojo to come in the afternoon, the wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner. That pending the hearing and termination, of this application inter parties, this honorable court be pleased to grant the order that was granted. That is therefore to be in the Lordship that question that Senior Counsel has not sitting in the pleadings before you. Number 2, Your Lordship, since we are here for mention and in the afternoon we are coming for the application for Recusal, and I have the advocates for the respondents insisting on the urgency to hear the application for setting aside, Your Lordship, it is important for the court to note that that application is not predicated on the evidence house. And therefore, if I were there, I would be seeking guidance around the file and replies. Your Lordship, I hope you are following. It doesn't seem to be following. Why do you say that? Why would you say that?
Thank you. I think that is... Sorry, gentlemen. You cannot talk forever.
My Lord, on a very small issue, we do confirm that for His Excellency, the Deputy President, Gachagua,
as the petitioner, we have not received responses from the respondents. So it is important that first of all we get directions for filing of responses, because as we speak now, we have not received those responses from the respondents. The number two, my colleague Senior Kibe has raised issues on filing of responses, so that in 522 we have given an indication that we might require to amend our pleadings, so that before the ruling that was delivered by this bench, there was indication that we might require to amend the pleading. That is in petitions in cohort number 1, so that if the court can grant us leave within 3 days, those amendments can be done. And thereafter, this can also probably affect in some petitions, cohort number 2. So it is important that we get that particular direction. Finally, my lords, this proceeding, because of the nature of the way they are proceeding, we request that probably we be provided with sequentially the transcribed proceedings, so that in case we require the proceeding at any time, those can be availed for purposes of good order. That is all.
With due respect to Counsel, we do not intend to make today this hearing a long hearing. We have been courteous enough, we have read our directions, and I think you should let us wait for proceedings in the afternoon.
I have something to say. Number one, the petitioners cannot approbate and reprobate at the same time. They are calling upon the respondents to file their responses. At the same time, they are seeking leave to amend the petitions. How would petitions that are to be amended be responded to when actually it should be the amendments that should come first and then responses follow? Number two, we brought to the attention of the petitioners that the interim order, one of the interim orders expires today, and the other one is the one we are complaining about, that it is actually aggrieving the respondents and should be set aside, the Kiroya order. Therefore, we shall be delving into that as soon as it is practicable. And number three, the reason why we are here and from the day before yesterday is due to the applications that were filed on the 18th of October to set aside the expected conservatory orders. Therefore, that urgency cannot be lost or cannot be clouded in whatever else they are saying. It is our position that we should actually proceed and be heard on why those conservatory orders should be set aside. Thank you.
My Lord, thank you for all that. You are very kind. You talk about the education. You know the prayer of the whole time of the very time is the you are not going to be shining out in new position. It's individual. Which cohort? I'm going to go better, but will enjoy it. In your own name. In our own name to be.
So you are in petition number 8? No. Interested party number 8.
Thank you, my Lord. I just want to restate the position that the urgency in this matter cannot be gainsaid or cannot be lost, my Lord. And the contention that the replies have not been made, that we have not made the replies, is not correct, because we have filed our responses. And my Lord, at the end of the day, the very essence that led to the empowerment of these churches will actually be lost, because then we will be going back and forth. And at the end of the day, my Lord, we will not have served the greater public interest or the greater public good that led to the empanelment, which you made a determination yesterday, my Lord. We would urge that we be able to proceed and argue this matter conclusively and rest it once and for all.
Thank you. We are no longer accepting any further submissions. I'm saying this, that it is not for court to direct parties when to respond to pleadings. It is not for court to direct parties when to respond to pleadings, but one thing which I can assure you that this bench will not allow anybody to take the process of court in circles. So if you have been served the document, whether petition or an application, if you don't respond, the court is allowed to infer that you have no response. If a petition has been filed and you have not responded to it, the court will make inference that you have no response to that petition. And by the very nature of these proceedings, we all acknowledge that they are public interest proceedings. Nobody will be allowed to take the court in circles. So I ask you, respond to the pleadings, file your petitions, respond to them. Don't come and ask for leave in a manner to suggest that you want to take this court in circles.
Katika kipindi tunakuletea wasanii.
What's up my guys? I go by the name Rejoinders.
Eti nikipita kwa macho na nipimia, na kama sina pesa ungewezi nipimia hapa Shenster the Poet manze.
Ngoma moto moto.
If you wanna show some love but don't fake it too. Hey, dakumenya mawazo mako. Nani enedera shire. Oh, utani wako.
Vichekesho mkisongaza, mahojiano moto moto, stori za wasanii pamoja na talanta za wasanii.
Fiki wa kasi gani kama wapatikani wakati wa shida.
Na pia kwenye kipindi utabambika, utajijenga, utaelimika, utakuza talanta yako.
My name is Rebecca Mutie, I'm a model and I'm Afri Kenya. I'm a student. Napenda kusikiza kipindi cha Bonga na Katoni kila Jumatatu kuanzia saa 9 mpaka saa 10.
Kumbuka ni kwenye Bonga na Katoni ndani ya TAS TV kuanzia saa 9 hadi saa 10 kila siku ya Jumatatu.
This is Bonga na Katoni in TAS TV. Karibuni.
Katika kipindi tunakuletea wasanii.
What's up my guys? I go by the name Rejoinders.
Eti nikipita kwa macho na nipimia, na kama sina pesa ungewezi nipimia hapa Shenster the Poet manze.
Ngoma moto moto.
If you wanna show some love but don't fake it too. Hey, dakumenya mawazo mako. Nani enedera shire. Oh, utani wako.
Vichekesho mkisongaza, mahojiano moto moto, stori za wasanii pamoja na talanta za wasanii.
Fiki wa kasi gani kama wapatikani wakati wa shida.
Na pia kwenye kipindi utabambika, utajijenga, utaelimika, utakuza talanta yako.
My name is Rebecca Mutie, I'm a model and I'm Afri Kenya. I'm a student. Napenda kusikiza kipindi cha Bonga na Katoni kila Jumatatu kuanzia saa 9 mpaka saa 10.
Kumbuka ni kwenye Bonga na Katoni ndani ya TAS TV kuanzia saa 9 hadi saa 10 kila siku ya Jumatatu.
This is Bonga na Katoni in TAS TV. Karibuni.
Nitatuliwa bila kusikizwa. Hata kama daktari wanasema kuwa submissions ililetwa, lakini law of evidence ina provide that mwenye kesi lazima akuje mahakamani na ajitetee, na mawakili hao wengine wamuulize maswali ambayo ni cross examination. Kwa hivyo hiyo ni right yenye Gachagua alidaiwa, na ndio maana unaona
katika kipindi tunakuletea wasanii.
What's up my guys, I go by the name Rejoinders.
Eti nikipita kwa macho na nipimia, na kama sina pesa unguwezi nipimia hapa Shenster the Poet manze.
Ngoma moto moto.
If you wanna show some love, I don't.
Finally, my judges, I think there is a law about service. That there are some parties who are present and have not been served, and we've been hearing this from the inception. I think tomorrow we settle the issue of service. We also settle the issue of filing of any affidavit or responses that ought to be done, so that after 2:30 we know how best we're going to proceed without people intervening with I have not had sufficient time to do this.
And I think before my presiding judge addresses, I just want to remind the parties that we are using technology to work. To me, the issue of service is not a big thing, because if you are hacked into a matter, automatically you get everything, unless you are not in the system. And if you are not in the system, get in touch with the deputy registrar. As simple as that. So that we avoid this issue of I was not served, I was served, I was not served. Let us make use of the technology at hand. Thank you.
Can I suggest that we are appearing in the ceremonial room at 11. I was going to plead, but any other issue being raised from the bar, be raised tomorrow at 11. No.
As the chair in charge of all the people at the party, after we have voted on this particular moment, we will thank all people that were present.
The application for recusal will be hard at 2:30. Whether you will respond to it or not, you will hear it. We will not actually late. What time tomorrow morning, sir? Because some of us did get things. At 9, yes. It's at 10 o'clock.
We're most obliged to notes, you can see
In a world of global commerce and competition, outstanding brands distinguish themselves through collaborative enterprise, creative
vichekesho mkisongaza mahojiano motomoto, stori za wasanii pamoja na talanta za wasanii.
Fiki wa kasi gani kama wapatikani wakati wa shida?
Na pia kwenye kipindi utabambika, utajijenga, utaelimika, utakuza talanta yako.
My name is Rebecca Mutie, I'm a model and I'm Afri Kenya. I'm a student. Napenda kusikiza kipindi cha Bonga na Katoni kila Jumatatu kuanzia saa 9 mpaka saa 10.
Kumbuka ni kwenye Bonga na Katoni ndani ya TAS TV kuanzia saa 9 hadi saa 10 kila siku ya Jumatatu.
This is Bonga na Katoni in TAS TV. Karibuni.
My name is Shadrach Moset, Solicitor General. Appearing together with Professor Rejoinders, Senior Counsel. As a highly transgressive one, courts have over time developed various methods or canons of interpretation. In the case of David Gill and others versus the Attorney General, a lot of High Court judges dealt with four constitutional interpreting principles, being that the Constitution must be interpreted holistically. That the Constitution does in favor of holistic approaches to its interpretation, and it must not be interpreted as one rule in statute. The Constitution has provided its own theory of interpretation to protect and preserve its values, authors and authors, and therefore in interpreting the Constitution, legal considerations are important to give its true meaning and values. Simply put, in the matter of the International Commission on Human Rights, simply put, and which are given and 6 answer the question as to what holistic interpretation of the Constitution means. The court stated as follows. What is meant by holistic interpretation of the Constitution? It must mean interpreting the Constitution in context. It is contextual analysis of the constitutional provision, reading it alongside and against other provisions, so as to maintain a rational explication of what the Constitution must be taken to mean in the light of history, on the issues in dispute, and in the prevailing circumstances. In the case of time rulers like which are doing institutional ruling, the court was in a final position that the Constitution must be read as an integrated code. The court observed as follows. The entire Constitution has to be read as an integrated code, and no one particular provision destroy the other, which sustain the other. This is the rule of harmony, the rule of completeness and exhaustiveness, and the rule of paramountcy of the written Constitution. On the tenets that the Constitution does not favor holistic approaches to its interpretation, and that it must not be interpreted as one rule or mere statute, which is not pronounce itself in the interim independent electoral commission. The court said as follows: the rules of constitutional interpretation do not favor formalistic or subjective approaches. The Constitution has incorporated in legal consideration social justice for the United States and society. The values and principles articulated in the preamble in Article 10 in Chapter 6 and in various provisions reflect historical, economic, social, cultural, and political realities and aspirations that are critical in building a robust, patriotic, and indigenous jurisprudence for Kenya. Article 159 of Article 1 states that judicial authority is derived from the people. That authority must be reflected in the decisions made by the courts. In expanding the principle that the Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, the entire Chief Justice is Lordship had the following to say in his own opinion in the Speaker of the Senate and another versus Attorney General. The Chief Justice then had this to say: in working with dissenting and concurring opinions in the matter of principle of gender representation in the National Assembly and Senate, I argue that both the Constitution 2010 and the Supreme Court Act 2011 both provide a inclusive interpretive framework upon which fundamental books, pillars, and solid foundations for the interpretation of our constitutions are the best. In their opinions, I provide the interpretive elements that should guide our jurisprudential journey as we identify the core provisions of our Constitution, understand its content, and determine its intended effect. To say now which I have included but I will not read. The Supreme Court also explained the incorporation of non-legal considerations and their importance in constitutional interpretation. In the case Communications Commission of Kenya and 5 others versus Raw Media Services, the question is, we visit once again the critical theory of constitutional interpretation and relate it to the United Human Rights Jurisprudence based on Chapter 12, the Bill of Rights of our Constitution. The fundamental right issue in this case is the freedom and independence of the media. We have taken this opportunity to assert how the social, economic, social, cultural, and political content is fundamentally critical in designing the various provisions in the Constitution that remains on the field of interpretation. The directive of the historical, economic, social, cultural, and political backgrounds to Articles 4, Sub-Article 2, Article 33, Article 34, and Article 34 of the Constitution has been given above in paragraphs 145 and 146. We agree with the concurrent opinion of the CJ and the President in the Judicial case, where there are differences of Blackwood dictionary, where we say that differences of Blackwood dictionary will not, therefore, always be enough, and differences to foreign cases will have to take into account these peculiar Kenyan needs and context. It is possible to set out the ingredients of the theory of the interpretation of the Constitution. The theory is derived from the Constitution through conceptions that may dissenting and concurring opinions have signaled as examples of interpretive comments. Permission the interpretation. But in the case of Center for Rights, Education and Awareness and another, the Court of Appeal was obliged to the subject of constitutional interpretation and all of the very principles discussed above. The Court found encountered the nexus between the principles of constitutional interpretation and the principle of statutory interpretation in the following manner. The principles of constitutional interpretation are not new. They also apply to the construction of statutes. There are other important principles which apply to the construction of statutes, which in a way also apply to the construction of a constitution, such as presumption against abstention. Meaning that a court should avoid a construction that produces an adverse result The presumption against unworkable or impracticable result, meaning that a court should find against a construction which produces unworkable or impracticable result. Presumption against unworkable or illegal result, meaning that court should find against a construction that creates an anomaly or otherwise produces an irrational or illogical result. And the presumption against artificial result, meaning that the court should find against a construction that produces artificial result, and lastly, the principle that the law should serve public interest, meaning that the court should strive to avoid adopting a construction which is in any way adverse to public interest, economic, social, and political or otherwise. The court, as an independent arbiter of the Constitution, has fidelity to the Constitution and has to be guided by the letter and spirit of the Constitution. On our part, we wish to emphasize that the Constitution directs that it shall be interpreted in line with the doctrine of linear constitutionalism. The doctrine holds that a constitution is a living document meant to evolve over time and reflect societal changes, contemporary realities, and shifting values. It further encourages that the rules are made and adapted to evolving circumstances, often encapsulated in the maxim that quote, the words always speaking. It underscores the constitutional provisions as which statute all further in time, but must be true as applying to current circumstances regardless of their original context. This interpretive approach ensures that the Constitution remains relevant and effective regarding the governance and legal framework of a modern, dynamic society. However, the blessing that the board is always speaking aligns with the pervasive approach to constitutional interpretation as endorsed by courts in various jurisdictions. However, this approach courts are required to interpret constitutional provisions in a way that gives effect to their underlying purpose and objectives, whether adhering to their legal or literal reading. Further, courts have emphasized the need to a flexible and forward-looking interpretation of the Constitution to meet the needs of member states. With the higher interpretive principles in mind, we will now deal with interpretations posed in the application and the consideration. I will deal with the second issue on where the DCJ can assign judges pursuant to Article 165, sub-Article 4 of the Constitution. There is no doubt that this was the most contested issue in the subject application. Article 165, sub-Article 3 and sub-Article 4 of the Constitution provide for empowerment of benches of and even number of judges as follows. Permit me not to what we want. In dealing with the above issue, courts are taken to basically opposite positions. One of them being that the assignment of judges is a constitutional duty which can only be undertaken by the Honorable Chief Justice. As such, the Honorable DCJ cannot assign judges under Article 165 of Article 4 of the Constitution. The other position is that although the duty to assign judges is provided for in the Constitution, its implementation is administrative, and that duty can be undertaken by the Honorable DCJ. The Kenya Medical Research Institute versus Aging, which will attend the bench of this court, held as follows. Report, paragraph 37. Therefore, by empowering this bench, the Chief Justice was carrying out his constitutional mandate as opposed to similar functions under the former Constitution, which were hinged on the constitutional provisions and were merely administrative. End of quote. In Kenya, the Precautionary and others, which was a five bench for this court, the court went ahead and described the role of the Chief Justice under Article 165 as constitutional as opposed to a merely administrative function. It's also it is our view that the constitutional mandate of the CJ can be judicial, administrative, or political, and the current constitution does not indeed states that the Chief Justice is the head of the judiciary which embodies all these functions. The five judges in that employment bench then find that the constitutional mandate except the CJ under 165 for the constitutional and administrative function. The court also elaborated down to the issue as to whether such an administrative function would be undertaken by the Honorable DCJ, and in the end, the court here itself as follows. The court, paragraph 78, it therefore finding that the constitutional function of the CJ to assign benches under Article 165 for the administrative function can be performed by the Deputy Chief Justice when the Chief Justice is for no reason unable to perform. The petitioners in these matters also cited the decision in Precautionary versus JSC and another, his constitutional petition number A408 of 2020, and addressing the opposition that the assignment of judges is a constitutional mandate and the sole preserve of the power of the Chief Justice. The decision was delivered by yours truly, who is part of this expanded branch. We have carefully considered the same decision. One of the issues there in which they decided to have a bearing on this matter was whether the Honorable CJ could rely on Section 5, Subsection 4 and Subsection 5 of the Judicial Service Act to authorize the Honorable DCJ to serve as the acting Chief Justice when the Chief Justice will proceed in leave pending retirement until when a succeeding Chief Justice was appointed. As the matter did not deal with the integrities of the aspect of assigning the judges, but rather the constitutionality of the actions of the CJ who was executing service, with respect to Peter that the issue is not a part included under consideration in this distinct application. The same decision is hence distinguishable. In terms of the matter at hand, it is imperative to look at the terms which come to play in this matter, including the administrative actions as well as judicial actions. We have I do not think there's room for material artists in the room, and they proceed to so from the above discourse, we do not find any difficulty in affirming the position that a constitutional mandate for the Honorable Chief Justice can be judicial, administrative, or political. We further find that the constitutional mandate concerns the Honorable Chief Justice under Article 165, Sub-Article 4 of the Constitution is a constitutionally administrative function. Shall now consider whether the function of the Honorable Chief Justice under 165, Sub-Article 4 of the Constitution can be performed by the Honorable DCJ. Article 161 of the Constitution establishes the office of the Chief Justice as the head of the judiciary, and that for the Deputy Chief Justice as the Deputy head of the judiciary. Article 163 of the Constitution creates the Supreme Court and designates the Honorable Chief Justice as the President of the Court. The Deputy Chief Justice is the Deputy is to be by the Chief Justice and is also the Vice President of the Court. Article 171 of the Constitution establishes the Judicial Service Commission of the JSC as one of the Chapter 15 commissions. The Honorable Chief Justice in JSC is the chairperson, and in this scenario, and unlike the constitutional architecture in Article 161 and 163, the Honorable DCJ is not the Vice Chairperson of JSC. Running alongside the functions of the Chief Justice and the Honorable DCJ as provided for in Section 5 of the Judicial Service Act. The provision is as follows. This is in respect to administration of the Judicial and not to if you will not. I proceed to say that the decision in Lena Conchena also got the definition and the various types of deputies and ultimately rendered itself in the following manner. I think it comes from court. Right. Paragraph 77 says, it has been done as before that where the Constitution intends the Deputy Chief Justice to act on behalf of the Chief Justice, it has expressly stated so. Specific examples cited were Articles 141.1, 144.4, 148.4. These solutions fall under Chapter 9 of the Constitution that deals with the Executive. This chapter does not have a general provision as regards the Article 161 to be in Chapter 10 of the Constitution on the judiciary. Hence, the provision of the deputization of the Chief Justice in Chapter number 9. A realistic and published interpretation of Article 161 to be of the Constitution and Section 5 of the Service Act leads to leave absolute inclusion that the Deputy Chief Justice substitutes the Chief Justice where necessary in the court. In the end, the judges found that held by the constitutional function of the Honorable Chief Justice to assign the benches under Article 165 for the Constitution, being an administrative function that will perform the DCJ when the DCJ is for good reason unable to perform this function. On our part, we have carefully addressed our minds to the issue. We find that there was a deliberate scheme by the drafters of the Constitution for the Honorable DCJ to deputize the Honorable CD as Deputy Head of the Judiciary and as the Vice President of the Supreme Court, but not in the JSC. Such was an emphasis on the various manifestations of the constitutional duties bestowed upon the Honorable Chief Justice and the Honorable DCJ. As such, the prevailing legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial functions and in the administration of the judiciary and a number of governments, but cannot do so in respect of the affairs of the JSC. Our attention has also been drawn to the provisions of Article 259, Sub-Article 3, of the Constitution, which states as follows. This refers to constrain the Constitution, and Sub-Article 3 provides as follows. Every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, any difference in this Constitution to a state or other public office or officer or a person employed in such an office includes a reference to the person acting in or otherwise performing the functions of the office at any particular time. Emphasis, or otherwise performing the functions of the office at any particular time. The above provision gives 3 terms in which constitutional functions can be exercised. That is, by the substantive office holder, or by a person in an acting capacity, or by a person otherwise performing the functions of the office at any particular time. In our understanding, and against the background of the document stated, the draft of the Constitution were deliberates about ensuring that the administration of duties and the application of the constitutional provisions are continuous and seamless, recognizing the necessity for officers and their functions to perform even in transitional or extraordinary circumstances. Such an interpretation avoids technicalities and vacuums that will discharge the functioning of such officers by institutions, thereby promoting administrative efficiency and upholding the principles or constitutional governance. The provision reflects the broader principles of the rule of law and good governance, which require that states and public officers continue to function effectively even during the transition from when the substantive office holder is unavailable. It in turn promotes legal certainty and administrative efficiency by ensuring that all constitutional responsibilities are carried out without disruption. For this reason, the functions of Article 165 of Article 4 in our view, and as far as the same view, the Office of the Chief Justice also includes the Deputy Chief Justice acting in the capacity or the Office of the Chief Justice or discharging his functions, they are interim, acting or auxiliary role. At this point in time, we also wish to point out that the Honorable Chief Justice empaneled his bench on the 14th day of October 2024 to deal with 6 constitutional petitions that entirely challenge the first petitioner's impeachment process in the National Assembly. The 7 petitions are still current. On the 18th of October 2024, the Honorable DCJ empaneled the same bench to deal with constitutional petitions challenging the impeachment of the first petitioner in the Senate. To us, it is beyond peradventure that the Honorable DCJ can assign judges under Article 165 about the Constitution whenever he or she is discharging any of the constitutional functions on behalf of the Chief Justice. In this case, we will not find any fault in the Honorable DCJ assigning judges to sit in this bench, more so when the Honorable Chief Justice has not raised a red flag.
I'm going to deal with a question of other related issues that came up during the submissions of the application. Besides the issue of the benches and empanelment by the Deputy CJ, several additional issues have been raised. The bench found it necessary to address these issues so as to ensure both the completeness of the record and finality in the issues raised. During the submissions, an issue was raised concerning the directions issued by the 3-judge bench and the transmission of the files in Nairobi Petition E565 of 2024, Kerugoya Petitions E013 and E014 consolidated, as well as E015 of 2024. A review of the CTS, that is a case tracking system, confirms that the petition in E565 of 2024 was filed on the 18th of October 2024 at 8 o'clock p.m. Later that same day, approximately 5 hours on, at 1:51 p.m., Justice Chacha Muta dealt with an application found as a certificate of urgency which had been submitted alongside the petition. By 5:33 p.m., roughly 3 hours after the other application, a notice of motion application dated the 1st of October 2024, was dated the 1st of October 2024, was filed, this time by the respondents seeking the following orders. 1, that the application be certified as urgent and service of the application dispensed with in the first instance. 2, that pending the hearing and determination of further application, inter partes, this Honorable Court be pleased to set aside, vary or review the orders issued on the 18th day of October 2024, that is the interim conservatory orders. 3, that in the alternative, this court be pleased to set aside, vary or discharge the ex parte orders issued on the 18th day of October 2024, and 4, that this Honorable Court to issue any other orders it deems fit in the interest of justice. Following its empanelment on the 18th of October 2024, and having received directions from the Office of the Deputy CJ, the bench deliberated on the appropriate directions to be issued. On the 19th of October 2024 at 12:20 p.m., the bench issued the following directions. That in light of the urgency of the matter and the weighty issues raised therein, we direct that the application be served and responded to formally for hearing inter partes on Tuesday the 22nd of October 2024 at 11 a.m. in open court number 18. Petition E013, on the other hand, was filed on the 25th of September 2024 at 8:33 p.m. While petition E014 was filed on the 2nd of October 2024 at 7:07 p.m. Both way past official working hours of the court. The CTS will further show that an application in E014 was filed on the 30th of September 2024 and directions were issued on the very same day, although the matter was not certified as urgent. Subsequent directions and a ruling issued on the 11th of October 2024 resulted in the consolidation of petitions E013 and E014, followed by an order for empanelment. As the record on CTS will further show, the directions issued by the court in E014 of 2024, which were issued on the 2nd of October 2024, were again issued at 6:22 p.m., which is outside of what one would call the routine working hours of the court. This was due to the urgency demonstrated in the application, which sought directions regarding the then ongoing public participation process. The bench takes great exception to the petitioner applicant's conduct that when favorable to them, issues of orders, or rather orders issued outside of what one would refer to as the normal or working hours of the court raise no concern. However, when the court acts in an instance where it has been moved by any other party and likewise proceeds to deal with an application at hand, the applicants show their indignation. Moving to petition E015, the CTS again will show that the same was filed on the 18th of October 2024, and once again following the directions issued by the court, this bench was empaneled on the 18th of October 2024 to hear all the three petitions, that is E565 of 2024, E013, E014, and E015, all of 2024. From this sequence of events, it is notable that the interaction between Counsel and the courts on an almost real-time basis is not novel, and is in fact a practice that counsels are well familiar with. The CTS enables both counsel and the court to operate in real time, transcending traditional time limitations. This fact also buttresses the argument that with the advent of the CTS system, it is not unusual for courts to issue directions within the filing of an application or outside of what once again would be referred to outside the routine work hours of the court when circumstances do so require. Moreover, in raising the issue of improper sitting, the applicants omitted a crucial factor, which was that the court had been moved by the respondents in petition E015 of 2020. Petitions have repeatedly referred to this convening as a sitting of the court, a term that we feel as a bench requires clarification and demystification. Yes, clarification and demystification. It is a matter of judicial notice that since the onset of the COVID-19 allowed it, quote, the practice direction number 19A of the High Court practice directions of the 11th of January 2022, which states as follows, that applications filed under certificate of urgency shall be considered by the judge, we emphasize here, at the earliest opportunity. While the practice direction is considered the next working day, the full adoption of the e-filing system across the judiciary has likely rendered these well known to the justice users across the country, and which we have demonstrated in this room. Furthermore, practice direction 19B confers discretion upon. Furthermore, practice direction 19B confers discretion upon the court to issue orders or directions without the attendance of advocates or parties. This implies that the court can indeed issue directions or an application without the need for a formal sitting. The relevant provision, once again, reads as follows: that the court may, in its discretion, issue orders, stroke directions without the attendance of the advocates or parties. In this court, rather in this case, the issue has been raised that this court allegedly served and considered an application by the respondent on a Saturday outside of the official court hours. The ordinary definition of a sitting, as provided in the Black's Law Dictionary, is a formal occasion when the court convenes to conduct its business. In this instance, no such formal sitting occurred. In this instance, I repeat, no such formal sitting occurred. Rather, the bench merely conferred and issued directions electronically as expressly permitted under Practice Directions 19B. This is markedly different from a court session in which the bench is convened to hear and determine a matter. Furthermore, no evidence or proceedings have been presented before this bench to support the claim that a formal sitting did take place. Accordingly, it is only fair and reasonable for the parties to dispel any notion that this bench convened to hear arguments from any party ex parte before issuing directions. No such formal sitting took place, the court again emphasizes, and directions were issued electronically in line with established practice and procedural rules. We do, however, recommend that the current practice directions and relevant statutes, such as the High Court Organization and Administration Act, be amended so as to provide a much needed clarity on this subject. Moreover, for the avoidance of doubt, and out of all the prayers sought by the respondent, only prayer number 1, which sought to have the matter certified as urgent, was granted. No other reliefs were considered or granted at the time. It is evident that the court was fully cognizant of both the urgency of the matter and the potential repercussions that granting any further ex parte orders could have had on the prevailing status quo. With this understanding, and in an effort to balance the scales of justice, the bench issued the directions that are now being challenged. We hold the view that there was nothing unconventional in the manner in which this bench dealt with the 2 applications filed under certificate of urgency. As regards the arguments that directions had already been issued by the respective courts or are mentioned before the bench on the 24th of October 2024, the arguments by the applicants appear to insinuate that the bench ought to have retained the date. For clarity purposes, this date had not been given by this bench, rather this date had been given prior to the empanelment of this bench. However, upon empanelment of the bench, the applications and the certificates of urgency, the ones that I have just referred to, were filed, which applications were dealt with, and which were rightly so. Being seized of the matter, it is our view that the bench retains the discretion to issue appropriate directions depending on the developments and in light of its mandate as it did, having been moved by a party and the certificate of urgency. With respect to the claim that was raised on discriminatory transmission of files to the bench, it must be emphasized that this bench has no role and no control whatsoever in the administrative processes that occur prior to its empanelment. Concerns have been raised about delays in the transmission of certain files, but it is crucial for us to clarify that the term transmission in this case may not necessarily refer to the physical transfer of documents. In the context of judicial processes, particularly with the advent of digital systems, transmission may very well refer to the electronic movement or assignment of case files within the judiciary's digital infrastructure. We say this on the strength of the fact that with the CTS, all file documents are available in real time across the judiciary, eliminating the need for physical movement. Let me refer once again to practice direction number 41A(2), which provides that advocates and litigants shall have access to court information electronically. While this court cannot and will not speculate on the causes of any delays in file transmission, the bench nonetheless finds no basis for concluding that such delays amount to any form of procedural omission on the part of the bench, as no such evidence has been presented. Applicants have equally in their submissions attempted to cast aspersions on the proceedings of this court, some of which I have already referenced, that is that the court was convened on Saturday, stating that there is no urgency in this matter, and so there was no need to convene the sittings of the 22nd day of October 2024, that this matter is being given priority over other petitions which have been filed, an insinuation that the bench is part of a conspiracy to infringe the petitioner's Article 50 right to fair hearing, and what I have again alluded to, that the transmission of the files from the Kiroboya High Court took place with what has been referred to as supersonic speed. One of the counsels went further by intimating that an exercise akin to the radical surgery may well be forthcoming, a statement which the bench, with tremendous respect, perceives as a veiled attempt at intimidation. The bench feels that such remarks are regrettable and wholly inappropriate. This bench remains firm in its duty and will not be swayed or influenced by any form of intimidation, regardless of its source. The bench takes the view that the applicants appear to selectively focus on aspects that favor the applicants more conveniently disregarding that the clients that the applicants are presently benefiting from final conservative orders, which this bench did not deem it fit to lift. Despite having obtained final conservatory orders, as the court has already observed, it is now apparent that the applicants no longer perceive the urgency in this matter. Instead, Instead, they seek to cast aspersions on this court for addressing the matter with the necessary expedition. Such conduct is contradictory and undermines the very urgency that the applicants had initially invoked. The bench notes that the issues raised in this petitions have on various occasions and before different judges consistently been certified as urgent and as involving substantive constitutional questions. This underscores the gravity and significance of the matters at hand. One of the counsels again insinuated that this bench is part of a conspiracy to violate the petitioner's right to a fair hearing under Article 15 of the Constitution. The bench finds that these submissions are without any foundation and wholly without merit. This court has not issued any rulings or directions that would suggest such an intention. It is apparent that this argument was made for the sake of the gallery, and we find it unnecessary to therefore address it further, save to reaffirm that this court remains fully committed to upholding the Constitution and the rule of law. In conclusion, we do find and hold that the accusations made by the applicants against this bench are entirely without merit. Obviously, the last part of the limb is whether the matter raises issues of public interest which require expeditious disposition of the petitions. The applicants have urged that the applications before the court are not urgent and have loudly wondered why it was necessary to give directions for hearing of the applications on the 22nd day of October 2024. In response, the bench quotes Article 131, which establishes the office of the President and the office of the Deputy President, and also we have cited Article 147 with regards to the functions of the Deputy President, just to lay context. And the context is this, according to the bench, that the first petitioner has been impeached under Article 145 of the Constitution, marking the first instance of such an event in Kenya's history. The impeachment of the said petitioner has undoubtedly garnered significant public interest, and these court proceedings represent a direct challenge to that impeachment. It goes without saying that these legal proceedings are of paramount concern to the citizens of this country. To suggest, as the applicants have, that this matter lacks urgency and does not warrant prompt adjudication is disingenuous and dismissive of its far-reaching implications. We have taken the liberty to define the term public interest in the Black's Law Dictionary, and you will also find the Supreme Court of Kenya's definition of public interest in the case of Stephen versus Rebuttal, which permit me not to get into. Safe to say that from the foregoing, a matter is of public interest if the holding on law affects a considerable number of people in society, if the holding in law involves government and or government agencies, if a determination of law affects the proper functioning of public institutions of government or of the court's scope for dispensing redress, and if the holding of law affects the mode of discharge of duty by public officers. These proceedings, in our view, as the bench, raise enormous public interest, and it is in the interest of the public that these proceedings are heard and finalized most expeditiously. Therefore, the aspersions cast by the applicants concerning the directions for the hearing of the applications before the court on the 22nd day of October 2024 now view lack basis and we are dismissed.
How so surely has to be. Nevertheless, as a directions regarding the procedure and process for handling virtual and online elections and proceedings. We believe that this, as this application has implemented the resources for such guidelines and will the issue non-apparent. In such, we hereby direct the Honorable Registrar of this Division to transmit a copy of this document to the Honorable Chief Justice. The body of the base wishes to advise the Honorable emphasize its unwavering commitment to objective neutrality in this matter. We assure all parties that the right of fair hearing remains fully safeguarded. The bench acting with diligence to its oath of office and to its strict adherence to the dictates of the Constitution remains resolutely committed to the fair and just determination of the issues before it. Finally, the petition taken the 2nd of October 2024 feasibility of this one way or the other. We need to advise the decision maker of the appealing the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. That is the truth. I believe since we received some communications from the deputy registrar, and there are certain other pending matters in the files that are under consideration. We shall arrange the directions of the court before the petitioner's point of view. We can say one or two things. I do not know whether at least Mrs. Milano Senior and the manager will be tried. My lords, we are pushed this honorable court of his own volition has granted leave to appeal. Speaking for myself, obviously the position is that of the client. So I will be opposing the client, but it is for the client to make the final decision. But in fairness to me, as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the guy, that is not something that should be left in the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record listened by the court of appeal. It was a very unfair position. May it please the court, on behalf of the respondents, we thank you for the timely nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. The respondents support a fair resolution of this dispute in accordance with the law, and therefore we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Kimberly White, who has alluded to other petitions
pending before court. It is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady. So that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. So thank you.
My Lord and Lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has delivered this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other preliminary issues that the petitioners unfortunately took a lot of court time yesterday to be in. My Lord, my Lady, the National Assembly has filed an application dated the 18th of October 2024. And I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should do. And just to put it on record, my Lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, where it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the items in this matter remaining and having been noted by the court, we proceed with the hearing of that application which has been fully responded to immediately after this. I'm most of that.
Petitioners. We are willing to argue the application in the next 30 minutes. Yes, the application was on 18th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into the principles. We will not take much time. The respondents can have as much time as they want, so that this matter can be concluded. Once Mr. Kiba has talked about the government, what we can see the council. From that time, it was apparent that we were not just addressing the court. We were addressing other ones. Do we need to be a very achieved by the government? We were going to that event to that I think the whole time we were clear. There will not be a racist decision. The don't do that is very important to I will ignore the remark that the petitioners are addressing the public dialogue today.
With your permission, yesterday we were barred from being part of this proceedings. We have seen communication that we are now legally here. We have stopped mourning. Could we be allowed officially that these files be called so that we are together? We still feel that we are excluded when we have been formed. That's why this petition. There is petition 5E570, E550, E549, E572 that are supposed to be before. That's the complaint to the CJA1, and the CJA has directed we appear here and be part of this mosaic. Kindly let us be part of it. I rise as the advocate appearance in E549 and associate myself with the submissions made by my Lord Senior Counsel on written and the ones made by my now friend Senior Clinic. Lordship, to the best of our knowledge, in the matter E015, when we brought yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday we came to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated, and we have initially noted that my friend is referring to, that he also seized of 4 other matters: E570, E580, E551, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in this to that particular files. I hope the court is in possession of this notice, so that the notice the court may refer to the same. Subsequently, Your Lordship, we will be seeking your guidance on how we deal with the application filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which by Your Lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
Madam Chair, may I please you, I hate to interrupt, but this is most unprocedural. We are all counsel of some reasonable experience. We all appreciate some of them. We are a very senior advocate, very senior counsel. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting those proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitions have been engaging in this dilemma tactics since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your Lordship may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be new, but they are not before the court.
Counsel on this side we have, yes. Counsel on that side appears to be taking the order. Just to Mr. Mutter, just the levels are asked of equity on that. We don't time counsel or the side I think for purposes of yesterday, we started hearing on the issue of validity of the bench, which has now been discussed by the ruling which read. The question that we wanted was the applications for the validity, plus the issue to do with recusal is hard. The understanding of the court and ourselves, because they cannot work together. So that the second preliminary issues, after the issue of the validity of the bench has been disposed of, and the 3 applications for recusal.
Those are preliminary issues, and they relate to the same consolidated matters that this court has given a ruling on. That is issue number one. Issue number two, a lot that is important to be noted. Yes, the consolidated file that is before you has that application for recusal. That's what my language is emphasizing. So the second business of the court is supposed to be that one. But more important, so that we do not want to hear these accusations about somebody is trying to develop this matter. We are the victim, and I retract. For purposes of the petitions before you, we like this petition happened yesterday. And we kept on saying yesterday, the petitions to be had. Now, these rules, because it's the enforcement of the Constitution, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond to the petition to get the matters rolling. There have been no compliance with the Mutunga rules for purposes of the respondent. So that if anybody wants to be accused of LADA, it would be somebody who has not complied with the Mutunga rules. That is issue number one. Issue number two is this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Mrs. Kiwabo, they are not even served with the application of the lesson that the recordings are itching to have them disposed. So because of that news that was created by them yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situation where some of the advocates in the matters that were not there yesterday, have not been served with this notice, and I know them. So that unless now we take a fresh day without somebody waiting to say that this court must discharge orders and we have as well in the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, I want to reach the conservative order and the other side is delaying, it is unfair. We want the petition hard and it starts with compliance. We the rules, which there is no compliance whatsoever by the respondents. So Lord, I beg you that let us not appear now to say that somebody is going to the gallery. Nobody is going to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the judges are going to guide these proceedings. Lord, I beg you to have the information about just want to highlight the elections, which I see. Because petitions are still being filed throughout Kenya. When we try this, we will assume someone complained of offenses which became legislators. Therefore, those things are the only possible true and induced proceedings. There are also other claims who are coming day in, day out. So the matters which you've set out for management and the matters in which we have been empowered as from yesterday. So if you wait for both good directions, then it's not tricky. You cannot just start looking from the air without facts. Let us measure these facts first, and from there you see the directions mapping, and then we can make the prayers.
Let's deal with these files first. Petitions, which are being consolidated. The first context when the petitions which are filing to use the processes that requirement yes. And after these days consolidated 6 petitions and the new petition being filed to the consent for 2024. Is that correct? That petition, filed for June of 2024, is the lead file in the petitions which were filed before the finalization of the matters in the States. Then, out of the proceedings in the States, other petitions were filed. And we consolidated all those petitions yesterday. So we have 2 random petitions before the Senate proceedings and after the Senate proceedings. You will remember that petition number 522 was listed for admission on 29th of this month. But because of you need to know, because at least starting the presentation of these petitions, we decided just to call it because we knew that all of you will be here, so that if there's anything you want to say in those petitions, you can say it. So that's the reason why we have petition 522 here for admission. It's not a regulation, but we say 3 parties are not here, and some of the parties are not listed yesterday, so we vote it. But the other petitions we mentioned are specific petitions where we have been named. And we want to find out whether we can consider the petitions or whether they can be done separately. So these are petitions number. This is petition number 570 AD by Uru and Victor Gachagua. Yes, this petition. Yes. Petition. This one was filed by the law firm of, I believe, in Chile. And now it's called Judicial and Company Advocates. I am aware of this petition for the simple reason that he basically that when it comes to the hearing, I appear alongside him. The parties are new, starting in the first restaurant and biggest control trooper, without the second restaurant, and there are others. Now, for purposes of this petition, it was filed after Friday. And by the admissibility, we found it to the order of the Chief Justice, and we expected it to be coming tomorrow on Thursday. But this committee was not served with this particular notice that is before you. Actually, we sent out the notice in the morning today because we received them in the morning. That's why I said that this matter will come in. Yes. petition is not to be approached legally because we find so that means what I would ask the court, and for the official reason that I am aware that in that matter the notice of motion is seeking a 5-judge bench, particularly for the reason that this is an application by the citizens of Central Kenya who says like in the year 2013 that their rights, not just regarding Gachagua, have been affected adversely by the impeachment of the Deputy President Gachagua, and therefore I would ask that this matter do come tomorrow so that the issue that issues of empanelment and in the presence of Mr. Muchembei and Joe, so now that it is obvious that even the direct, like the advocates who filed the case are not here, it would only be fair that there is another nation where they can also be there. After we can have the file, we are just looking at it from our end. But that is the position as far as 517 is concerned. With a specific application, we are 5-judge bench in that matter. Justice so the request for the final bench, I think so, the bench will stay unless he wants to appeal. Yes. The chances of appeal are very high to this. So I believe that there must be some mechanical applications to the issues but specifically that issue will be addressed and the Chief Justice will have the relevant communications tomorrow morning, while given the nature of the issue that must be dealt with, there must be a 5-judge matter. All benches can be expanded. I believe that is the position that we are coming from. So we don't say specifically that we don't want anyone, all benches are capable of being expansion, particularly bearing in mind. And this is something that a number of the time that already we are presenting, they have been repeated insinuations by our people out there, including senior counsel and the Nancy Abdullahi, that the senior bench is supposed to do that, they're supposed to do this or the other. We can't help that. This is not coming from the president. But you shall have the notice of hearing. Yes. The notice of hearing for the rental. I don't know the time in the Namibia. Because by the time I get to my office, I will not be to some of this. But we have the time is spent here means that even if you come at time, you find us here. And I don't want to come to work. The first chance of the interest is that you come at but I am asking this particular file that you record my presence together with the other as I mentioned earlier is appearing for the Deputy President with the second response. This one? Yes, the green file. Yes, this one is this matter of first, yes. If you look at the party, second motion. So we are doing the motion. I accept. I will be here tomorrow. Inshallah. Listen. Yes, my name is Marvin. I wish to go on record for the first interested party. Lordship, my name is on record for the second and the fourth interested party. And permit me to only indicate the implication of the order of the empowerment that were issued by the judge who directed the Chief Justice does empower you. The base of my thinking and knowledge is that the prayer was granted as it is for the empowerment of 5 bench. 5 judge bench. The judges have said that this trial has been independent to compress the Honorable Justice Comparative, the Honorable Justice Impeached, the Honorable Dr. John Fredman, that's correct, but I will address it more than that. So the reason is for which countries you are here for the second and the fourth interested party. Thank you.
And that is petition number 565 of 2024. So we have requested, my Lord, that you give directions in respect of the applications in that manner, because this process of taking forward might take some time. And there are 3 cohorts of files that are before you. And if I may just be given a moment to explain myself. As the court has correctly identified, there is a cohort of files that are consolidated in petition 522. There is a cohort of files that is consolidated around petition 565, which have the 2 applications that the court has identified as added. And then there are these others that have been referred to the court by virtue of the email that we have all seen today. It is my request that the court keeps them in those cohorts so that these are important, but the applications are added. And the court has identified that added. Because this will go on for 2 or 3 hours without any directions having been given in 565.
What could they be held together? We are being made orphans. The state is in the bedroom, let us also be in the bedroom so that we can respond.
Well, perhaps, as you consider that, the good to be the labor, that if you are considering whether they are ready for consolidation, the consolidation should not then slow down the hearing of the application that you have already identified as added. If they have to come on board, they come on board and proceed from where we are.
Let us be on board fast. And now as we will escape from a president,
my lady and my lords, I just have a passionate plea for many things. The first place is we will consider utilizing the ceremonial court to the ground floor
because of the pressures it's sufficient for all the pass. That's number one. Number two, my request is this. The court has all the petitions. Why can't the assistants to the court enumerate the parties there in the quorum in the manner we used to do in the Court of Appeal before? So that when we appear here, whatever time we indicate, we just fill our respective names, and the court will be able to deal with the matter without the need of this back and forth. Number three, my lords and my ladies, I think the court needs to just be a little bit proactive. When you retreat, you know my two positions. One, then you will be becoming the interlocutory applications, in which case you confirm issues for the parties submitted. Or two, if you're minded to hear the petitions themselves, then still frame the issues and form it to us so that we are able to make progress. That way we make good use of the initial time that is not limited in this particular. I receive you
As a former chairman of the Council of Science, let me second the first issue and think that if only for the purposes of everybody getting sufficient oxygen, because we are too crowded, and the people want to do so, we live here, and the members of the public, if it is possible, let us do this in a more Thank you.
I wish to say that perhaps when giving directions, then I think that parties and files are going to be consolidated. Then it will be proper each person is served in the application so that we are able to respond, even if we are given a day to respond, so that when we begin to submit, we are able to submit according to the law, not as part of and whatever issues are being raised. Thank you.
My Lord, like when we beseech the court, if we are to make progress, I beseech the court to invoke its powers under Section 55, Article 159, go on and on. There is no shortage of legal provisions enabling this court to rein in on the lawyers. Because if you don't do that, my Lord, on a matter like this, where you have 20 lawyers, 50 lawyers, and everything, we will be coming to you. We will be doing legal gymnastics, legal ping-pong, what I call legal service to another occasion. And people will be lamenting as we are now lamenting to you. So the applications, both from this side and this side, certified agent, because we are spending a lot of time, each of us from whatever side, starting to raise this or one housekeeping issue. I beseech you, in a matter like this, the court must be very firm. It must run the council. The court itself must have very clear direction, which is the application that will be had in what sequence, what are the time allocations, how the parties share those things.
How they relate to the matters from the court. So we have a reason
under the cover of 550.
550.
No, sorry, my lord, that was not clear.
Yes. 550. Petition 550. Who's in 550?
Mine is 572.
I'm asking you 550.
We appear for the first respondent.
I guess you can show us who is the allocation.
The petitioner, my lord, is the former deputy president, my lord. Represented by my lord.
Lord, I appear for the deputy president, not former. He remains in office on the basis of the conservative orders, and each bench has confirmed weighty issues, which is why we are here. Let's go to the rush.
For the first petition,
For the first petition. I thank you.
My lord, it is again Yamodi and Gumbo for the second respondent. And our learned colleague, Mr. Ruga.
That matter, my name is Mukele. I appear together with Ms. Angie and my senior professor, Gender, for the third and fourth respondent.
Yes. Who else is in this matter? So, for the petition is, what are the issues in this matter? And they relevant to the consolidated petitions. There are so many files. This is the same team of lawyers, including myself, and again, when we get the ruling, it's appearing for the deputy president. What I'm asking is it going to be consolidated or is it signed? One of the ones that we have consolidated. No, sorry if I appear as yes, please. For you to be able to progress, I beseech you to adjourn this matter tomorrow. Go and make directions. You're either hearing the petitions or the applications. Come here so that we have a perspective before we progress. Otherwise, we will not make. We are aware of that fact, Mr. Hardy, that it is the council school will be saying that they are going to be hard. Even when petition, even the legislative issue has not been granted. Therefore, let us agree on the way forward. If you get a proposal, the council can come from you side, how you want to deal with all these petitions. Is it possible that you want to ignore all applications and pursue the petitions? You can make a submission which this will can consider. If I may, just to buy the way and go upon the senior council. The other application to find the applicants or the petitioners are very interested in the period of objection report is moving this afternoon. We have an application that was filed dated the 10th of October 2024 for discharge of the concerned orders. Before the issue of this ordinance can be either way, we need the directions with the hearing and then the consolidated petition. Some of the petition deal with issues or coordination of law before the laws of the impeachment. The definition of the law is that the party in the petition is the form of the petition. That's the petition without the law for the second. Allow us to laws without our petition for the second side of the consent. However, because the right of the right is not a right. The law is a 4 minutes.
we are on the third body. And if we are good in interrupting, perhaps we throw them. 550, I've recorded the file. And that's what I asked. Is this file related to the files before the court? For the purposes of consolidation, or it can stand alone.
Can we deal with that or not more? We only deal with that. Consolidation has implications. We need to consult my team, consult the client. Let's take the forum, let's deal with the consolidation.
So we mention it tomorrow.
Yes, yes. Dr. Clarence Eboso. Dr. Clarence Eboso.
My lords and my ladies, my name is Counsel. I am acting in person, and I am the second petitioner. The first petitioner, Dr. Clarence Eboso, is online, my lord. And my lady,
May it please the court. My name is Dr. Clarence Eboso. I'm the first petitioner in E541. The petitioner is between Dr. Clarence Eboso, Ms. Wanjiru Mwangi, versus the Speaker of the National Assembly, the Attorney General, and with the Law Society of Kenya as an interested party. The petition relates to the process of impeachment, particularly in the National Assembly, and seeks orders to quash the proceedings. The petition has an application which was certified urgent and which sought an injunction against the entire proceedings of impeachment. The court which certified it urgent directed that the application would be heard by the bench that will be constituted. Several of the prayers that were made in the application have since been overtaken by events. However, the substance of the application sought to conserve the issues as they were, and therefore the conservatory orders that were issued by the court in last week on Friday protected some of the prayers that we had made in the application. Yesterday I pointed out to the court that proceeding with the discussions on the conservatory orders would have prejudiced us because then we would have lost out without participating. our prayer would be
exactly the application. We are taking so long. Just tell us with clients whether this petition you want it to stand alone or whether you want it to be consolidated with the petitions going forward.
That's where I was going to go.
Just go there, please.
I would be seeking that the petition be consolidated with the petitions relating to both the impeachment process and the filling of the vacancy that arises from impeachment. The reason being, upon filling of any vacancy.
Okay, we have had you agree with this petition being consolidated with the petitions which are in file number 565 of 2024.
My Lord, may I just conclude? My Lord, may I just conclude that I will be willing to compromise our application, provided that we can be allowed to participate in the applications for conservatory orders that are before the court in the interest and in time.
Okay, Commission, my Lord, I appear for the first respondent.
Yes.
And my Lord, I noted that we didn't come with our file.
Is this petition post-Senate proceedings?
No, my Lord. It has not mentioned it was filed, my Lord, before. And it has not touched on issues, my Lord, that happened at the Senate. But in other, my Lord, will be opposed.
So we will mention this matter
tomorrow, my Lord.
We mentioned this matter on 29th, where the petition number 522 will be mentioned.
Most of that.
Tomorrow or the 29th?
My Lord,
yes.
I'm not sure if the court got the last statement I made. It would be very prejudicial to us if the discussions relating to the conservatory orders continue without our participation, because we are essentially raising the same issue in our application.
My Lord, I agree. We filed our application on the 8th of October 2024 before the National Assembly and even made it impeachment to Rigathi Gachagua. We are active persons, we are laymen, my Lord. We are also protected by the same laws, Article 27, Article 47, 48, and 49, and 50, my Lord, for the right to fair hearing. So we do ask the court does mention our matter tomorrow so that we can articulate the points that we need to.
My Lord, I appreciate the fact that the petitioners are appearing in person. My Lord, once the court has made an order, my Lord, the only remedy available to the parties is either to appeal, my Lord.
We are not ready
to be available.
Yes. And my Lord, the presiding judge, my Lord, my reading, what is in matter. My name is Wamboi, Shadrach Wamboi. I have the honor and privilege of introducing counsel for the petitioner.
I appear alongside my learned senior, Mr. Dunstan Amoy. I'm present. Mr. Samson Yabere, my senior. I'm present. My learned colleague, Mr. Nicholas Karanja. I'm present. And my learned colleague, Ms. Melissa Omeda. We all appear for the petition applicant. Thank you.
In that matter, I am Shadrach Moses, the Solicitor General, appearing for the Attorney General, together with Professor Gitu Mudel, Senior Counsel, Emmanuel Peter, Deputy Chief State Counsel, TAS TV, Deputy Chief State Counsel.
My Lord, if may please in the matter, my Lord, I appear alongside Ole Kuyoni for the first respondent.
Please, you, my Lord. For the second respondent, my name is Bumbo. I appear together with my learned senior colleague, Mr. Paul Nyamori, and Mr. Honorable Tonga Brugara. You may please, my lords and my ladies. That matter, my name is Edwin Bukele. My Lord, I appear together with the senior professor of gender, my Lord, Senator Hilary Sigay, and Ms. Matthew Tanji, for the third respondent, my Lord, in respect of this matter. For the third respondent, Speaker of the Senate.
The Deputy President is the interested party, and I appear with my colleagues, Mr. Ngoya, Mr. Acharya, Jomo, Debwa, Kimpa, and Dati, Victor Swanya, Faith Muge, Faith Whitewood, and Mr. Muge, for the interested part. That is the case. Thank you, Lord. Lord, just to respond to the question whether this petition should be considered for the others. The questions that have been posed in the instant petition question the constitutionality of the impeachment process of the Senate that led to the removal by way of impeachment of the Deputy President. Secondly, Lord, it also questions the constitutionality of the appointment of Professor Kithure Kindiki as the Deputy President designate in that office. And for that reason, Lord, the view that we take with humility is that the petition is ripe for consolidation, and my Lord, just for the avoidance of any doubt, and my Lord, we have an application filed and dated the 18th day of October 2024 that sought an order of conservative order to stop the implementation of the decision made by the Honorable
Speaker of the Senate, Honorable Amason King. So, my Lord, when we canvass, or we have to canvass the applications as to whether the current conservatory order should be disturbed or not, we want to actively, we will seek humility to participate in this proceedings. Thank you.
Yes, my Lord, we are vehemently opposed, my Lord, to the Rejoinder or intended consolidation of this petition, but also that we don't take time before you this evening. We would prefer, my Lord, that this matter also takes the cue of being mentioned tomorrow with the others, my Lord, where we will substantively, my Lord, be presenting, my Lord, before you reasons why this matter should not be consolidated with the one that is before you today. And my Lord, so that we save time, I speak for all the respondents.
Tomorrow.
Sorry, my Lord.
Mention tomorrow.
You mentioned tomorrow.
My Lord, if you permit me. My Lord, there is a mischief that we need to cure or to safeguard ourselves against. My Lord, there is an attempt to have a litigation by way of installment in this matter. So much so that, my Lord, if you look or you find time to look at the petition and the application, you will see that the issues that are raised by my seniors and counsels for the petitioner are synonymous, they are the same.
Since it is not consented to report and we listen to tomorrow.
Most of my time, because the question of consolidation is a question of law, and it's purely on a principle question. And we will be able to argue the question of consolidation as and when they are invited. Thank you. Yes, please. Yes, I am guided by my senior counsel coordinator. The question of consultation is one that even the bench, as it is currently constituted, we can actually look at the matters and on its own motion, so matter, give directions or orders, whether it is deserving to be heard alongside the other matters, or we just need to take a cue behind other petitions.
I'm not the court has spoken. You mentioned it tomorrow. Thank you. Let's consider that tomorrow.
Just like that. Thank you.
This file has a mission date for 29th of October, but because the issues were arising, we wanted to mention it again today if there is any issue arising out of it.
In terms of appearances, and in order to save the court's time, the same counsel that I enumerated are appearing for the petition. The Deputy President. In this matter.
Yes, my Lord, for the respondents, a quorum, similar, my Lord, so that we save on time. My Lord, we would be willing, my Lord, to present before court two options. Either, my Lord, we retain the mentioned date that is given, or, my Lord, you mention the matter tomorrow, so that if there's anybody who would want to address you, we address you tomorrow, my Lord.
You don't want to talk tomorrow on so many matters. If there's no need, you can entertain the 29th.
You can entertain the 29th.
We can meet tomorrow. Yes, we are clear with the reasons. We can go back to petition number 565. No, we have not mentioned my matter. 559. 559. It was consolidated. I'm sorry, I never had you call it out. I'm sorry, it was giving me. But in that respect, we have an application, the logical have it on record. We could also mention and get directions tomorrow on the application for the recusal of the bench dated the 22nd. I will be most obliged to you. In addition, we get tomorrow, most obliged. So then we are back to the petition number 565.
We wish to confirm that on the part of the Attorney General of the Republic, we are ready to argue our application certified urgent by this court, or by the court value the matter to this court.
Well, I believe this is the matter that we had earlier indicated, that after all these matters have been considered, directions have been given in this matter, specific directions need to be given for purposes of that matter. And for purposes of the review, those specific directions to be given, I want to point out 3 things. Number 1 is that we will need directions on when the first application that was to be done after the validity application is determined, when we are going to be having. That is issue number 1. Issue number 2, that is important, is the fact that now that today the Chief Justice has caused all of us to come on the basis of these other matters, the point needs to be noted that for purposes of the basis for all these matters that empanelment was done, the reason was that there were applications for conservatory orders. Those applications for conservatory orders were first certified as urgent, and will be the first business of this court assuming there is no other preliminary issue like recusal or otherwise. Third is this, that for purposes of those applications where conservatory orders were made, the conservatory orders may have been made in 2 or 3 files, but they conserve the status, quo that is cross-cutting in all the petitions that are before you. Apart from the fact that in that particular petition, the one that has conservatory orders, where this court, because all those applications were done on Saturday, the parties, starting at least those that I represent, because of the nature of the proceedings that were there yesterday, we have not completed doing the responses to the applications by the Attorney General to lift conservatory orders. We could not be able to do the authorities for reasons that were indicated, and more importantly, my learned colleague Mrs. Kemogo, whose file has been consolidated, did indicate she has not even been served, and in that matter, she needs to respond and be heard. Therefore, in considering this issue that is itching the group that wants lifting of the orders, I would like the court to give directions bearing in mind that the stakes of the parties, all the people who are filing petitions, is to ensure you are not faced with a fait accompli, where you are told Kindiki, you can go to hell. We do not want to be faced with a fait accompli situations. Now, it will be absolutely important that the subject matter is preserved, if not for any the court. Do not shield the court. Do not shield.
Katika kipindi tunakuletea wasanii.
What's up my guys? I go by the name Rejoinders.
Eti nikipita kwa macho na nipimia, na kama sina pesa ungewezi nipimia hapa Shenster the Poet manze.
Ngoma moto moto.
If you wanna show some love, show some love, but don't fake it. Hey, ndakumenya mawazo mako. Nani anadera shire? Oh, rutani wako.
Vichekesho mkisongaza, mahojiano moto moto, stori za wasanii pamoja na talanta za wasanii.
Fiki wa kasi gani kama wapatikani wakati wa shida.
Na pia kwenye kipindi utabambika, utajijenga, utaelimika, utakuza talanta yako.
My name is Rebecca Mutie, I'm a model and I'm African Kenya. I'm a student. Napenda kusikiza kipindi cha Bonga na Katoni kila Jumatatu kuanzia saa 9 mpaka saa 10.
Kumbuka ni kwenye Bonga na Katoni ndani ya TAS TV kuanzia saa 9 hadi saa 10 kila siku ya Jumatatu.
This is Bonga na Katoni in TAS TV. Karibuni.
My Lord, with your kind permission, for record purposes, I wish to bring to the attention of the court that we shall no longer be acting for the 6th respondent in this matter, and to that effect we have filed a notice to cease acting on account of the Supreme Court decision that determined that the president cannot be subject to civil proceedings. So in that regard, we will not be able to act contrary to an express court order, and we have therefore filed a notice to cease acting, and we ask the court to deem that to be a sufficient notice that the person named as the 6th respondent is now unrepresented in these proceedings. Thank you, Dr. Kamoto. However, we are not inclined to do anything this afternoon except the business of the 2 files before the court. After that, we can take directions as may be necessary. Most obliged. As far as time allocation is concerned, this is how we will allocate time. The main applicants will give you 15 minutes each. The main applicants, we will give you 15 minutes each. Supporters of the application will give you 5 minutes each. If you are supporting the application, we'll give you 5 minutes each. Respondents will give you 7 minutes each. Interested parties will give you 5 minutes each. Rejoinder by main applicants will be 7 minutes each. We ask the court assistant to observe time strictly.
Can you permit me to say something? What? This is our first impeachment case since the beginning of I mixed up with all those things that involve
and the petitions we are allowed in protocol. And when it comes to these cases, we are all concerned about the safety of the state, to save the state. Let people see what is going to say. They should be able to that's not true. And now, say to you most respectfully, come into this movement, therefore, to fulfill the figure, to stand for the rule of law, the supremacy, and for preservation of the state of truth. Let people see what it is. Let us not come up with shouting, screaming, or complaining, and so on. My lords, your ladyship, I appreciate the matter before this court is the recusal of the judges. But please, I urge you to be a little bit more flexible on the issue of time, like 5 minutes. My lords, no counsel enjoys making an application for recusal of judges. It's a very easy. So please, allow us a little bit more flexibility.
Dr. Kamil has submitted that he needs unlimited time, meaning that he can argue this case even until tomorrow. Mr. Mute, how much time do you require for yourself?
I would say for those supporting at least 10 to 15 minutes. It's just relaxation that I'm asking for. So that the issues are only articulated. My Lord, may I suggest that we stick to the time you have allocated us, and you have the discretion to allow anybody, including my learned senior, any flexibility, please.
That's what we did last time. We allocated times, but we were flexible.
We are prosecuting this application. That we just say that officially so that you don't feel, I don't feel pressure. This is the kind of case, my Lord, that if you do not argue it, immediately this case can somehow have another problem. I don't want anybody to accuse me. I did not argue this or the other, then I have an opportunity. 10 minutes will not bring heavens down. It is only 15 minutes to enable you in the job, not for myself. But please let us appreciate that this is a court of law. And when the elections are made, let's respect those elections. And then in this election, we have a good time. So if the time is necessary for one party to ask for more time, we will consider that. Thank you. Well, the first application, which we have filed these documents in the final officially called petition number 015 of 2024 is an application dated 21st of October 2024. It is appended by an affidavit that has been sold by this affidavit has been sold by the Honorable David Moody Mabenga. It is further supported by a supplementary affidavit that is 21st of the supplementary affidavit of 24th of October 2024 by the Honorable David Mabenga. Now, in addition to that, we have filed a bundle of apologies, which I believe that we have been punished to report. Now I am looking at my own chief I am certainly going to request an additional time, but then we start and see how best we can make the time that has been allocated. In the ruling that you delivered yesterday, we made a significant point that this is a matter of extreme public importance that deals with the most weighty issue that can be conducted both with regard to the office that it relates to and the issue of political succession. Now, the issue of political succession countrywide is an existential issue of the state. Existential issue of the state in the sense that this is an issue that when you read Professor when you read all these cases from Pakistan, they are the most weighty constitutional issues that can appear before any group of judges. In for purposes of this country, we are saying that for the 2020 constitution, the matter before you, and that is why I have informed the Parliament of this application, is one that is an existential issue for purposes of the 2010 constitution. The Lordships, I say, Honor, sorry for interruption. It will be noted. I am unable to follow proceedings. Okay. Now it's okay. So I was submitting saying that it is an existential issue for two reasons. Most of us who are sitting here are aware of two provisions of the former constitutions of Kenya. We used to have a section 23 of the Kenyan constitutions in which all executive powers were vested in the president. That position radically changed under the 2010 constitution. We used to have section 30 of the constitution in which parliament meant the president and the legislature. Now, those positions changed. The change of those positions, which the submissions that we are making, the impeachment proceedings will have the consequences. If it goes the way in which it has gone, or effectively bringing back Zambia, sections 23 and sections 30 of the former constitution. Now, the second issue that we need to emphasize on the existential issues of the constitution is this. Now, from the standpoint of the constitution, and this exact constitutionalism, there is these issues that is called security of tenure that certain officers enjoys, particularly with regards to the questions of removal. Now, the two officers that enjoys the greatest tenure are the office of the president and the office of the deputy president. Now, why is that the case? Because they are legally protected that to remove a president or a deputy president during impeachment. They are also secured by the electoral process. That those two people, to get to those offices, they must be voted into those offices by the people. Now, the significance of this is this. Every other holder of the offices, from constitutional office holders to judges and everybody else, doesn't enjoy political tenure. It is only legal protection for those particular offices. So that my Lord, the point is this, that the true weight of this matter is this. If it were to turn out that an office that enjoys the greatest protection, like the office of the deputy president, can be called, removal can happen, as we are alleging it happened in this case, but the whole scheme of constitutional tenure and protection that is necessary to protect our democracy will be effectively null and void. This would mean if you have numbers, you do not like the speaker of the day, you can get him out. Numbers in a democracy, that is why you raise the constitutions, numbers must be controlled by law. If we reach a position where the numbers seems to be controlled by the law, now that will effectively and negated all the constitutional gains that this country has made. Now, having made that point, the nature of the issues that you are dealing with, let me come to the issues before you. Now, the petitioners, in those cases, in those applications, in the applications, are saying a very simple issue. They are saying that as a result of events that occurred in Kirinyaga, that are partly the subject of the yesterday's decision that was made, and as a result of other matters that is the subject of the supplementary affidavit, the petitioners feel, and the petitioners are of the strong opinion, that a case of this magnitude is not the kind of case that should be decided by a bench in which they do not enjoy full confidence in. My Lord, the basis of that, since it is highlighting, would be four. My Lord, on the first issue is that the petitioners, and in the applications that they did, and is a subject of overruling, they pointed out certain issues that brought into question the issues of the transparency, the proper accountability, for purposes of the handling of that particular file. The affidavit is there. And then according to the petitioner, that brought into them some doubts, the manner in which the handling was done, as to the impartiality of this particular bench. The petitioners goes on to issues number 2. They say that whereas they put in an affidavit setting out the reasons why there was a problem with the manner in which those issues were done, the respondents did not respond to challenge those particular set of facts. But what the petitioners are saying that now that the respondents did not challenge their set of facts, the contrary issue that happened is this. That in the ruling that was read yesterday, we got about 30 minutes ago, there was a section that was called other issues. In the section that was called other issues, the petitioners are saying that this court answered factual and evidential issues that relates to that application. And the consequences of that is that although they had been agreed to them, that would amount to this court entering the arena of conflict between the parties, the petitioners and the respondents. And my Lord, the old principle applies that a judge, one cannot be a judge of his own cause, and in any matter that they are dealing with, it should be a matter that they are absolutely neutral as far as the facts and the evidence are concerned. My Lord, in our people societies, I talked to my parents, I talked to this other, he said his community had the same set of issues. According to my community that I came from, in those cases that used to be done traditionally, the first thing that would arise was this, and that 159 said we respect our customs. It was to ask, what who will be able to determine this case? Are all the parties satisfied with this group of wazes that will be deciding the case? In either of the parties say, we need to do that. I don't know about yours. I say, I don't know whether he thought for himself. But let me have something. I didn't want to destroy him by the point I was saying, I am happy that I can defend himself what he told you. But what I'm saying, at least for my community, that issue that I see, does any of you have a problem with any of these wazes who will decide the issue? Now, if the issue arose that a party said they don't want that consent to be there or that other one, invariably, and this is communal justice, that person would pull out and get another that everybody feels comfortable with. So, my Lord, and I've appeared with you, I respect all of you absolutely. The petitioners are saying the circumstances of this matter is that we are unable to enjoy that confidence. Now, when the petitioners were speaking about what they say they feel, like in
is a 3-judge bench, one in which they expect fair and square justice. That is the terminology in the case of Yolongoli that we have attached in our submissions. But from the word go, a party appearing before the judges should be able to feel that we have a reasonable chances of success between those judges, but more importantly, that none of the judges is connected to the cause, one to the cause, or to the individual in which you are in dispute with. Now, why is that important? That, my lord, is important because since Saturday of this week, in fact up to yesterday, the petitioner says they have been treated to a situation, and a lot of those information people have sent it to my phones because they have seen it on television. We have such a scenario that repeatedly they keep saying we are going to have what is this word? We are going to have a swearing as soon as these 3 judges meet those particular orders. But that cannot create confidence because assuming it is not this case, every partner will have very many cases here. If somebody you are drinking in a bar says, no, you are going to lose that case before the persons we are appearing before. That, my lord, is a party. Parties are not lawyers, are not supposed to be sophisticated. That party will be left certainly with a huge problem as to whether actual justice is possible. And it will actually be, my lord, that whenever else is dealt, the petitioners will win this case. As we expect, we shall win if the petition is hard. But if that is the case, and that may actually be the case before you. But my lord, the scenario that is bad and that is prevented by the law is the scenario where the parties lose. Because they will say, oh, we have the Nancy told us, Oscar Sudi told us, Counsel told us, and all these individuals who are saying it was all drama. We are here for entertainment. But if judges are supposed to be treated to entertainment, and those judges are supposed to stop that entertainment, well, there is a problem on the face of it. There is a notice of appeal that we have filed, and it is part of the supplementary affidavit. In this notice of appeal, the lordships, we have pointed the issue, and we have said one of the other issues of concern is that the judgment of this court that dealt with these other issues, that judgment, the contents of that, amounted to preempting and answering the application that I'm arguing before the court. Because those issues we are submitting did not come from the respondents, but these applications having been filed, we are arguing these applications. After, in the previous hearing of yesterday, we have effectively been responded by the court itself. The petitioner says that they are absolutely uncomfortable with that, and they cannot be able to say that if we have reached a situation whereby judges are answering our case in advance, it is absolutely bad and beyond repair. Now, the second last issue that I want to say is this. The issues is, and we expressed that concern yesterday, we were not sure whether we didn't file a notice of appeal as counsel. But we are told you cannot file this one because it is the issue as far as we are concerned, we were not treated fairly. We were accused, we are playing to the gallery, as a result of the accusations and indictment that we are playing to the gallery. What effectively ended up being glossed over is the question of, it is a question of our own submissions. And now the basis, and therefore the accusation, and we are saying we are not treated in a temperate and judicious manner. The petitioners and their advocates. Then now we go to the deciding for purposes of yesterday, the whole issue. Now the whole issue in our petitions, a number of them when it comes, will be the question, does the IEBC have the power to have authorized the president to say that he did? I'm saying it is in our petition. I'm saying one of the issues that will be coming in for determination not going to substantive application. So recusal. Let him speak. Let him hear the issue and the answers. Madam, I was making is this. One of the questions, I want to try to 165. And the question is this. The question that will be arising is whether the IEBC Road Commissioners could have declared Honorable Kibiki to be suitable for this nomination in the letter they did to the President. Now, that particular issue is significant because the petitioners are saying that this court, having effectively read Article 165(4) in a manner that amounts to amendment of Article 165(4), they perceive the real danger that when a more important question arises, the same logic will be applied against them. And they are saying, this being a very serious legal issues, the bench cannot be said that for purposes of the issues actually in convention, that the people can be oblivious of such an issue. I need like 2 or 3 minutes. But having said that, therefore, it is our submission. And all of them are saying, nobody extracts any knowledge. It's this kind of an application because judges are legal experts. But now the point that we also want to add for purposes of this application, and this is contained in the advance of my clients, is of course to point out to the issue that the Honorable Deputy President regarding Gachagua, by a letter dated 23rd of October 2024, did file a complaint against all the lordships. And this complaint was acknowledged by the Judicial Service Commission that it has been received. Then there is an issue that required disclosure. According to the petitioners, I was even aware of this, I saw it today. According to the petitioners, is that there is a very close relationship between one of your lordships, the Honorable Judge Nuruma, and the Speaker of the National Assembly, who is the Speaker of the Senate, who is a member of here. That close relationship, according to the petitioners, is one that ought to have been disclosed so that parties could be able to make up their mind with that are you comfortable, and we do that every day. I've actually not proceeded in a number of matters for some of the judges who are my classmates, say, keep your office, you are close to a person, are you comfortable? That question ought to have been raised. That issue was not raised, and as a result of that issues not having been raised, and now having come to public notice, the petitioners are of the view that it would not be proper to be able to proceed in this matter. But in conclusion, what I would like to add
before my learned friend concludes, I want you to be clear. Could you please assist us to set out the nature of that relationship and where it is expounded in the academic?
Well, I know that I thought that can actually come during the response, as I was saying.
The duty, the burden of establishing facts is on the person giving facts. So we want to know that relationship so that we can respond to it.
Yes, my Lord, I have no problem whatsoever. There is a written affidavit. Now in paragraph 6 of the supplementary affidavit, it reads as follows: whereas I was not aware of the relationship between the Honorable Justice Nuruma, who is among the creditors in this matter, and the foreign respondent, that is King, it has been brought to my attention that the Honorable Judge and the foreign respondent, Speaker of the Senate, are very close friends as demonstrated as here under. 1. The respondent attended the wedding ceremony of the judge and he took a photograph with him. The post on social media,
I think I should finish.
Yes. The particular demands of practice of people are taken in my humble submission to oppose most of it. We are looking at this for petition. It's clear that some of the teachers do not do the right thing. I think trying to make a reference in a practical manner, which is negotiate with the level of shift for both. I would especially say to you that this is an area where we have also to protect the judiciary and the judges and the managers of the judicial officers. I'm not very sure that we should have an in-depth account of what really is going on in the review.
Thank you, Mr. Padilla.
Let me explain that there is a new application that has just come online that contains some of these allegations. It wasn't there before, and that's what I saw.
I think I agree with Dr. Kaminwa that unless, because as I said, this information or something that came to my notice, but I was sticking to what the learned colleague is talking about, unless there is insistence by my learned colleague. But I do not see the value of that insistence and follow Dr. Kaminwa's position. It is stated in the affidavit. I will not say anything more on that. The rest of it can say we can have a rejoinder when the issue arises. But the problem with these issues of somebody not continuing what they are saying is that you keep forgetting the last point. The last point I think that I was making is this. That at the heart of an application for recusal, the authority speaks themselves, the one we have cited, I will not have time to go through them, is these issues that are considered very important. Number one would be whether, on the basis of the accusation and the pretensions, separately, would one party feel that their rights to fair trial before an independent, impartial, and fair tribunal be upheld? The petitioners on whatsoever say their right under Article 50 to fair hearing, which is absent, would not be possible with the circumstances of this case. Number two, there is a question of the right to protection of law under our Constitution. That right to protection of law requires that for it to be protected, there must not be any doubt that that protections will be availed if it is deserved in accordance with the law. The petitioners again say they have reasons to believe as a result of all matters taken into account that their rights are that. But I have to finish. But the final issue that is critically important for this issue is the old notion, the old principle that justice must not only be done, but must actually be seen to be done. The circumstances of this case, it is our submission that apart from the real issues that the petitioners have, the better perceptions, whether substantial issues, the petitioners are saying that, your lordships, they are unable to say that at the start of this proceeding, we are confident that these judges are capable of upholding our constitutional rights and to uphold justice equally between us. Well, we are most observed. Thank you for letting me conclude substantially on what we set out to do. We are most observed.
My Lord, before the next speaker goes on, I think it is something the agreement is not fair to the court. Because my learned friend was charged by Professor Mugeli to tell you what is the specific thing. Let they take a posture, assisted by the senior, that we don't want to go there. You cannot eat your cake. The reason they don't go there, my lord, is because it is frivolous. Now, the misfortune where is this? The world is watching these proceedings. They say we don't want to go there. And the typical person watching this, there is something very serious about the integrity of the court that they are raised. When as a matter of fact, going by the list, the judge went to a restaurant. In one of their opinion, we say the judge went to some law school. Clearly, we are being unfair to the court. We want to paint a picture, hiding that we don't go there, so that the world will be left with the impression that there is something terrible about it. My lord, I think it was Tom, I would say, if you want to paint a picture of me, don't embellish, say it once and all. If there are any allegations now that we are conducting these proceedings to the world, if there are an allegation of any impropriety against any judge, they can't blame the case for the gallant exit. We don't want to do that.
Whose machine is
There's something wrong somewhere. What happened? I'm excited. I'm going to go. There's something going on.
There must be something wrong with that. If you are using a gadget and your gadget could be posting this noise, please just set it.
May I make a comment, my lord? May I remind my understanding very, very respectfully. It is our duty to protect the court.
They are not protecting the court, they are telling the whole world that this court is improper,
May I say what I want to say?
We apply for recusal. I think the proper way, Dr. Kamina, let parties submit according to the directions which we gave. And of course, again, there is an application supported by affidavits. There are amendments in those affidavits, and because some of those amendments actually touch on us that we cannot defend ourselves, we would be satisfied if you read them even broadly, so that the world knows that these are not complaints against the bench.
Madam, may I say something? As you are not aware, at times when we are in the court, the open court, yeah, you say to a judge or judges, but our information, but our that was so clear that you cannot hear this matter. Can you go to the chamber so that I can discuss that? I'm not asking to go to the chamber. Also, I will say, as lawyers or as advocates, we are also under duty to protect the judicial system and to protect the people of the judicial.
I think that is what I think one way of protecting judicial officers is by disclosing in front of the case what is there.
I think that I want to do to respect.
Next time, I hope also don't have to say must be impeaching, which is what they are trying, then accusing or not treating. Because I have not actually read everything. There are other issues I could also have read. But now I'm doing this. Hearty congratulations to my long time friend. That was underlined by there. And the source is Right Honorable Amazon Jeffa Kegi, EGH. the petitioners say the issue, and that is the issue that I picked during my submission, that there is a long-term friendship between the judge and the party. That long-term friendship ought to have been disclosed. I said that. Then it goes on to say, on the occasion of the renewal of your marriage vows with your beloved wife, it is now there, because they are hidden. You are a true testimony to the belief that spouses resolve to speak with each other through thick and thin, great things can happen. I wish the two of you the very best in this long journey, and pray that God continues to bless this union and review you with his riches, wisdom, and the patience that comes with marriage and family life. Ongera Kakayo. And below there is the photograph where a gift is being given by the Honorable Mr. King, Senator, to the couple of Judge Rima and I believe his spouse. That is the annexure that was put by the petitioners in proof of the fact that there is a close relationship, a close friendship that under the law ought to have been disclosed, given that Kingi is a very important party for purposes of the case against the Senate that he botched everything and has come here to defend those impeachment proceedings. I believe my job is done, and because that is all that it says, and that is the affidavit of the petitioners. Unless they need me to read something else, I can sit down.
I am in 509 where we have the application. 509 is in part 1. Yes, property 1. That we are arguing the application dated the 22nd of October with a number of damage lordship having been filed this afternoon through the court's email. The lordship from the onset with heavy heart lordship that we have moved you through these mechanisms, and that the lordship and submissions I begin by indicating and relying on the Judicial Service Code of Conduct and the 2020, and I draw the attention of the court to Regulation 47. Regulation 47, the Lordship states that a judicial officer may recuse himself or herself in any proceedings in which his or her impartiality might reasonably be questioned, where the judicial officer, 1, is a part of the proceedings, B, was or is a material witness in the matter in controversy, C, has personal knowledge of disputed evidentiary facts concerning the proceedings, D, has actual bias or prejudice concerning a party, E, has personal interest or is in relationship with a person who has a personal interest in the outcome of the matter, F, has previously acted as counsel for a party in the same proceedings, G, is precluded from hearing the matter, H, a member of the judicial officer family has economic or other interest in the outcome of the matter in question. A recusal by a judicial officer shall be based on specific grounds to be recorded in writing as part of the proceedings.
Your Lordship, it is my client's, the petitioner's case, but this bench should recuse itself on the ground contained therein. Permit me to begin by indicating that yesterday when the court was delivering its ruling, it indicated actual bias on the part of the parties before you, Your Lordship. The petitioners were condemned in a wholesale, in disparaging language coming from the bench, a language that indicated prejudice or bias on the part of the petitioners. It was indicated by the bench, Your Lordship, that despite the heavy submissions, the authorities that we quoted, we are not addressing the bench, but addressing the government. It is so prejudiced, Your Lordship, that such perception on the part of the petitioners culminated into the court not even taking note of most crucial issues that we have submitted on. For example, despite the plea that is now being launched, the court failed to take into notice of the position of delegated authority. It is a considered submission, Your Lordship, that had it not been for the bias and the prejudice that the court has on the part of the petitioners, such would not have escaped the mind of the court. Your Lordship, further, the court made further remarks that we take great exceptions to the remarks of the petitioners. When the court indicates that they take great exceptions to the remarks of the petitioners, it's a prima facie indication that the court has descended into the realm of dispute, and that the court therefore becomes or takes a defensive approach in the manner in which the prosecution of the case is being conducted. Your Lordship, a judge must at all particular time be a sovereign person, slow to anger, and of good temperaments. Your Lordship, the statement indicates that the court has taken a position as against the respondents, the petitioners. And the position is prejudicial to the petitioners and erodes their confidence to continue appearing and making submissions before this court. It was the observation of these honorable court, Your Lordships, that my client indicates that the court made further findings that the petitioners were not pursuing the urgency of their applications. What a reasonable man, a bystander, a fair-minded person, listening to these statements, internalizing them, will come to a conclusion that the court has taken a hard position on or against the petitioners. The test of a fair-minded person, Your Lordship.
My Lord, we really need to intervene, but my colleague, if he is at the time already to say that, let him tell you how, yes, the ruling you issued will be a basis for an application that was out long before that ruling.
Your Lordship, if he may be patient, you have his chance to bite the cherry and respond in that manner he so feels that he should. Your Lordship, the application has also indicated that Justice E. Ogona is closely associated with his spouse, who serves in the Water Kenya Towers Agency. The abundance of our clients, Your Lordship, because this is a matter that also have been disclosed at the inception of the proceedings.
Let me get you right. You mean the judge is closely associated with what?
So that the court does not again disclose me. The Lordship, the spouse of his Lordship, one Florence Oloch Auma.
Did you report to that issue?
Yes.
There's a disposition to that.
Yes, there's a disposition of that issue.
That Florence is the one?
Yes, there is.
Paragraph?
Yes, paragraph. Paragraph 13 of the supporting affidavit, as read with paragraph 11 of the further affidavit. She holds a position in the Kenya Water Towers Agency, an appointment that was done pursuant to the Gazette Notice number 7515 of 2013, for and on behalf of the presidency by your current year. The Lordship, it may go on record that the sixth president who initiated or made this appointment is a party in these proceedings, and that the parties.
No, my lord, I'm not getting you right, and I'm sorry for that.
Where are you lost, my lord?
If I'm looking at the same document as you,
yes.
The Gazette Notice 7515 was issued on the 7th day of June 2023 by Soipan Tunya.
That's correct.
Cabinet Secretary for Environment, Climate Change and Forestry.
That's correct.
The sixth respondent in this proceedings is who?
He's the president.
Then, where is the next one?
I'll get there. I'll get there. Your Lordship, the cabinet under the Constitution is constituted of the president, and the cabinet secretaries appointed thereafter, and the deputy president of the Republic of Kenya. That's your plan to Tuya is an agent of the presidency. Your Lordship, one of the issues that was before the impeachment was that the deputy president, the petitioner hearing, indicated that Kenya is a shareholding country. There are shareholding agreements before you, and that positions either in parastatals or corporations want to be shared in accordance with that share agreement.
That is the reason why his current will impeach.
You have been given an opportunity to ask, yes, you will be given an opportunity to respond. We believe you are eating, Mr. Lamont. Take your call. Your Lordship, it is by client submissions that Florence Auma Oloch may have been a beneficiary of that shareholding. Your Lordship, finally, Your Lordship, we have
it is extremely unfair and unjust, especially for an advocate to mislead or what you say to play to the gallery. Can we read paragraph 12 of the affidavit? So that it does not. Yes. Let's hear it from him, where he says that the Senate board is chaired by the president, who has. So can you kindly do it properly so that you don't have to hold on
Hold on, Your Honor. The two lordship and my lords, they will have time, as you say, to respond and say all these things. If he's saying nonsense, they'll stand up and say so. But this constant interruption is intended to delay this hearing. Let them respond when the time comes.
Yes. And we have involved the condescending nature of the respondents. Everybody here has been instructed by a client either to speak sense or nonsense. So, that being the case, the condescending attitude is completely objectionable. And everybody should take their seat and use their time with sense. If sense can only come from them, they do it during their time. Thank you very much. Can I finish my protected admissibility, and the rest will be granted. That's what I was saying. You will have your time. I know you are press one, but it really says the application be presented. Let's not have a few
Just one thing.
Your Honor, if I'm allowed to just say something. Applicants finish their case and then people will respond. Because these interjections are just going to affect the conduct of the proceedings. It's very unfair. Let everybody have a chance. Each person has 10 minutes, others have 5 minutes. Let them utilize their time. But these objections in between is unfair and it's affecting the flow.
Come before you say that. My dream is to conduct these proceedings in an orderly manner. As Professor Dipu Bujai used to remind us when we were in school, to be an advocate, you are a superior mortal. Can you just be slightly superior and deal with this thing in an intelligent way?
However, if you have one time to almost oblige Lordship. It may be noted that the Lordship, the chair of this board is directly appointed by the President, the six respondents in this case. The Lordship, may I submit again that the perception out there is that this bench has been constituted for a particular purpose. And the bench is just a mere conveyor belt, and that the parties herein will not have the chances to have justice of their case being dispensed. The Lordship, I have annexed a tweet by Senior Counsel Ahmed Nasir, annexed in our affidavit at paragraph 12, and I wish to read that tweet, Your Lordship. Ahmed Nasir, Your Lordship, is a senior member of this bar, a senior counsel, and Your Lordship, here it goes. The conservatory orders will be discharged by the 3-judge bench, latest by next week, if not by Friday. Even as we approach you, Your Lordship, the perception out there is that this bench is part of the conspiracy.
And of mercy is not the law.
Your Lordship,
He speaks not to the law. And of mercy has also an affidavit. He's not a witness, my lord. How does an of mercy, we have 64 senior counsel. How does an of mercy, how can you state informed submission before this court?
May I answer that, Your Lordship, to the good professor, that we are speaking about perception. The standard of a bystander, the reasonable man, a fair-minded man in the status and the character of a senior counsel, and that's what says, and the president's lawyer says, we cannot receive gratis. That is the standard.
This court will quash.
Mr. Kenya, you can have the time to respond.
No, but the point is, he then speaks in your favor.
This is that point. Let him respond. You will not reach here to submit. You will pick the line that is so wish. But you have seen, Your Lordship, that the perception out there is that this bench has been constituted as a conveyor belt. Further, Your Lordship, this court will remember that on the 16th of October, we moved the court for a mention on the 18th. The court declined to grant that mention and slated of file to be mentioned on the 29th of October. But when they were moved by parties in these proceedings, the court was generous and gracious enough even to sit on a weekend, to sit on a Saturday. Noting that we were before you, we slated our matter for the 29th, and there was an urgency. Your Lordship, how can a fair bystander be convinced that this court will dispense with substantive justice? How can it be said that this court is impartial? Your Lordship, the question of a spouse being linked to a judge, as indicated by Rule 47, is of paramount importance and something that cannot be ignored. Why did the court disclose to us? Why did the court conceal? If the court can conceal such kind of apparent evidence, what else is it capable of concealing? Your Lordship, permit me to indicate that in our affidavit that we wish to expunge paragraph 16 of our affidavit, supporting affidavit, will not rely on it, and paragraph 10 of the same affidavit will not rely on the same. But the standard, Your Lordship, is that of a bystander. Another Nazi spoke, and he has a following of over 1 million on his speaker handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is considered for a particular nation, 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Masharia will highlight on the authority in support of my submissions and those of Eden.
On expansion, paragraphs 10 and 16, if I had properly. Yes, of people supporting affidavit. Excellent. I don't know whether we can do that. Through oral submissions, you cannot expunge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number 2, if you expunge paragraph 16,
can you cover it in the response, please?
I know that if you expunge 16, I have a problem with that. There is no obligation before you. If you expunge paragraph 16 from the affidavit, there is no application has been added for you. So you know this clarification, then let's not take things lightly.
Mr. Lordship, yes, it is true that the paragraph that I seek to expunge is paragraph 16.
These affidavits, the applicant's affidavit.
That is Obui Namena.
Perhaps, my lord, again, because we have to be fair to the court, my committee has to be candid and confirm to the court. The reason we will be withdrawing that paragraph 16 is because the claim there is factually false. Because you can't just withdraw and do the one thinking. I don't see that paragraph. You can read it. The paragraph 1
Your Lordship, are you having the same agreement as paragraph 10, which we have to withdraw, and paragraph 16, so that we can consider if it can be yes,
We give Mr. Debo my votes in nomination
yes. Let's read those paragraphs here so that we can sit down.
I'm just saying it was 13 from these tutorials that he's getting for this.
Lordship, I would wish to say that most respectively, I wish to say no more with respect to the paragraph. Paragraph 16 we have some issue. How many people in conduct of these trials? Listen, who is in conduct? Listen. Yes, Lordship, I believe you have applied to expand paragraph 10 and paragraph 16. Yes, Lordship. Can you read those paragraphs which you intend to expand? Your Lordship, paragraph 16 says paragraph 10. Your Lordship, may I take note that these paragraphs have been expunged. One, we have to expand those paragraphs, but there's no application to expand them. The petitioners have credible information that Honorable Rima is a close associate to the proposed the president. One is the Kidore Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expunge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is conflicted as she should excuse herself, as she was Mr. Kidore Kindiki's LLM student at Moore University. You have no LLM program at Moore University. You have the right to survey, sir. And that's why I'm expanding. That's why I'm expanding this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
You have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
Some issues to be linked.
Because
and a response is there, that we decline the invitation to extend, they will remain as part of the request. We are not obliged. I would appreciate if you want to address us in the course of the as you are submitting. Is that the position? Yeah. Okay, proceed.
Is that it is a party?
Are you supporting the motion?
I'm supporting my own friends. Complaint is not going to apply fairly sufficient.
Yes.
Thank you very much, I'll take about 15 minutes. Massively, my issues are issues of law. They will not incite any shooting up from opponents. They should not. My lords, I have my lords in the leadership. I have submitted some two cases. The first case is the case of Standard Chartered Financial Services in another versus Manchester Allocators. I don't like to have that with you. And the second is a case called Naveen Prenjikarai versus the Regulated and others. In the case of Standard Chartered Financial Services Limited versus Manchester Allocators, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set aside and valid. And the only question before that court that led to this decision was the question of bias. I invite my lords and the leadership to paragraph 1 of the decision, where the court says as follows in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declare finality, set aside, and the appeal had fresh. I invite you now to go to paragraph 9. We've done back to back the photocopy, but if you look at paragraph 9, in the middle is in bold, the words Jasbir Singh Rai and two others versus Talkan Singh Rai. The court is saying what is held, and it says this. During the pendency, my lords and your lordship are there, in the middle of paragraph 9, during the pendency of the applicant's motion on the respondent's preliminary objection, this court in a 5-judge bench decision in Jasbir, and I review the whole case there, held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and hear and finally conclude the matter. In light of the decision in the right case, it was deemed appropriate that since this matter raises similar issues, it is similarly had by a 5-judge bench, hence the unusual composition of this bench. They are merely underlining the importance of the matter the court is dealing with. Permit me now, your lordship and my lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which involves the court and my friends with, which is a well-known case of Senator Agustin Pinochet. But at paragraph 63, this is what they say. Bias, whether it is perceived or actual, undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by the judge in R versus Bob. Justice must be rooted in confidence, and confidence is destroyed when the right-minded people that Mr. Bego was talking about go away thinking the judge was biased. At paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a jury is alleged to be biased, it is important to keep in mind the appearance as well as the fact of impartiality has been done. And this is what they say at paragraph 6. And this, my Lord, your Ladyship, is what I would be beseeching this court to find favor with when you retire to the The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own trial judgment saying this in court, this rule is to be very strictly applied so that even the appearance of bias is done away with. The appearance. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, we then cite a case called R versus Sussex. Justice should not be done, but should modestly and unfortunately be seen to be done. I will leave for you to read paragraph 67, which I also recommend to you. And then paragraph 71, another in which case cited. First, actual bias will of course always disqualify a person from sitting in judgment. Even in the absence of actual bias, however, the importance of public confidence in the administration of justice is such that even the appearance of bias will disqualify. And we say emphasis added. And I will also invite you to look in the fullness of time to paragraph 73 and 74. Paragraph 81, they cite the case cited earlier, I think I mentioned it. This is the case of the Agostino film share. It actually begins at paragraph 80. There's a long passage, I won't read it on account of time. But at paragraph 81, they cite the basis for the reason the two applicants before you have moved. It's the Latin phrase, nemo debet esse judex in propria cosa. No man is to be a judge in his own cause. Then at paragraph 82, Lord Pope, in the same position. Indeed, it may be said of all the various tests which I have mentioned, including the maxim that no one may be a judge in his own cause, but they are all founded upon the same broad principle. Where a judge is performing a judicial duty, he must not only bring to the discharge of that duty an unbiased and impartial manner, he must also be seen to be impartial. Having considered all those, the court, and then in that case, what the issue was that the late Justice Laka had been presented on the parties previously, not in this matter, but previously. But at paragraph 86, they give a summary of what I told you, and then go to paragraph 88, and then this is how the court finally resolves the matter. I will also recommend to you paragraph 90. Let me read paragraph 90 before we go to the conclusion. The mere probability or appearance of bias was enough to breach the cardinal rule of fair trial in the administration of justice. Having raised the issue of bias arising from the same circumstances in the hearing of an interlocutory application by the same judge in a matter involving the same parties, we do not understand why the applicant's counsel failed to raise the issue during the civil appeal. That omission notwithstanding, the seriousness of the bias, of the issue of bias, cannot be underrated. As observed in the Benzo case, bias is one of the grounds that will justify review of a previous decision of the Court of Appeal. And I say, this was the first time it's ever happened in the history of the Court of Appeal, and as far as I'm aware, the only time it has happened. So paragraph 25 is what the court says. Accordingly, we allow this application, declare that there was a failure of justice in the judgment dated 4th October 2002, and we accordingly invoke the court's residual jurisdiction to correct that injustice by reviewing the judgment and setting it aside with all the consequential orders. Now, my learned friend, Mr. Kibe, has referred to a passage that my even learned friends who respondents insisted must be read. And this is a question of the attendance of a wedding where gifts are shared by a judge, who the gifts are received by a judge by a party who is before this court. We are before this court because the first petitioner was impeached in the Senate. The Speaker of that Senate is a party in this case. In the document presented by Mr. Kibe, the speaker describes the judge, and there's nothing wrong with having friends, as I should say. He says, my long-time friend. This is what he says. Now, we found a decision, and I've shared it with you. This is the case of Naveen, where on August, a similar situation occurred. And I invite the court now to look at paragraph 70 and allow me to read this, because I won't be reading anything else after I read this. This is what the court, this is, I said, is Naveen, Crime versus Veronica Limited and Arts. I begin to. I say paragraph 70, please forgive the declaration of the authority. And this is a 2022 decision. So both the Standard Chartered case and the case before you were determined under the current constitution. And as I'll be demonstrating here, they also took into account the Judicial Code of Conduct. I'm reading from paragraph 70. In this matter, the third respondent declined to recuse himself. This is a matter of an adjudicator, appointed under Article 159. Declined to recuse himself on the basis of the relationship between him and the counsel for the first and second respondents was a professional one. This court, however, takes judicial notice of the fact that in the Kenyan context, invitations of colleagues to weddings is extended to those that one considers close, and such invites are not extended to all concerned. Had that been the case, then third respondent would have as well extended the invite to the counsel for the applicant who is an advocate just like him. Given the circumstances, this court arrives at the inevitable conclusion that apart from being a professional colleague, the third respondent and counsel for the first and second respondents are friends. And that is the perception that any reasonable, objective, informed member of society would reach based on circumstances of this case. I continue paragraph 21. As counsel for the applicant stated, it is common knowledge that there is a custom for invited guests to give gifts at a wedding, exactly as happened in the case Mr. Kibe showed. In this case, apart from the third respondent and the counsel for the first and second respondents, the applicants and the counsel will never know if the counsel for the first and second respondents whether gift-bearing guests at the traditional wedding or not. In this case, we know because the photograph depicts a gift. It, however, boils down to the failure by the third respondent to disclose to the applicants and the counsel that he intended to invite the counsel for the first and second respondents to his traditional wedding and seek their views on the same. I need to emphasize that the real issue here is not that a wedding was attended. It is that that issue was not disclosed prior to the hearing and dismissal of an application in this matter and the continued conduct of this proceedings. I continue. Bearing in mind the final nature of arbitral awards, which can only be set aside upon and together satisfying the conditions stipulated under Section 35 of the Petition Act, the need for disclosure becomes even more critical. Paragraph 72. In S versus Roberts, the court stated that the application be that of the reasonable person in the position of the litigant and that is based on reasonable grounds. I continue at paragraph 73. The counsel for the first and second respondents has stated that since he and the third respondent are arbitrators who have served at the Chartered Institute of Arbitrators, Kenya branch, as chairman and vice chairman of the institute respectively, during the same tenure, they were bound to interact or have interacted in the Chartered Institute of Arbitrators events, trainings, board meetings, and members' welfare gatherings were discharging their professional mandate. I do agree that the above events are professional in nature. However, weddings are personal events where families, friends, and close colleagues are invited. The lack of disclosure by the third respondent that he had invited the counsel for the first and second respondents to his traditional wedding is one that leads to the perception of bias. Due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence that applicants have that he will be neutral when it comes to the hearing and determination of the eventual proceedings before involving the parties hearing. In conclusion, this court holds that there was a lack of transparency on the part of the third respondent, and he should have done the honorable thing when he was requested through an application challenge to recuse himself from the arbitral proceedings in nature. This this court finds that justifiable doubts have risen as the file students' impartiality and independence, and the same have been proved by the applicants. This is a decision, and the only one we could find that addresses on all fours the issue that confronts these courts. I asked this court to find favor with this decision, to recuse itself, and I said, and I do so with tremendous respect. It's just that the nature of the matter, the nature of the issues, and the perception as such as are captured in that decision. Recusal will be the only thing that will do justice not only for the African before you, but to the court itself. Thank you for the privilege of your attention, for your time, and let's get any questions. I'll answer that.
My humble submission that your lordship must exercise flexibility. The legal case law getting recusal is inapplicable in legal cases. As a matter of fact, I will take you very respectfully. If there are parties, and if there are, if you want to hear this matter. Please walk out. You are not the only judges in the country. There's another panel of judges who are appointed to hear this matter. My Lord, to say so very respectfully to refer to my own history. When you reach my age, you keep on looking at your history. I remember there were one or two expatriate judges, colonial judges. The moment you said to him, or to him, if you wrote it, I would like you not to hear this matter. I want you to speak yourself. His response was, okay, I mean, if you don't want to hear this case, get another judge here. That is the attitude. Those of us who have had the advantage of receiving higher education know when you're giving introduction to philosophy, you are taught perception. The first course you take is perception and reality. Perception and reality. When you're studying philosophy, perception is a very important concept when it becomes the arena of politics. Reality will be completely different. And indeed, I believe it is different in the case before the Lordship. I appear before you very often. I have never entertained any idea about your standing in relation to justice. But the perception now that has been painted by my able language friends, friends, with the American group, with the Cuba, and with the Natalia, that there is a sizable portion of the Kenyan population which will not be happy to hear you sit and listen to this case at all. And may I remind the Lordship very respectfully, impeachment is all case of the country.
There's no way you can move away from that at all. I would respectfully refer you to a book I've taken the trouble to read.
Sorry for the interruption. We are muted again. Perhaps you could be unmuted so that we follow the proceedings.
I wonder why it has happened in respect of the community. Can I speak now? Can I speak?
Yes. You know it.
Yes.
Yes. Well, there is a book here, Politics of Presidential Impeachment. Politics of Presidential Impeachment. I've taken the subject during the weekend to read this book. Impeachment is politics of the country. There's no way you can remove it from the politics of the country. And that's what I'm saying very quickly. That as you have been told, there are some people who feel very strongly that it should be like this. It's all right. Then the case of the judges to hear the case. Your goodness to do this to another. There's no reason for you to remain in the case when other people you wanted to hear the case at home. May I remind you, we are hearing impeachment cases, advocates to be able to think broadly and bring to the notice the culture of the people that we are serving. There is a little song that is a song that is sung by a little girl in Kenya. Those of us who listen to the Kenyan radio may have heard of it. He says in Kiswahili, Kenya ni nchi ya watu wa kitu kidogo. He says very quickly, Kenya ni nchi ya watu kidogo. Na wanataka kitu kidogo ndio fanye kitu. The majority of our people are not the people who are in this country. The majority of our people are people who have not had the advantage of receiving the education, the training, the guidance, and the advocates, the members who are living today. And as one of my friends very carefully pointed out, majority of the people believe that the case before you has been engineered by the politics of the country. And if some of them believe that the lawsuits cannot hear them, again, I say to you very, very respectfully, you stand to lose much. You better leave the case, let other people hear the case, and you continue to maintain the law. Now, to go back to the politics of impeachment, this matter was first started in 1980. National Assembly very overwhelmingly stated that the deputy president has to be impeached. It was then referred to the Senate, and the Senate again said very overwhelmingly that the deputy president was impeached and convicted him. My Lord, the story is that one hears in the streets of Nairobi. The story is that one hears elsewhere. You can't afford to pay every stories that members of parliament were each given handsome amount of money. That may be so, or may not be so. But that doesn't matter. They have made the point that the members of parliament received bribes and they handed down a decision which majority of people believe that it was a corrupt decision. You cannot afford to ignore that. Now, when you go to the Senate, we are told the same thing. That members of the Senate receive money in what is called quite partial, quite partial. They receive money from known people. I think you cannot afford to do that at all. Now, when we come to judiciary, they expect the best. They expect people who are good integrity. They expect people who can hear and who they cannot suspect at all. But if then they are suspecting some people, whether truthfully, whether honestly or not, it's my humble submission, the natural thing as a judge, if I was sitting where the lordships are sitting, I would say, as Hanino, I'm walking out. You will not say it. It is the judiciary that people have got confidence in. That's when I remind you, lordship, where the practice is. It is the judiciary that people of Kenya acted are respectable. It is the judiciary that judges the people think that we can do good effects. When we had programs in the year 2007, it is the judiciary that served the country. When we had programs recently during the time of President Uhuru Kenyatta, and the matter went to the Supreme Court, it is again the judiciary that served the country. Now, if you find people now are questioning the very institution of the judiciary, it's my humble submission that as a judge, just say thank you and moving out. That doesn't necessarily mean that there is something wrong with you at home. And as I said, my Lord, I've spent many years appearing before your Lordship with the Justice of Order in Mombasa. At no time did anybody ever open his mouth and say to me that, I mean, this Justice of Order is this, it is, it is, it is. Nobody ever did it. I want to suggest to you, I've had the privilege of appearing before you in many cases. There are cases where I have given legally. There are cases where I have not given legally all the support. But at no stage did I ever entertain an idea that there is something wrong with justice. We have confidence in all of you. But now, we have this concept of perception. There are some people who feel very strongly that justice of all should be out. Justice Muleno should be out. I think that now say I'm getting you not speaking against you. I'm the one who has fought for rights of women. And I kept on shouting very loudly that we want to be judges. And I won't have the fortune of appearing before you very often.
Actually, you have on a couple of times.
I know, my memory is letting me down. But my own fiancé, I have had the opportunity of appearing before you. And may I say this also, my Lord, if you go and check the Judicial Service Commission records, you will not find a single letter from John Camino complaining against any judge. I have never done such a thing at all. It's because I have got confidence in our judges. I have got confidence in our magistrates that they will deliver justice. But I'm just telling you, my lords and my ladies, if at this time you have some people who feel very strongly in the camp because they will not get justice before you at all, please walk out. Don't continue to get it. And indeed, the people who are saying that your lordship or my lady should not hear this case, when they are speaking, you cannot really criticize them. They have got some valid complaints. My Lord, United States of America, which I had the opportunity and the privilege of respecting and studying their jurisprudence, they gave me additional legal education. United States of America, which has an impeachment provisions like a Kenya, for 200 years there is no president or deputy president who has been impeached and the impeachment has succeeded. None at all. None at all. Kenya, a young country, which got the first constitution involving impeachment provisions, came into operation in 2010, and in 2024, we are now being told the deputy president has been impeached successfully, has been found guilty. Is it unreasonable to suspect there is something wrong? Is it unreasonable to suspect that someone is doing something wrong? I thought that would be enough. And I want to probably educated. But in some very situations in the Republic of Kenya, why believe the first one within such a short time to be impeached in the country? Is there can't be suspected something wrong? That we are not doing some things properly. That America, which has had impeachment provisions for 200 years, has never successfully convicted someone of impeachment after a position.
Thank you, Dr. Kabinda. Thank you very much.
May I say thank you? May I say with your respect? I would appreciate if you would hold the circumstance. Thank you.
Last 2 minutes, brothers. In considering this application for recusal, I pray that you bear in mind the following. One, your brother is the Justice Judge of Wisdom. Your brother is the Justice Gandhi. Your brother is the Justice Nova. Sitting separately, each one of them was persuaded that the petitions and the notices of motion asking for conservatory orders raised weighty constitutional issues. That is why this bench was constituted. Those weighty issues await full arguments by both sides for the court to resolve. Number two, the weighty issues are around the petitioner applicant, the deputy president, challenging and seeking to have the impeachment quashed. In the interest of time, I will not restate those weighty issues. They are in the record, but they are there. Challenging the impeachment and seeking to have the impeachment quashed. For the sake of this country, today and going forward, those are issues that must be heard and adjudicated by a bench that has no issues of bias, apparent or real, being raised. So for that reason alone, please accede to the if you set up to adjudicate those issues. So that's
I would like to talk about just 3 aspects on the subject of recusal. And I'll be making reference to the achievements that we need to be calculated. But
recent Supreme Court decision delivered on 11th of October 2024. Leadership on the rights and on the left, our counsel were involved in this matter where the Supreme Court was asked to recuse itself, which means this is very limited in 5 others versus East African Development Bank. With the management and the clinical support of the same center to do one different sides of that decision. When that application was made before the Supreme Court, I do not want to go through all what went on. I want to go straight to paragraph 27, where the court said, having arrived at the inescapable conclusion that you are being accused of bias and working towards an undisclosed indeterminate outcome, we are strongly persuaded that our further participation in these proceedings will not serve the ends of justice, at least in the eyes and perception of the appellants/applicants. Consequently, and inevitably, each of us, his bench, does hereby recuse him or herself from further participation hearing and determination of the appeal dated 25th April 2023 and filed on 26th April 2023. That's a decision that was made just when these petitions were concluded. So, when allegations of bias and working towards a certain outcome for the Supreme Court recently is recused itself. I have a decision, another decision. It's called the State of Punjab versus the Vita Parsi, which also the question of recusal was discussed here. And again, I don't want to dwell the whole position is very long, it's about 400 pages. But at page 9, paragraph 16, the court says the standard that is applied in determining whether a bench should recuse itself. And the test, right? The test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and whether the adjudicator was likely to be disposed to decide the matter only in a particular way. And the court went on to say, the court has to proceed observing the minimum requirements of natural justice. i.e., the judge has to act fairly and without bias and in good faith. A judgment which is the result of bias or work of impartiality is anality and the trial, quorum, and judice. Therefore, the responsibility of that opinion is liable to the court. Lastly, and this is what is very important, at paragraph 18, the court said in part, however, if there is real ground for doubt, that doubt must be resumed in favor of the accused. So that means, if you are in doubt whether you should accuse yourself or you should not accuse yourself, that doubt should weigh towards the accused. All decisions will be shared. And then the court went on to quash some proceedings which had taken place, the appeal had been determined, and then the This one went all the way to the Supreme Court of India. So the court said that that is how situations of bias are treated. I had reference to the code of conduct of judicial officers. I think that's what Mr. Henry was referring to. But I want to look at this as to where those provisions are obtained from. And those provisions are obtained from the IDA guidelines on conflict of interest in international arbitration. You will find that material is published by the I wrote that from the International Bar Association, and it was done first in the year 2004, and it has been applied worldwide as a guide on determining matter situations of conflict of interest. And it has graded conflicts in several shades. The traffic light shades is green, there's brown, and there's the riverboard, sorry, the riverboard, the green, and the brown. And at clause 2.3 said, one of the situations that is a waivable conflict is the arbitrator has a close family relationship with one of the parties or with a manager, director, or member of the supervisory board or any person having a controlling influence in one of the parties or influence of one of the parties or the council representing a party. Going to the materials, if they are true, that was stated by my other friends, then that situation has already arisen. And therefore, it is a good ground for increasing. Now, I don't want to take what we thought that these materials would be circulated. It's much more in these materials that speak towards the case of the situation that is not. Thank you very much.
Sorry, Counsel, does the court have the benefit of the authority that you have to talk to in that case and the ICA case? Yes, and the ICA.
Anyone else wish to say something? On behalf of the second petitioner in 565, we are allowed to proceed. Can you see me? I'm virtual. I'm online.
What is your name?
Tomorrow, Teresia Wanjulu Makazi from Canberra.
Yes, proceed.
Yes, thank you. I just wish to support that application by just submitting that public perception is everything and it cannot be ignored. I wish to rely on Article 47, 1 and Article 50, and more specifically in Article 47, 1 is where it says that every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. And more specifically on the part that is procedurally fair. Yeah. If you look at the way the court has conducted itself, of course we are in no doubt that the court is competent enough to handle these petitions, but then again, on the issue of the procedure, we had raised an issue of service, and the court ruled that we should check all documents in the portal. Unfortunately, today, we could not access the e-filing portal. So what one is meant to wonder is why we were told to access documents online, and when we go to the portal today morning, it's not working. Therefore, there is this perception that perhaps there could be something going on, because at all material times, judges shall be impartial. And the issues being raised currently are that there is an issue. Sorry? Okay. So there are issues that are being raised that are raising issues to conflict of interest, whereby we have been directed by the applicants to note that one of the judge has a spouse who has been nominated or appointed by the President of Kenya, His Excellency Rebuttal. And I think that is not a question where we should be giving out affidavits. I think that is a question where the judge, the honorable judge, should just come out and tell us if this is true, then are we going to feel conflicted, so that we can, as petitioner, say, okay, proceed, or no, let's have a neutral bench. The other issue is the issue of another judge, Honorable Justice Muruma, being seen. No, not the judge, I'm not saying the judge, I'm saying the spouse of the judge. Being nominated, that's the issue that has been raised by the applicants. And so we feel, of course, if this appointment was done, will he be able to in Murima, attending a wedding ceremony, Kingi. So the issue is, and they are long-time friends, will he be able to disappoint a friend? No, these are the issues that the public is asking, and it's the perception only. So in issues such as this, we say these issues are very important and they cannot be ignored. And in no point of, if people are saying we don't want the bench, it's not so hard for the bench to say, okay, just let's go back to the Chief Justice, please appoint another bench. There's nothing wrong with that. We know the judges are competent enough, but then if the issue of conflict of interest is arising, then the best thing to do before we go to the substantive issues is to pen everything down and say that go back to the drawing board and appoint a new bench. That's all.
Thank you, Mr. Roshi. My name is Gavin Roshi. I do appear for the Impeached Party, Democratic Movement Party, together with Mr. Kara. My Lord, I want to say only one short thing, and then allow Mr. Kara to conclude, not repeating what has been said this afternoon. My Lord, in 2008, I was involved in the matter which time the Vice President of the country. I appeared before Justice Paul Kihara, and he immediately told me the second respondent is my personal friend, was my classmate in law school. I recused myself. I was sent to Justice when I appeared before her, and my Lord, she said, the first applicant, a renowned professor, is my personal friend, and I recused myself. My Lord, I ended up in a lot of court settlement. I do ask Mr. Kara to conclude.
My Lord, my lady, I just make one submission that in light of the disclosure about the relationship between Justice Murima and the Speaker of the Senate, we find ourselves in a very unfortunate situation where the bench looks like it's on trial. Motions of recusal are normally very difficult to prosecute, because the question is, And this is a question that respectfully I want to pose to the bench. Will you feel comfortable? Will you appreciate the fact that so far the events that have taken place, whatever determination that you will arrive in this particular matter, when they are weighty constitutional national matters that affect the entire country, are you satisfied that they will be received well by the public? That's a question that should be in the mind of the judges as they decide whether to recuse themselves or not. Secondly, it is very clear that the only mistake here was that Justice Mourinho did not disclose a relationship between himself and Amazon, which is an act of a friendship and which is not even illegal. But disclosure, the mere fact that there was no disclosure by itself creates suspicion, apprehension in the minds of the applicant. The last question is, if Justice Mourinho decides to recuse himself, is it the entire bench that will recuse itself, or only one judge will recuse himself? Because I'm convinced that inevitably Justice Mourinho must recuse himself. Thank you so much.
By your worship and your lady, with your please name and name Safiba, as well here for the third petitioner in the consolidated petition. Your worship, by this just to put into context the Supreme Court decision in Bari and 5 others versus East African Development Bank. So your lordship, in that particular matter, I want to say that first of all it was before the Supreme Court, and notwithstanding the doctrine of necessity, the Supreme Court considered that the right to a fair hearing by an impartial tribunal was so sacrosanct that the Supreme Court did not even consider the doctrine of necessity. So I just want to read paragraph 26 where the Supreme Court says, what is undeniable is the fact that by resorting to this cause of action, the applicants are equivocally accusing this bench of lack of impartiality, fairness, and integrity. Such an accusation against a judge goes to the very core of his oath of office. Coming from a party to ongoing proceedings, such an allegation must strongly persuade the judge to recuse themselves. So that is what the Supreme Court said. So your lordship, in that particular paragraph, the Supreme Court is saying that if there is an allegation, especially because this instance is actually almost safe to that, because there was a complaint that was lodged against that bench before the Judicial Service Commission. I have heard today that the first petitioner has already lodged a petition before the Judicial Service Commission. Your lordship, I beg that you are guided by this decision in holding that the right to a fair and impartial tribunal is very clear.
Thank you, Judge. I think you should let us know about the petition which has been done, because I don't think that is aware of that.
Your lordship, I think it is in the law around it.
A petition? No, not petition. You want a complaint that was there to mislead the public. It is not there's a whole difference between a complaint and a petition. It's not to mislead the public. It is one who has said petition.
My name is Dr. Eboso, and I'm petition number 11, the consolidated petition in the court of one. As I sat as a petitioner who essentially had no issue with the sitting of the bench, because when a petitioner files a petition, there is a presumption that the bench is properly constituted, and that Kenyans elected the Constitution of 2010, and in it provided the independence of the judiciary and the conduct of the expected conduct of judges. And therefore, we as Kenyans have trust in the judiciary and the individual judges at the time when they are appointed and during the course of their performance of functions.
But as I sat, I agonized over the issues that have been raised, and at the outset, I realized that the recusal application has been made to this bench to recuse itself, or some of the judges to recuse themselves as a decision of the bench. And I agonized over whether recusal or the place of recusal proceedings in a setup like ours. And perhaps this was amplified by the back and forth that we saw with regard to the facts that were coming out. And I would wish to be persuaded by Dr. Hamima that really recusal proceedings and the kind of facts that come to light ought not really be a subject of litigation for several reasons. One, recusal proceedings are really against individual justices, and they relate to the personal conduct which really lies in the mind and conscience of the individual judge. I would give an example. Suppose we ask the bench for one of the judges to recuse themselves, and two of the justices disagree with the recusal, but the very judge who we are asking to recuse themselves. Would we then say that this bench has ruled that the judge must sit? So it's really an individual decision of the judge to reflect upon the facts that are before him, the relationship that is being alleged, because while it can't be litigation, and it should be in the interest of all the parties that the judge is not biased, such that when you make it litigious, what happens is one side will be claiming the other side must prove a point, which they are not really very materially cognizant of. And it's really just the judge who knows the actual facts of the issue. And so it really is upon the judge individually to look at themselves and ask themselves whether the facts that are being alleged constitute what would amount to a bias. And when we make it litigious like this, we actually violate the Constitution for the reason that the conduct of a judge is not meant to be subject of any proceeding before court. That is a matter that should be before JSC, that should be before other tribunals. And the Supreme Court has told us that in Bailey, that the conduct of a judge, because what judge is being alleged here, a judge is being alleged to have concealed information that they ought to have given. A judge is being alleged to have sat abused office by sitting on a particular day and whatnot. So those are things that really should not be a subject of proceeding if we really intend to proceed with this matter. Suppose this bench does not recuse itself, then how does the matter proceed in that manner? I'd like to point out that I think I've already talked about the fact that the facts relating to a recusal, the person who really knows what those facts are and the extent to which they are is the judge. And so any discussion as to whether we prove the case or not prove the case is neither here nor there as it relates to this issue. I'd like to refer the court, I don't know how we quote precedents, but I'd like to refer the court to a decision of the Supreme Court of the United States in Jewel Ridge Coal Corporation versus local number 6167, United Mine Workers of America in 1945. And there the court, the Supreme Court found that I think one of the parties was asking for the entire bench to recuse themselves. And let's say maybe 1 minute for the entire bench to recuse themselves. And the Supreme Court of the United States found that the parties' issues are not being made by the bench. And a question of recusal should be directed at the judge, and it should be the judge to make the decision whether they themselves will recuse themselves or not. It was also, again, captured in 1980 in a decision called Hanrahan versus Hampton, still at the United States Supreme Court. And in India, in 2016, Advocates on Record Association and others versus Union of India. Justice Nathan also pointed out the same. And finally, I'd like to refer the court to the fact that this is a sensitive matter, but it's also, as sensitive as it is also an urgent matter, as considered by the bench and as considered by everyone. That there is the aspect of necessity that this matter must be had. And there's also room for appeal should any person feel they are aggrieved by decisions of this court or the judges herein. And so what I would say is that I would ask that the individual justices that you look into the issues that have been raised, you look into the facts which you are familiar with them yourselves, and go home and reflect whether indeed you will have the impartiality to hear this matter. And once you make that decision, let's hear the matter and proceed. Thank you.
My words on my lady doctor with the previous matter, my name is Gamboi, Shabra Gamboi. I speak with the blessings of my senior, Mr. Ramston Mari, and Counsel of the on behalf of the 9th petitioner. My Lord, at the very outset, permit me to submit that this court has a duty, either individually or as a collegial bench, to hear and determine the matters that are presented before court. Indeed, just like any other person, you have a duty to act in the defense of the Constitution. However, matters that relate to the calling into question of the conduct or the integrity of the bench or a judge are matters that are characterized in this country with a lot of rage, as we have even seen being demonstrated in this honorable court. In other occasions, applications for recusal, my lady and my lords, are said to be a dialogue of the deaf and the bands of the blind, to the extent that the petitioners of the applicants making an application such as the one that finds itself before you, sometimes refraining from even saying the very grounds upon which they make the application, as we have seen before this court. And again, the bench on the other end, on many occasions, tends to draw conclusions of what they think the applicant is saying about their conduct or their integrity. So for that reason, the court is then called upon to reflect as to its duty to do that which is just vis-a-vis the perception, either actual or apparent, that may flow or be submitted by applicants who call to question the conduct of the court. My lady and my lords, permit me to also make a contribution with regards to the decision that has been made in the Supreme Court case of Limited. And there is something that is important that we must highlight. In this application, the Supreme Court was not called upon to adjudicate on an application for the recusal of the court. That was not the application that was lying before court. What is important that we must underscore in this case is that the court was invited to suspend or stay its proceedings in view of a complaint that has been made by the applicants before the Judicial Service Commission, so that the court ultimately ended up recusing itself, not that it had been invited to recuse itself, but because there had been a complaint that had been filed before the Judicial Service Commission. My lords, the reason why the 9th petitioner rises in support of the submissions made by counsels who have made the application is largely due to our duty as the officers of the court. And we have seen in the application, in petition number E015 of 2024, annexure marked annexure marked BNM2, which is a letter addressed to my colleague Mr. Swanya of Swanya and Company Advocates from the Judicial Service Commission, highlighting a complaint that has been made by the Deputy President of the Republic of Kenya, His Excellency Gachagua, against this honorable bench. So, my lady and my lords, as I rest, the question that begs the answer is simple. If a complaint has already been lodged against the persons of this honorable court, how will a reasonable person, or will a reasonable person out there be confident that this court, in light of the complaint that has been lodged against you by one of the petitioners, arrive at a just finding in this case? Ladies and lords, that should not to end of my submissions. I shall take the floor for the remaining minutes to my seniors to also speak some wisdom to what is the issue. Thank you.
My lady and my lords, my name is Samuel Bailey, of the 9th petition of the second court. I stand in support of the motion for recusal, and I juxtapose it in this manner. Recusal applications are tantamount to the court being on trial. It's a charge sheet for the court that it then will determine the parameters that have been set and the grounds that have been accused to find or make a finding whether they merit. And in so doing, the court will not be given an opportunity to make submissions as we agreed. It's the court that is going to now render a ruling. Then the big question that we ought to ask ourselves, whether then the court is going to rebut on the heavy submissions that have been made, because going into the second room of going to analyze what the petition is all about will mean that we as the petitioners will have faith in even opening the second chapter of the proceedings as they are going to happen. So therefore, my lord, my lady, the point we are making is kindly, there is enough evidence that has been laid before you to make a determination that indeed it is not available for the court to open the second chapter of going into the determination of the petition. I rest my case there. The balance of my time, I invite Kumari to finish up our comment.
My Lord, and already very, very brief. One, the court in determining whether the DCJ has powers to constitute a bench made a finding that the petitioner was found guilty of an offense of addressing the gathering. His lawyers, all of them, never addressed the court. The lawyers were not addressing. It is the petitioner who was addressing. You have already made a decision that the petitioner was addressing the gathering. We really have confidence to appear before him. I'm sincere when he was constantly spotted by the Supreme Court that was attacking the courts. The court decided to punish. When he appeared, all the members of the Supreme Court recused themselves. They never gave him audience. Will the deputy president have audience before when the main substantive motion comes before you? You have already made up your mind that his job is to address the public. The rationale for this matter going live and my brothers and sisters saying it's a public interest matter is because 55 million Kenyans are waiting to see the free learned judges appear in passion. It is our submission from our plant Sheria Mtani that based on that, you recuse yourself. I'll give a small analogy. When I went to pay down for a friend of mine, he was told in a dark place, those people are witches. So that something we need to, when food is being prayed for, you must close your eyes. We never closed our eyes because behind us we fear, my Lord and my lady, that these guys might destroy us. Petitioner is scared of the stage. That's all.
I will move all parties supporting the application. In that case,
I thank you, my lord, and members of the bench. I will try to be brief. My colleagues and I, that is, I think, would like to be truthful. First, we would like to begin by observing that today is the 10th day since this bench was constituted. It was constituted on the 14th of October. There were petition 522, petition 550, petition 560. Nobody ever complained at all until we came here on Monday. And even then, the complaint was a number. The petitioners appeared before my Lord Judge Ogola on the 16th of October. Orders were made in their favor. They were extremely happy. No complaint. The three judges of this bench were in the bench in 522 of 2024. No complaint. This complaint is a complaint founded on the fact that on the 18th, the Honorable the Attorney General, for the first time, also got orders. Now that is when this bench became a bad bench. It was a very good bench for as long as it gave any order to the petitioners. It became a suspicious bench when it gave an order, only an order to expedite the hearing. The Attorney General had wanted many things. They were all declined. I will address you, my lords, on the understanding that we have two petitions. There's one petition I call the Kirugoya petition. And there is another petition I will call the Nairobi petition. It is our preliminary submission that yesterday's ruling of the 23rd substantially addresses the issues raised in the Kirugoya petition, and that those issues are now, they are restituted. There is issue estoppel. There is issue estoppel, a doctrine of law that states a question that has been resolved by the court cannot be litigated afresh in the same proceedings. It is our second submission that the first limb of the Nairobi petition on recusal that speaks to how the case was handled between the 18th and the 22nd is also substantially settled by yesterday's ruling. And I think my learned friend, most of them were able to confirm that. And they complained about that. So what issue is alive? The only issue that is alive is the issue of recusal, allegedly on the grounds that I'm so happy that my lady has been spared any further unwarranted attack as regarding her standing. So I will not make any reference to that. It has been considered that it was made recklessly, without any factual basis. And I think that what an ethical advocate of the Honorable Court should do is to start by saying, I apologize to her leadership for these allegations that are contained in a document that bears my signature. But that is not for me to say. So let us proceed to the two other allegations. At one point, I was very surprised to hear a submission that said that my Lord Justice Ogola is close to his wife. How can that be? How can that possibly be a bad thing? But a further extension of that argument was equally spurious. A professional person is entitled to an independent professional existence. Be it the husband, be it the wife, be it siblings, be it children, they have independent professional, and I am shocked that that can be a ground. Another ground now is that the Honorable Justice Muruma is a friend of the Speaker of the House. The Speaker of the House was my student. I don't know whether I should recuse myself. But if I just say this with respect, I have been a law teacher for 38 years. I apologize that that's not very long. There are 3/4 of the lawyers under the age of 50 I have taught them. I don't know whether I should recuse myself each time I appear against, including the Honorable Trevor Jenda here, Senator. Will you confirm that? I confirm. Senator, the Solicitor General, the Attorney General. This is the nature of our profession. This is the nature of our profession. The Speaker is a member of the legal profession. The Honorable Justice Muruma is a member of the legal profession. How else are we to do our work? Paul Kibuki Mwete, Senior Counsel, a personal friend for many years. On the day I got married, he brought me a copper coffee dispenser. I never to do any case with him. And I always tell people, I know Paul Mwete from when I was there. He came to my wedding, he brought me a gift. It cannot possibly be. That is not how this profession works. Let me quickly say this, what I believe, we believe, is the standard. The standard is set in the case of, most important of this all, is the right case, which has been talked about, when we ask for an recusal. And I agree with Dr. Camilo when he says that no lawyer, no advocate should ever make an application for recusal lightly. Indeed, an advocate approached by a client who is making personal attacks against a judge that are baseless must return the brief to the client. That is the honorable thing to do. I have referred you to the right case, but the most important of this all is the objective test that is set in the Rawal case. And the Rawal case, which you are aware of, Rawal versus Judicial Service Commission, the court says there is no basis for a judge to automatically recuse themselves when a bare allegation is made by a party. The allegation must be substantiated. First, they now quote the Court of Appeal. Firstly, it is obvious from the above test that there is no basis for the latter elastic test propounded by Dr. Camilo, where a judge must automatically recuse himself or herself upon the making of a bare allegation of any of the parties. We have not come across any authority in support of the proposition, and Dr. John Camilo did not provide any. On the contrary, decisions abound that judges must not recuse themselves on flimsy and baseless allegations. It is our submission that a claim that the friendship that may exist between a party and a judge because they went to the same school, because they went to the same university, because they come from the same county, that is baseless. It must be demonstrated. Like was said in the case of Kaplan and Stratton versus Z Engineering Construction Limited, if disqualifications issues were to be raised, say, because a judge and a member of the bar belong to the same Rotary Club, or the same Lions Club, or the same Sports Club, there would be no end to such approaches. There would be no end. In this case, it has not been demonstrated that there is any way in which the independence of any of the judges here can be said to have been compromised. Let me say something relating to the Dye case, because I was involved in that case, again with my very good friend, the Honorable P.K. Moite, on one side, and my friend Paul Nyamodi. They were on one side, I was on the other side. I think that's why Mr. Nyamodi has now come back to my side. Because we were the successful party in that case. And that's one of my learned juniors here on the opposite side has stated, you need to understand the context of the Dye case. Because at paragraph 24, the court states this: the appellants applicants herein are seeking a stay order, from this court in the most unusual, strange, and dare we say disingenuous strategy. What have they done, my other friends? We have litigated for a very long time. Litigated in England, in the High Court, litigated in England, in the Court of Appeal, litigated in the High Court here, litigated in the Court of Appeal here, litigated in the Supreme Court, and their final card, they had made a complaint against the Supreme Court. And what they were asking the Supreme Court to do is stay proceedings as we go to prosecute the allegations we made against you. And I think the Supreme Court threw the seal at them, and that is why the decision says what it says. Now, I want to wind up by saying that if this court were to accede to this application, it would throw into disarray a critical public interest litigation when the country is in the throes of a serious constitutional crisis. That is why philosophers like Dr. Muthoni say that city is bound, as philosophers are quibbling on whether we need a bucket or a pipe to put out the fire. We are in the throes of a grave constitutional crisis. The court that we have been given to resolve this issue cannot stop sitting on the basis of the most flimsy allegations of friendship between parties, because I don't know of a single representation here that is not related to one another. If you open this door, you will have created a precedent where all a lawyer needs to do, an advocate, all he needs to do is to make a connection. To make a connection, you go to the same church, you go to the same mosque, you used to work in the same chambers, you were trained by the same pupil master. Our connections will never cease. Like they say about tort actions, there can never be an end to tort actions, and there can never be an end to the relationships we have in the legal profession. An applicant must demonstrate that because of that relationship, there is reason to believe, demonstrated by clear past behavior, past judgment, past ruling, past conduct, that a judge will be biased in any way. But ultimately, as the authorities I have cited to you state, a judge has taken a judicial oath. A judge has a judicial oath. He answers to his conscience and to his oath. Now finally I will say, because I've had the great privilege to sit as an arbitrator in numerous matters, both locally and overseas, I have never found a standard that requires that a person who has a historical connection with somebody, without demonstrating more than that, can be the basis of recusal. I will now hand over before Madam. Thank you for asking me to my learned friend, Mr.
My lords and ladies, for completeness of our record, we have 5 rounds of opposition. We also have filed a list and bundle of authorities, all dated the 22nd of October 2024. My lords and my lady, permit me to start by saying that judges, just like any other judicial officer, have a duty to sit. They sit to determine disputes. Disputes between parties who come before them. That is what makes us a country governed by the rule of law. In that duty, my lords and ladies, it is important that we ensure there is efficiency in the conduct of that very important responsibility. That is on the one hand. On the other hand, it is important that judges then guard against manipulation of processes. In the context of what we have proceedings like we have today, the manipulation of process could manifest itself in the form of forum shopping, where we say that I will file this matter before this court, and before this court. In my book, one of them will give. And that if I run into headwinds in any particular direction, then I must, as of necessity, run away from that court. My lords and my lady, this is a position that has been adjudicated, the fact that the court has a duty to sit all the way to our Supreme Court,
We have in our list and bundle of authorities provided, cited one of the cases being the case of Gladys Beausoleil versus the Judicial Service Commission and a second party. At paragraph 5 of that decision, the court says that the doctrine of duty of a judge to sit, though not profound in Kenya's jurisdiction, then there's a thing that's a mistake. Every judge has a duty to sit in a matter which they should duly sit in. Recusal should not be used to cripple a judge from sitting or to hear a matter. That duty to sit was buttressed by the fact that every judge took an oath of office to serve impartially and protect, administer, and defend the Constitution. In yet another decision, Petitioner versus the Attorney General and the Salaries and Remuneration Commission, at paragraph 61 of that decision, the court says, the court has a duty to sit on matters presented before it for resolution and should only recuse itself where circumstances permit, but not where it will create an unconstitutional moment by refusing to hear a litigant's case because the opposite party apprehends bias. In what context then should we understand that jurisprudence? Balance Melody, it must not be lost to us that when we are dealing with fundamental topical issues of conversation in a country such as Kenya, like what we are dealing with, these matters evoke emotions. Just like in our election context, whenever a party loses, it is never so easy to accept the result of that race. It is for that reason that sometimes people have all manner of aspersions cast against the court, against the independent, all other independent organs of the Constitution, because a decision has gone one way or the other, in instances not favorable to one party and favorable to another. We must appreciate that we are in an adversarial system where, as of necessity, a decision will be determined or will be made in favor of one party as against the other. That said, my lords and ladies, learned senior counsel Professor Gil Mugai has made reference to the fact that the matter that is before you, though dubbed as recusal, is a matter whose subject matter has been completely determined. There is issue festival, and that everything that has been presented before you today are issues that were contained in the ruling that the Lordship issued yesterday. As a starting point, I would make reference, my lords and ladies, to the application that was filed yesterday by our opponents. The application seeking to have this, the question is the empanelment of this bench. If you look at paragraph 1 of that application, on the grounds on the face of the application, my lords and ladies, the court was invited particularly to recuse itself. It then means that that motion for recusal was a motion that was live before this court. That motion was live between the same parties. It touched on the same issues that were presented before this court. The court pronounced itself on all those issues. What then is the business of bringing those issues through this second court application in the name of an application for recusal? My lords and my ladies, if at all, as we now see, the applicants were not satisfied with that decision, the ruling of this court, the option that was available for them was to appeal that decision. Presenting this second application does not in any way open for them a door other than for purposes of delaying these proceedings. And I would say that with tremendous respect to my line friends on the other side, and so that I am able to demonstrate, permit me to just look at the applications that have been filed and the issues that have been raised in those applications. I'll start with the application filed by my good friend, Dr. Evans Ogara. In his application dated the 21st of October 2024, he raises as ground number 1 the issues of the certification of these matters on the 18th of October. That was an issue that was before you this time. At paragraph 3, so that you understand context, he also says that on the next day, being Saturday, 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with an order of this honorable bench stating that the first and sixth respondents' application dated 18th October 2024 was coming up with parties hearing. Again, that was an issue that was before you. At paragraph 4, he talks about the subsequent reference of the matter by the Chief Justice on the 18th of October. That was an issue that was before you. Finally, he questions the unclear circumstances that led to the placement of the file of this bench on a Saturday before you without the express directions of the Chief Justice. Again, my lord and the lady, that was a matter that was before you. In the application by Mr. Njiru Negwa, again, the same thing. First ground, that the petitioners have learned that this bench sat on a Saturday, the 19th of October 2024. That was an issue that was before you. Paragraph 2 says that the petitioners were surprised by the sudden turn of events. Again, the same language used by the application, in that application, a matter that was before you. Paragraph 6 says that the petitioners are apprehensive that this honorable court has clearly demonstrated that the case for the Attorney General is more important than our petitions, yet we are raising similar issues. Again, that issue was before you and it was determined. Paragraph 8. Let us talk faster. How then do we treat all those issues that were before you? And this so that then we understand that these matters were before you, when you deliver the ruling you need to share with us this afternoon. From paragraph 73 all the way to paragraph 96, each and every of these issues were responded to. I mean, determinations were made. At paragraph 79, for instance, the court says, but backed by this sequence of events, we take great exception to the petitioner's conduct that when favorable to the petitioners, orders issued outside the normal working hours of the court raise no concern. However, when the same court acts in an instance where it has been properly moved by the other parties and likewise proceeds to deal with an application at hand in the same vein, the petitioners show their indignation. That was a finding that was made. At paragraph 96, we then go further and say that one of the senior counsels went further by intimating that an exercise akin to the radical surgery may be forthcoming, a statement which he perceived as a vague attempt at intimidating, intimidation coming from senior counsel. My lords and my ladies, what is left that you're supposed to determine again? It is an attempt to have a second bite at that which I already said. If for one moment we were to look at this application by Mr. Rebuttal, he then introduces very strange allegations which he has had to withdraw. Everybody saw his discomfort at making reference to those issues. But as we all observe, these issues around making allegations and running away from them are meant to have aspersions and indirectly intimidate the court. Permit me to say, I was making reference to paragraph 8, where they say, for instance, that The petitioners have credible information that Honorable Justice Broma is a close associate to the proposed Deputy President, one Mr. Kindiki, and that the same judge failed, refused, or neglected to disclose that fact. Really, is that an issue that a party seeking the resolution of a matter that they brought under a certificate of urgency would want to raise to be a reason for a judge to disqualify himself? What is this association that we're talking about? What evidence have we tendered that there is anything that will be considered to be either untoward or that will make it inappropriate for the judge to sit in this proceeding? In fact, we want to add in a paragraph that is sought to one of paragraph 10, say that this close association between Honorable Justice Brima and the proposed nominee for the position of Deputy President of the Republic of Kenya might have caused this court to convene and sit on Saturday with a view of assisting one party in this proceedings. Is that not outrageous, to say the least? We go on to say, at paragraph 11, that the petitioners are in possession of credible information that Mr. Justice Ogola, who is the presiding judge in this proceedings, is conflicted as his spouse is a member of the Kenya Watch Board, having been appointed by the President of the Republic of Kenya, who has in haste nominated Mr. Kindiki as his principal assistant. Allow me to pause on that allegation for one moment. What evidence do they present? Absolutely none. Today, let me take one step back. Yesterday, when the court was rising, we did put them on notice that we would seek to cross-examine the deponents of the affidavits that contain these very unfortunate affirmatives. To try and cure that, they then introduced a gazette notice. In that gazette notice, my lords and my lady, they then seek to say, gazette notices speak for themselves. The gazette notice says, that is gazette notice number 7515, in the exercise of powers conferred by those provisions of the law, I appoint Rose Ombaki and Florence Auma Olosh to be members of the Kenya Water Towers Agency Board for a period of 3 years with effect from 9th of June 2023. The appointments by Gazette Notice number this and this are thereby revoked. That Gazette Notice is signed by the Cabinet Secretary for Environment, Climate Change and Forestry, Sultan Tuya. At what point, my lords and my lady, does then, at what point does it become that it is His Excellency the President who appointed I have to use the words. His spouse is a member of the Kenya Water Towers Board, having been appointed by the President of the Republic of Kenya. When you come with such outright lies, what are we trying to do? To the court, to the individual members of the court, to the parties before these proceedings? Is it a case of saying that you will get out of that court by all means necessary, including by peddling lies? My lords and my lady, these are the grounds upon which you're being asked to recuse yourselves. I've also seen there was, just give me 1 second, there was a very equally strange affirmation about Lady Justice Florence Gabi. That Lady Justice Mugabe is conflicted as such and that she could. There is an amendment to the effect that Lady Justice Frida Mugambi was a student yes, that Lady Justice Mugambi is convicted as such she could recuse herself as she was Mr. Kiburi Kindiki's LLM student at Moi University, a crucial issue that she failed, refused, and or failed to disclose to the parties at the inception of the trial. My lords and my lady, the qualifications of our judges are no secret because they're state officers. You only need to go to the website of the Judicial Service Commission and find the truth. My lords and my lady, when we saw this very strange apartment, we took the trouble to go to the website of the Judicial Service Commission and established that Her Ladyship Justice Wilfreda Mugambi got her LLM from Birmingham University in the UK. How then do we want to bring these lies and feed them to the people of Kenya, feed them to the court, and expect that on account of such flimsy, concocted material, then the court should recuse itself? Again, is it a case of us saying, by all means necessary, we shall not appear before that court? My lords, my lady, there are clear standards and thresholds that have been established both by the regulations governing the conduct of the court and even case law. That, my lords and my lady, first, you exercise your conscience as to what should make you recuse yourself. Number two, in the event that a party is raising a concern as to your recusal, then it must be a substantial issue. It must be a substantial question that has been brought before you. It cannot be that every frivolous allegation that is brought before the court should make the court down its tools. That, my lords and my lady, will amount or will create or facilitate an environment where foreign shopping will be right. We just need to mention anything that I went to school with so-and-so, that I go to church with so-and-so, that I travel with so-and-so, and that should be a reason for them to recuse themselves. That certainly cannot be the standard. Now, once lady, I'll refer you to one of the decisions in our family list authorities. That's the UNAD, Expert CJL 1986, 60 AL JR 528, where the court had this to say, that although it is important that justice must be seen to be done, it is equally important that judicial officers discharge their duty and do not, by acceding too readily to suggestions and appearances of bias, encourage parties to believe that by seeking the disqualification of a judge, they will have their case tried by someone thought to be more likely to decide the case in their favor. My lords, my lady, the question that we'll be asking ourselves is, what is that fundamental question that has been presented? And why this is an important concern is because sometimes such frivolous grounds are raised purely to embarrass the court. On this occasion, I have absolutely no doubt in my mind that the net effect of what these allegations have done is an attempt at embarrassing the court. My lords and my lady, we urge that you resist that temptation to ask the court to recuse itself on the basis of such flimsy, baseless allegations. Just to speak to the fact that this is an attempt at embarrassing, if not intimidating the court. Our friends for the applicant have also indicated that they have simultaneously sent or lodged a complaint with the Judicial Service Commission. Following from the submissions that I made reference to in the ruling about intimidating the court with the radical surgery, again, going to the question of presenting this application for recusal after the one yesterday, and now going to lodge a complaint to the Judicial Service Commission, is that not an attempt at intimidating the court? My lords and my lady, I would not ask for an answer. That is an issue that anybody, any reasonable person out there would be able to make an decision or a determination about in their own space. My lords, my lady, is it also possible that this could be one of those issues that the applicants or the respondents have complained as being delayed? Because we raised concerns yesterday. We are raising them again today. We have spent a whole afternoon arguing about issues that on the one hand have been completely determined by this court. The second part of those issues are issues that did not have any grounding, any material or in support whatsoever. Are those not meant to delay these proceedings by any means necessary? Having taken cognizance of the fact that we came to you, both parties, under certificate of urgency, these matters must be treated with the urgency with which we came. And so we ask, my lords and ladies, that you dismiss that application with the content it deserves. May I now invite another friend, Mr. Yamoni, to speak to a few of the main issues.
My lords, my lady, I wish to commence my submission in opposition to the application for refusal before you receive by tendering an unreserved apology on behalf of the members of the bar who have been urging and opposing the application before you today. Despite my relatively few years at the bar, I appreciate that prosecuting an application for recusal, and I have some experience in prosecuting applications for recusal, and it will become apparent in a moment, are not easy applications to prosecute. But the reason that I offer the unreserved apology is that it is my humble and respectful position that however difficult they are, there is no need for them to be prosecuted in as bad-natured a manner as these applications have been prosecuted before. And for that, I am sorry. The only mistake that your lordships and my lady have made is to serve your nation as judges of the High Court and choose to sit in this matter. We have been told that there is no difference between this matter and any other matter, and I affirm that there is no difference. It is a matter just like any other matter. I wish to start by perhaps completing a submission that was made and not completed by my learned colleague, Mr. Bumbo, who submitted a few moments before. The issue of your recusal was not just an issue in the grounds, in the notice of motion that you determined here.
Babe, let's go for a run.
Katika kipindi tunakuletea wasanii.
What's up my guys? I go by the name Rejoinders.
Eti nikipita kwa macho unanipimia, na kama sina pesa unguwezi nipimia. Hapa Shensta the poet
Goma moto.
By this court. Because again, in my few years at the bar, in my relatively few years at the bar, seldom have I come across an application dated today, had on the same day, and a substantive ruling running to in excess of 40 pages delivered the next day. So that issue has been dealt with conclusive by the court in yesterday's ruling. I wish to then focus on the authority that was cited in the Dairy matter. And again, in my relatively few years at the bar, I have had the pleasure, the privilege of arguing several matters in the Supreme Court. Many of them are precedent setting. Dairy is one of them, and I did not know Dairy would be one of them. But the ruling of the Supreme Court delivered in the Dairy matter on the 11th of October this year has confounded me for a few reasons.
I am still trying to understand what the meaning of that decision is. And I will share with your lordships some of the issues I have with that decision. And hopefully your reading will help me understand. The decision in Dari is not available as an authority for what the petitioner cited to be. And one of the issues that confound me with that Dari decision, and if my lords, my lady, when you retire to consider your ruling in this matter, to take a moment and find the original script or the original volume, not the one reported in Kenya, but the one that is on the Supreme Court's website and was circulated to us on the 11th of this month. You will find that at the beginning of that ruling, Paul Nyamode, yours truly, is referred to as senior counsel. Now, I cannot insist that I'm senior counsel because the Supreme Court referred to me as senior counsel in that ruling. That is the first issue that confounded me with that ruling. The second issue is that there was no application for the learned judges of the Supreme Court to recuse themselves. There being no application for the learned judges of the Supreme Court to recuse themselves, learned judges of the Supreme Court did not then have the benefit of argument from counsel for either of the parties as to whether or not they should recuse themselves or not. And if you look at that Dari decision, you will not find anywhere.
Perhaps you are disparaging the Supreme Court.
I'm speaking about the decision. If you look at that decision, in the disposition at the end of that decision, the Supreme Court does not declare that it has recused itself. So if you were to extract the order, the issue of recusal would be absent. So in respect of that, I wish to submit that the issue of recusal in the wrong matter is very limited. Having not been an issue before court, and having not been an issue that parties submitted to, it then cannot become an authority, cannot then be cited as an authority for recusal. The second issue about the Dari decision, and the second reason why I say that Dari is distinguishable, is as follows. And like in this matter, where the issues, where the facts upon which the application for recusal are based have been judicially considered, and a decision given, and that decision is contained between paragraph 74 and paragraph 96 in the decision we delivered in this matter yesterday. In Dari, the issues that the Supreme Court then Suomoto relied on to recuse themselves had not received any judicial consideration. Yes, those facts went on to become a complaint before the Judicial Service Commission. In the same way, the facts that form the basis of your determination between paragraph 74 and 94 of your decision have gone on to the Judicial Service Commission as a complaint. But those facts now forming your decision, the proper thing to do is not to complain to the JSC, but to appeal. That is the proper thing to do. So to then file a complaint before the JSC and then reach for Dari out of context, you know. And for those reasons, that Dari decision is distinguishable. And I urge you to distinguish. The second decision that I wish to urge you to distinguish is the decision that was cited by my good and learned friend, Mr. Thomas Shari, the Navin Friendly Kerry versus Burunga Limited decision. And the reason I want to urge you to distinguish that decision is as follows. A true reading of paragraph 5 and paragraph 6 of that decision show that the arbitration commenced on the 31st of March 2021. The traditional way in which the judge then took offense to took place on the 18th of February 2022. So it is clear, and that is clear from a reasonable process of deduction, that the traditional wedding then took place during the currency of the arbitration. That is not the case here. The screen grab that has been produced of Mr. Justice Mlima and the Speaker of the Senate, if we are to believe that it is true, is dated the 9th of October 2021, more than 3 years ago. So this decision is distinguishable on the facts. Judges do not live in glorious isolation. Your appointment as a judge does not mean that you cannot invite your friends to a wedding. On the 9th of October 2020,
guys, I go by the name.
And it is those orders relate the petitioner's rights to a fair hearing under Article 50 of the Constitution. These submissions are without foundation and wholly without that this argument was made by my learned colleagues. You have a duty. By my learned colleagues, you have a duty.
My lady and my lords, hot on the heels of submissions by Mr. Manyamodi, now Senior Counsel, I wish to state as follows. My lady and my lords, the serpentine and similar submissions by Ndegwa and by my learned friend, Senior Counsel John Aminwa, just in case he says I was breastfeeding, must be faulted for two reasons, my lord. My lord, one, Mr. Aminwa refers to the Richard Nixon impeachment as the first impeachment, when it is clear, my lord, that in the US, the first impeachment was that of President Andrew Johnson in 1868, coming after he dismissed a war general, Mr. Stanton. The Richard Nixon impeachment was the second impeachment coming in 1974, because you said that was the first impeachment, and Nixon resigned. It's just important for context, my lord. My lord, it's just important for context that in the second impeachment of Richard Nixon, he resigned on the 8th of August, 1974, and thereafter the next president, Ford, took over for the next 3 years. I think it was striking a lot to refer to this impeachment because of the case of he resigned, I said he resigned. After the Watergate scandal, the impeachment commenced and he resigned. And that is what gentlemen do when an impeachment is imminent. My lord, I want to connect this to my submissions that we shall be relying on the political question doctrine and the finality of impeachments by Senate in a comparative context. My lord, let me submit that in Gladys Bolshoi versus JSC, this court set out a threshold for recusal. And the threshold is, my lords, that a recusal application must be made in good faith. And if the court listens to the histrionic from the petitioners, the court will note that the application is not made in good faith. It is tied to an intention to extend ex parte orders that advantage the petitioners. The petitioners are intent, my lords and my lady, on scattering the bench and scaring them away from sitting so that they can have suspended and irregular orders issued in Kerugoya by Justice Richard Mongo. Then they went to the second act of actually filing a complaint to the Judicial Service Commission submitted to Isaac Wamasa and duly acknowledged, so this court can be scared away and done away. My Lord, when the scheme is not complete, my Lord, Judge Ibrahim at page 31 of the Gladys Boss Sholay position stated, my Lord, that the threshold for impeachments cannot, of the recusal cannot be solo, and only allegation made of any form of bias must be proved through credible evidence. And then I dive straight to section 11 of the Oaths and Statutory Declarations Act. The petitioner's affidavit. The petitioner made a false affidavit through a document pursuant to factual issues that the petitioner then attempted to withdraw in court. My Lord, that not only invites a criminal sanction under section 11, but what is more important, my Lord, is that false affidavits are no affidavits and must be struck off. Because the penultimate paragraph in an affidavit, my Lord, swears to the truthfulness of the whole document. Where therefore, my Lords, any part of that document is false, the affidavit must be struck off. My Lord, we further submit that to both applications, my Lord, that are before you, parties having been unable to meet a threshold that would warrant the disqualification of all the judges sitting in this bench, that the applications must fail. I have no doubt, my Lords, that we have cited relevant authority. We have cited the authority in Jackson, Malali, and others, a court of appeal decision on the threshold that learned friend Senior Counsel Hamina wants to lower. He invites the court that at every mention of the possibility of bias, that the court downs its rules. My Lord, if that were the case, no judicial proceeding will be conducted in this country. And learned friend, Senior Counsel Professor Gideon, I told you of the number of students that he has taught. I think I've taught more young counsel in this room. And it would be impossible, my Lord, if association by way of sharing a classroom or teaching were a threshold or a test for bias, that judges would accuse themselves, my Lord. No judge, my Lord, would sit on any bench to hear any case, because we are all extracted from the same academic background and a due trend. Unless my Lord friends are saying that. Yes, my Lord, in response to the suggestion that the Honorable Justice Lima attended a wedding of the Speaker of the Senate. My Lord, the Speaker attended the wedding of the Honorable Justice. My Lord, the Honorable Justice Kingi, Amason Kingi, is a peripheral party in the proceedings. Indeed, if we look at the proceedings, my Lord, what we have in the proceedings is not Amason Kingi as a party in his name. It is the office of the Speaker as a corporate office who is a defendant or a respondent in these matters. But number two, my Lords, the Honorable Speaker Kingi merely presided over the proceedings in Senate and is not a voting member in the sitting of Senate that led to the impeachment of the former Deputy President. My Lord, the Honorable Kingi has not taken part in the appointment of this bench in any form. But clearly, the petitioners are clutching on straws, and every attempt at ensuring that this court does not proceed seems to be falling by the wayside. I urge the court and I invite the court to consider this application for recusal as another attempt to frustrate the processes of this court and to ensure, my Lord, that this bench does not proceed to dispense justice that ought to be dispensed expeditiously in line with the Constitution. I pray, my Lord. And my Lord, on the appointments of judges, my Lord, clearly, if peradventure the argument on conflict extended to who appoints, my Lord, the President appoints all judges, and is a party. I think they should have added that ground, perhaps, because the President appoints all judges. But that cannot be a cause for a party seeking a recusal, my Lord, because the President, in performing a constitutional mandate, just like, my Lord, the CS environment Solpantria exercised has titled mandate in appointing Florence as a board member, my Lord, cannot be a cause or a basis for seeking or asking for consent. My Lord, soon parties will then apply for recusal on the basis, my Lord, that two judges or a litigant and a judge belong to the same community. Thank you, my Lord.
Sorry, none of them is quite near me, so I think I will. Thank you. Thank you very much. Just a brief rejoinder to the application, and especially in view of what has actually been disclosed after the arguments. And my lady and my lords, I would be urging you kindly to actually go through these voluminous decisions we have given to you, because part of what some parties are submitting are the saying it falls on all fours in relation to the matter before you is nothing far from the truth. And the example that has been cited is that of Virunga Limited, where it has actually been shown that that authority cited does not in any way relate to what is before you in terms of facts and the applicable law. It has been clearly demonstrated that here disclosure was necessary because...
Just a minute. We wish to adjourn for 10 minutes. You can take a break for 10 minutes.
Katika kipindi tunakuletea wasanii.
What's up my guys? I go by the name Rejoinders.
Eti nikipita kwa macho na nipimia, na kama sina pesa ungewezi nipimia hapa Shenster the Poet manze.
Ngoma moto moto.
If you wanna show some love but don't fake it too. Enda kumenya mawazo mako. Na niende shida.
Vichekesho, tukitangaza mahojiano moto moto, stori za wasanii pamoja na talanta za wasanii. pia kwenye kipindi utabambika, utajijenga, utaelimika, utakuza talanta yako.
My name is Rebecca Mutie. I'm a model and I'm Afri Kenya. I'm a student. Napenda kusikiza kipindi cha Bonga na Katoni kila Jumatatu kuanzia saa 9.
In the application by Mr. Njiru Ndegwa, again the same thing. First ground, that the petitioners have learned that this bench sat on a Saturday, the 19th of October 2024. That was an issue that was before you. Paragraph 3 says that the petitioners were surprised by the sudden turn of events. Again, the same language used by the other application. In the other application, a matter that was before you. Paragraph 6, it says that the petitioners are apprehensive that this honorable court has clearly demonstrated that the case for the Attorney General is more important than our petition, yet they are raising similar issues. Again, that issue was before you and it was determined. Paragraph 8. Let me stop first there. How then do you treat all those issues that were before you? And if just so that then we understand that these matters were before you, when you delivered your ruling which was shared with us this afternoon, from paragraph 73 all the way to paragraph 96, each and every of these issues were responded to. I mean, determinations were made. At paragraph 79, for instance, the court says that backed by this sequence of events, we take great exception to the petitioner's conduct that when favorable to the petitioners, orders issued outside the normal working hours of the court raise no concern. However, when the same court acts in an instance where it has been properly moved by the other parties and likewise proceeds to deal with an application at hand in the same vein, the petitioners show their indignation. That was a finding that was made. At paragraph 96, you even go further to say that one of the senior counsels went further by intimating that an exercise akin to the radical surgery may be forthcoming, a statement which we perceive as a veiled attempt at intimidation coming from senior counsel. My lords and my ladies, what is left that you're supposed to determine again? It is an attempt to have a second bite at that which has already sailed. If for one moment we were to look at this application by Mr. Ndegwa Njiru, he then introduces very strange allegations which he has had to withdraw. Everybody saw his discomfort at making reference to those issues. But as we all observed, these issues around making allegations and running away from them are meant to cast aspersions and indirectly intimidate the court. Permit me to say, to make reference to paragraph 8, where they say, for instance, that the petitioners have credible information that Honorable Justice Mima is a close associate to the proposed Deputy President, Mr. Kithure Kindiki, and that the same judge failed, refused, or neglected to disclose that fact. Really, is that an issue that a party seeking the resolution of a matter that they brought under a certificate of urgency would want to raise to be a reason for a judge to disqualify himself? What is this association that we're talking about? What evidence have we tendered that there is anything that will be considered to be either untoward or that will make it inappropriate for the judge to sit in these proceedings? In fact, they go on to add, in a paragraph that they sought to, one of the paragraphs, paragraph 10, say that this close association between Honorable Justice Mrima and the proposed nominee for the position of Deputy President of the Republic of Kenya might have caused this court to convene and sit on a Saturday with a view of assisting one party in these proceedings. Is that not outrageous, to say the least? We go on to say, at paragraph 11,
that the petitioners are in possession of credible information that Mr. Justice Ogola, who is the presiding judge in these proceedings, is conflicted as his spouse is a member of the Kenya Water Board, having been appointed by the President of the Republic of Kenya, who has in haste nominated Mr. Kithure Kindiki as his principal assistant. Allow me to pause on that allegation for one moment. What evidence do they present? Absolutely none. Today, let me take one step back. Yesterday, when the court was rising, we did put them on notice that we would seek to cross-examine the deponents of the affidavits that contained these very unfortunate averments. To try and cure that, they then introduced a gazette notice. In that gazette notice, my lords and my lady, they then seek to say, gazette notices speak for themselves. The gazette notice says, that is gazette notice number 7515, in the exercise of powers conferred by those provisions of the law, I appoint Rose Ombaki and Florence Auma Oluoch to be members of the Kenya Water Towers Agency Board for a period of 3 years with effect from 9th of June 2023. The appointments by Gazette Notice number this and this are thereby revoked. That Gazette Notice is signed by the Cabinet Secretary for Environment, Climate Change and Forestry, Soipan Tuya. At what point, my lords and my lady, does it become that it is His Excellency the President who appointed I want to use the words his spouse is a member of the Kenya Water Towers Board, having been appointed by the President of the Republic of Kenya. When we come with such outright lies, what are we trying to do to the court, to the individual members of the court, to the parties before these proceedings? Is it a case of saying that we will get out of that court by all means necessary, including by peddling lies? My lords and my lady, these are the grounds upon which you're being asked to recuse yourselves. I've also seen there was, just give me 1 second, there was a very equally strange averment about Lady Justice Frida Mugambi. Paragraph 69. Okay, let me just get that. That Lady Justice Mugambi is conflicted as such as she could. Wait a minute. It's not this one. But there is an averment to the effect that Lady Justice Frida Mugambi was a student. Okay. Yes. That Lady Justice Mugambi is conflicted as such she could recuse herself as she was Mr. Kithure Kindiki's LLM student at Moi University, a crucial issue that she failed, refused, and or failed to disclose to the parties at the inception of the trial. My lords and my lady, the qualifications of our judges are no secret because they're state officers. You only need to go to the website of the Judicial Service Commission and you find the truth. My lords and my lady, when we saw these very straight averments, we took the trouble to go to the website of the Judicial Service Commission and established that Her Ladyship Justice Winfrida Mugambi got her LLM from Birmingham University in the UK. How then do we want to bring these lies and feed them to the people of Kenya, feed them to the court, and expect that on account of such flimsy, concocted material, then the court should recuse itself? Again, is it a case of us saying, by all means necessary, we shall not appear before that court? My lords, my ladies, there are clear standards and thresholds that have been established both by the regulations governing the conduct of the courts and even case law. But, my lords and my lady, first, you exercise your conscience as to what should make you recuse yourself. Number two, in the event that a party is raising a concern as to your recusal, then it must be a substantial issue. It must be a substantial question that has been brought before you. It cannot be that every frivolous allegation that is brought before the court should make the court down its tools. That, my lords and my lady, will amount or will create or facilitate an environment where forum shopping will be rife. We just need to mention anything, that I went to school with so-and-so, that I go to church with so-and-so, that I travel with so-and-so, and that should be a reason for them to recuse themselves. That certainly cannot be the standard. My last lady, I would refer you to one of the decisions in our bundle and list of authorities, that's UNAD, ex parte CJL 1986, 60 AL JR 528, where the court had this to say, that although it is important that justice must be seen to be done, it is equally important that judicial officers discharge their duty and do not, by acceding too readily to suggestions and appearances of bias, encourage parties to believe that by seeking the disqualification of a judge, they will have their case tried by someone thought to be more likely to decide the case in their favor. My lords, my lady, the question that we'll be asking ourselves is, what is that fundamental question that has been presented? And why this is an important concern is because sometimes such frivolous grounds are raised purely to embarrass the court. On this occasion, I have absolutely no doubt in my mind that the net effect of what these allegations have done is an attempt at embarrassing the court. My lords and my lady, we urge that you resist that invite. You resist that temptation to ask the court to recuse itself on the basis of such flimsy, baseless allegations. Just to further speak to the fact that this is an attempt at embarrassing, if not intimidating, the court. Our friends for the applicant have also indicated that we have simultaneously sent or lodged a complaint with the Judicial Service Commission. Following from the submissions that I made reference to in the ruling about intimidating the court with radical surgery, again going to the question of presenting this application for recusal after the one yesterday, and now going to lodge a complaint to the Judicial Service Commission, is that not an attempt at intimidating the court? My lords and my lady, I will not ask for an answer. That is an issue that anybody, any reasonable person out there would be able to make an indication or a determination about in their own space. My lords and my lady, is it also possible that this could be one of those issues that the applicants, or rather the respondents, have complained of as being a delaying tactic? Because we raised concerns yesterday. We are raising them again today. We have spent a whole afternoon arguing about issues that on the one hand had been completely determined by this court. The second part of those issues are issues that did not have any grounding, any material or in support whatsoever. Are those not meant to delay these proceedings by any means necessary? Having taken cognizance of the fact that we came to you, both parties, under certificate of urgency. These matters must be treated with the urgency with which we came. And so we ask, my lords and my lady, that you dismiss that application with the contempt it deserves. May I now invite my learned friend, Mr. Yamodi, to speak to a few of the remaining issues. My lord. My lords, my lady, I wish to commence my submissions in opposition to the application for recusal before you this evening by tendering an unreserved apology on behalf of the members of the bar who have been urging and opposing the application before you today. Despite my relatively few years at the bar, I appreciate that prosecuting an application for recusal, and I have some experience in prosecuting applications for recusal, and it will become apparent in a moment, are not easy applications to prosecute. But the reason that I offer the unreserved apology is that it is my humble and respectful position that however difficult they are, there is no need for them to be prosecuted in as bad-natured a manner as these applications have been prosecuted before you. And for that, I am sorry. The only mistake that your lordships and my lady have made is to serve your nation as judges of the High Court and choose to sit in this matter. We have been told that there is no difference between this matter and any other matter, and I affirm that there is no difference. It is a matter just like any other matter. I wish to start by perhaps completing a submission that was made and not completed by my learned colleague Mr. Gumbo, who submitted a few moments before. The issue of your recusal was not just an issue in the grounds, in the notice of motion that you determined yesterday, but it was contained in prayer 5 in that notice of motion. And I do not understand why the petitioners complain of bias or any improper treatment by this court. Because again, in my few years at the bar, in my relatively few years at the bar, seldom have I come across an application dated today, had on the same day, and a substantive ruling running to in excess of 40 pages delivered the next day. So that issue has been dealt with conclusively by the court in yesterday's ruling. I wish to then focus on the authority that was cited in the Dari matter. And again, in my relatively few years at the bar, I have had the privilege of arguing several matters in the Supreme Court. Many of them are precedent setting. Dari is one of them, and I did not know Dari would be one of them. But the ruling of the Supreme Court delivered in the Dari matter on the 11th of October this year has confounded me for a few reasons. I am still trying to understand what the meaning of that decision is, and I will share with your lordships some of the issues I have with that decision, and hopefully in your ruling you will help me understand them. The decision in Dari is not available as an authority for what the petitioners cite it to be. And one of the issues that confound me with that Dari decision, and if my lords, my lady, when you retire to consider your ruling in this matter, you take a moment and find the original script or the original version, not the one reported in KLR, but the one that is on the Supreme Court's website and was circulated to us on the 11th of this month. You will find that at the beginning of that ruling, Paul Yamodi, yours truly, is referred to as senior counsel. Now, I cannot insist that I'm senior counsel because the Supreme Court referred to me as senior counsel in that ruling. That is the first issue that confounded me with that ruling. The second issue is that there was no application for the learned judges of the Supreme Court to recuse themselves. There being no application for the learned judges of the Supreme Court to recuse themselves, learned judges of the Supreme Court did not then have the benefit of argument from counsel for either of the parties as to whether or not they should recuse themselves or not. And if you look at that very decision, you will not find anywhere.
Perhaps you are disparaging the Supreme Court.
I'm speaking about their decision. If you look at that decision, in the disposition at the end of that decision, the Supreme Court does not declare that it has recused itself. So if you were to extract the order, the issue of recusal would be absent. So in respect of that, I wish to submit that the issue of recusal in the very matter is then obiter. Having not been an issue before court, and having not been an issue that parties submitted to, it then cannot become an authority. It cannot then be cited as an authority for recusal. The second issue about the Dari decision, and the second reason why I say that Dari is distinguishable, is as follows. And like in this matter, where the issues, where the facts upon which the application for recusal are based have been judicially considered and a decision given, and that decision is contained between paragraph 74 and paragraph 96 in the decision we delivered in this matter yesterday. In Dari, the issues that the Supreme Court then suo moto relied on to recuse themselves had not received any judicial consideration. Yes, those facts went on to become a complaint before the Judicial Service Commission. In the same way, the facts that form the basis of your determination between paragraph 74 and 94 of your decision have gone on to the Judicial Service Commission as a complaint. But those facts now forming your decision, the proper thing to do is not to complain to the JSC but to appeal. That is the proper thing to do. So to then file a complaint before the JSC and then reach for Dari out of context is wrong. And for those reasons, that Dari decision is distinguishable. And I urge you to distinguish it. The second decision that I wish to urge you to distinguish is the decision that was cited by my good and learned friend Mr. Tom Macharia, the Navin Premji Kerry versus Virunga Limited decision. And the reason I want to urge you to distinguish that decision is as follows. A true reading of paragraph 5 and paragraph 6 of that decision show that the arbitration commenced on the 31st of March 2021. The traditional wedding which the judge then took offense to took place on the 18th of February 2022. So it is clear, and that is clear from a reasonable process of deduction, that the traditional wedding then took place during the currency of the arbitration. That is not the case here. The screen graph that has been produced of Mr. Justice Mrima and the Speaker of the Senate, if we are to believe that it is true, is dated the 9th of October 2021, more than 3 years ago. So this decision is distinguishable on the facts. Judges do not live in glorious isolation. Your appointment as a judge does not mean that you cannot invite your friends to a wedding. On the 9th of October 2021, Mr. Justice Mrima did not know that he would have to go through the torment of sitting on this bench. In respect of the Manchester Outfitters decision, I also submit that that decision is distinguishable for the following reason. Mr. Justice Laka had been an advocate for one of the parties. Again, in an advocate-client relationship, the client pays the advocate fees.
And that relationship is not at play here. And for those reasons, I urge you to distinguish that decision. There are two pieces or two annexures that we wish to make a specific submission on. And that annexure is the screen grab by learned senior counsel Ahmed Nasir as to what would take or what is going to happen in this matter. Those are electronic evidence. And those are electronic evidence I submit within the meaning of section 106B of the Evidence Act. In the absence of a certificate required by section 106B of the Evidence Act, that evidence is not admissible. It has been submitted by those who have submitted before me in opposition of the application that the petitioners are guilty of forum shopping. I wish to persuade you whilst on my feet this evening that this application is a further attempt at forum shopping. My lords, my lady, you will not, because you are seized with petition number 522 of 2024, that on the eve of the impeachment hearing, the petitioners insisted at an hour not too different from this that you hear their application for conservatory orders. The application was heard, and you, with exceptional dispatch, delivered the ruling the next morning at 8:30 in the morning. My lords, my ladies, after the ruling, the learned counsel who were in court for the petitioners engaged you in a lengthy submission, which appears to be their stock in trade, on a request for leave to amend that petition. And the requirement or the request that they wanted, or the reason why they wanted leave, was they envisaged that perhaps after the impeachment proceedings in the Senate, there may have been need to have recourse to court and seek certain orders. But what did the petitioner do? The petitioner, and we are told that he was unwell, as he was unwell, issued instructions for this petition to be filed, for petition 565 to be filed, and conveniently this petition did not come to this bench. This petition went before another court, and surprise, surprise, before that court they got their orders. And it is those orders that they seek to defend here today. A request for you to recuse yourself is in furtherance of their attempt to foreign shop. And my lords, my ladies, as I take my seat, I urge you to bear in mind the finding that you have already made about these petitioners. Paragraph 98 of your decision and paragraph 99 of your decision rendered this morning or rendered yesterday, which with your permission, I ask to read. Counsel also insinuated that this bench is part of a conspiracy to violate the petitioner's rights to a fair hearing under Article 50 of the Constitution. These submissions are without foundation and wholly without merit. The court has not issued any rulings or directions that would suggest such an intent. It is apparent that this argument was made for the gallery, and we find it unnecessary to address it further. This is in furtherance of that disposition of the petitioners. This is a hot on the heels of submissions by Mr. Manyamodi, now senior counsel,
wish to state as follows. My lady and my lords, the serpentine and similar submissions by Ndegwa and by my learned friend, Senior Counsel John Aminwa, just in case he says I was breastfeeding, must be faulted for two reasons, my lord. My lord, one, Mr. Aminwa refers to the Richard Nixon impeachment as the first impeachment, when it is clear, my lord, that in the U.S., the first impeachment was that of President Andrew Johnson in 1868, coming after he dismissed a war general, Mr. Stanton. The Richard Nixon impeachment was the second impeachment coming in 1974, because you said that was the first impeachment, and Nixon resigned. It's just important for context, my lord. It's just important for context that in the second impeachment of Richard Nixon, he resigned on the 8th of August, 1974, and thereafter the next president, Ford, took over for the next 3 years. I think it was right, my lord, to refer to this impeachment because of the case of he resigned, I said he resigned. After the Watergate scandal, the impeachment commenced and he resigned. And that is what gentlemen do when an impeachment is imminent. My lord, I want to connect this to my submissions that we shall be relying on the political question doctrine and the finality of impeachments by Senate in a comparative context. My lord, let me submit that in Gladys Bolshoi versus JSC, this court set out a threshold that a recusal application must be made in good faith. And if the court listens to the histrionic from the petitioners, the courts will note that the application is not made in good faith. It is tied to an intention to extend ex parte orders that advantage the petitioners. The petitioners are intent, my lords and my lady, on scuttling the bench and scaring them away from sitting so that they can have open-ended and irregular orders issued in Kerugoya by Justice Richard Mongo. Then they went to the second act of actually filing a complaint to the Judicial Service Commission submitted to Isaac Omasa and Julia Court, so this court can be scared away and done away. My lord, when the scheme is not complete, my lord, Judge Ibrahim had placed at one of the Gladys Bolshoi position, stated, my lord, that the threshold for impeachments cannot, of the recusal cannot be solo, and any allegation made of any form of bias must be proved through credible evidence. And then I dive straight to section 11 of the Oaths and Statutory Declarations Act. The petitioner's affidavit. The petitioner made a false affidavit through a document pursuant to factual issues that the petitioner then attempted to withdraw in court. My lord, that not only invites a criminal sanction under section 11, but what is more important, my lord, is that false affidavits are no affidavits and must be struck off. Because the penultimate paragraph in an affidavit, my lord, swears to the truthfulness of the whole document. Where therefore, my lords, any part of that document is false, the affidavit must be struck off. My Lord, we further submit that to both applications, my Lord, that are before you, parties having been unable to meet a threshold that would warrant the disqualification of all the judges sitting in this bench, that the applications must fail. I have no doubt, my lords, that we have cited relevant authority. We have cited the authority in Jackson, Malawi, and others, a court of appeal position on the threshold that learned friend Senior Counsel Hamina wants to lower. He invites the court that at every mention of the possibility of bias, that the court downs its rules. My Lord, if that were the case, no judicial proceeding will be conducted in this country. And learned friend, Senior Counsel, Professor Gideon, I told you of the number of students that he has taught. I think I've taught more young counsel in this room. And it would be impossible, my Lord, if association by way of sharing a classroom or teaching were a threshold or a test for bias, that judges would accuse themselves, my Lord. No judge, my Lord, would sit on any bench to hear any case, because we are all extracted from the same academic background and a dual trend. Unless my Lord friends are saying that. Yes, my Lord, in response to the suggestion that the Honorable Justice Lima attended a wedding of the Speaker of the Senate, my Lord, the Speaker attended the wedding of the Honorable Justice, my Lord, the Honorable Justice Amason Kingi, is a peripheral party in the proceedings. Indeed, if we look at the proceedings, my Lord, what we have in the proceedings is not Amason Kingi as a party in his name. It is the office of the Speaker as a corporate office who is a defendant or a respondent in these matters. But number two, my lords, the Honorable Speaker Kingi merely presided over the proceedings in Senate and was not a voting member in the sitting of Senate that led to the impeachment of the former Deputy President. My Lord, the Honorable Kingi has not taken part in the appointment of this bench in any form. But clearly, the petitioners are clutching on straws, and every attempt at ensuring that this court does not proceed seems to be falling by the wayside. I ask the court and I invite the court to consider this application for recusal as another attempt to frustrate the processes of this court and to ensure, my Lord, that this bench does not proceed to dispense justice that ought to be dispensed expeditiously in line with the Constitution. I pray, my Lord. And my Lord, on the appointments of judges, my Lord, clearly, if peradventure the argument on conflict extended to who appoints, my Lord, the President appoints all judges, and is a party. I think they should have added that ground, perhaps, because the President appoints all judges. But that cannot be a cause for a party seeking a recusal, my Lord, because the President, in performing a constitutional mandate, just like, my Lord, the CS environmental country exercised has title mandate in appointing Florence as a board member, my Lord, cannot be a cause or a basis for seeking or asking for confirmation. Parties will then apply for recusal on the basis, my lord, that two judges or litigant and a judge belong to the same community. Thank you, my lord.
Undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by Lord Joff in R versus Gao. Justice must be rooted in confidence, and confidence is destroyed when right-minded people, the right-minded people that Mr. Ndego was talking about, go away thinking the judge was biased. At paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a juror is alleged to be biased, it is important to keep in mind that the appearance as well as the facts of impartiality has been done. And this is what they say at paragraph 66. And this, my lords and your ladyship, is what I would be beseeching this court to find favor with when you retire to do your ruling. The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own 5 judgments saying this in the Court of Appeal, this rule is to be very strictly applied so that even the appearance of bias is done away with, the appearance alone. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, they then cite a case called R versus Sussex. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. I will leave for you to read paragraph 67, which I also recommend to you. And then paragraph 71, another English case cited. First, actual bias will of course always disqualify a person from sitting in judgment. Even in the absence of actual bias, however, the importance of public confidence in the administration of justice is such that even the appearance of bias will disqualify. And this emphasis added. And I would also invite you to look in the fullness of time to paragraph 73 and 74. Paragraph 81, they cite the case cited earlier, I think I mentioned it. This is the case of Agostino Pinochet. It actually begins at paragraph 80. There's a long passage, I'll not read it on account of time. But at paragraph 81, they cite the basis for the reason the two applicants before you have.
Katika kipindi tunakuletea wasanii.
What's up my guys? I go by the name Rejoinders.
Eti nikipita kwa macho unanipimia, na kama sina pesa unguwezi nipimia hapa Shenster the Poet manze.
Ngoma moto moto.
If you wanna show some love but don't fake it. Hey, dakumenya mawazo makuu. Aniendelea shule.
Vichekesho mkisongaza, mahojiano moto moto, stori za wasanii pamoja na talanta za wasanii.
Sikiwa kasi gani kama pati gani kazi wa shida.
Na pia kwenye kipindi utabambika, utajijenga, utaelimika, utakuza talanta yako.
My name is Rebecca Mutie, I'm a model and I'm Afri Kenya. I'm a student. Napenda kusikiza kipindi cha Bonga na Katoni kila Jumatatu kuanzia saa 9 mpaka saa 10.
Kumbuka ni kwenye Bonga na Katoni ndani ya TAS TV kuanzia saa 9 hadi saa 10 kila siku ya Jumatatu.
This is Bonga na Katoni in TAS TV. Karibuni.
And that letter makes serious allegations, not just about this bench, but about other judges who are not in this matter.
Katika kipindi tunakuletea wasanii.
What's up my guys? I go by the name Rejoinders.
Eti nikipita kwa macho unanipimia na kama sina pesa unguwezi nipimia hapa Shensta the Poet manze.
Ngoma moto moto.
If you wanna show some love, but don't fake it. Hey, ndakumenya mawazo mako. Nani anadera shida? Oh, utani wako.
Vichekesho mkisongaza, mahojiano moto moto, stori za wasanii pamoja na talanta za wasanii.
Fiki wa kasi gani kama wapatikani wakati wa shida.
Na pia kwenye kipindi utabambika, utajijenga, utaelimika, utakuza talanta yako.
My name is Rebecca Mutie, I'm a model and I'm Afri Kenya. I'm a student. Napenda kusikiza kipindi cha Bonga na Katoni kila Jumatatu kuanzia saa 9 mpaka saa 10.
Kumbuka ni kwenye Bonga na Katoni ndani ya TAS TV kuanzia saa 9 hadi saa 10 kila siku ya Jumatatu.
This is Bonga na Katoni in TAS TV. Karibuni.
To talk about some grounds which he says were before the Senate, but which were dismissed. So
that's not correct. That is not correct. Ground number 4, to correct my learned friend, was supported by 51 senators out of 67. It was one of the charges that was upheld by the Senate.
My Lord, those are the matters that are in the petition. And that is when we are
let us restrict ourselves to the application.
Most of it.
Yes, my Lord, the nexus of this application, the nexus of my response, is that the first petitioner has impugned the conduct of 6 judges. This has never happened before in this country, that one person is unhappy about 6 judges. At the same time, my lords, you have been treated this afternoon to issues of bias. The first petitioner had his day before the National Assembly. In that house, 282 members of parliament voted to impeach him. Out of those 282 members, a majority of them were from his own party, United Democratic Alliance, where he is the deputy party leader. They were not biased against him. The matter went to the Senate. 53 senators, a majority of them from his own party, voted to impeach him. He did not raise the issue of bias. My Lord, you have been treated to the issue of weddings. Weddings by the petitioners. I ask this court to take judicial notice that in the National Assembly, and my learned friend Kibe Mungai spoke about our tradition, we come from the same community, the first petitioner last year attended the wedding of a member of parliament, Eric Wamumbi, member of parliament for Madeira, where the first petitioner comes from. That member of parliament subsequently impeached him. If the basis of closeness is the basis of impeachment, how would somebody who have attended his wedding impeach? But he did not impeach him because of attending his wedding. He impeached him because of serious violations of the Constitution. So that if the issue here is a wedding being attended, the first petitioner himself has attended a wedding, and not just as an ordinary guest. He was the father of that member of parliament in that wedding. But he was still impeached. So that, my lords, I want you to take comfort. Those are matters before the Hansard of the National Assembly, which is evidence before this court. Your Lordship should take comfort. The first petitioner in the National Assembly, he impugned institutions. In the Senate, he impugned the Ethics and Anti-Corruption Commission, the National Intelligence Service. He has now impugned the conduct of IEBC. He has now impugned the conduct of the National Assembly. He has impugned the conduct of the Senate. He has impugned the conduct of the executive. So which institution does he have faith in this country? It appears that there is none. My lords, eminent judges, it is a matter of judicial notice that your esteemed colleagues, although the petitioners argue that you are unfit to hear this matter, have elected one of you, presiding judge, to be a principal judge. Your own peers, through a peer review. All judges in the country have elected one of you to be principal judge. Your peers equally have elected one of you to the Judicial Service Commission.
My lords, our application is limited to your lordships and our leadership, not the other judges. There are many outstanding judges in this country with courage, with everything. The petitioner has not cast aspersions on judges generally. We've stated our grounds for the application for recusal of this particular bench.
Your Lordship, the character of judges in this session has been impugned by several counsel appearing for their clients, and it is important that we rebut the issue of their character. Thank you. Your Lordship, my client, the ninth respondent, has also filed a public participation report before this court. 200,000 Kenyans exercise their right of public participation in the National Assembly.
What have these got to do with the recusal? That's the only thing we argue.
If my learned senior will be patient, I'll show him the nexus.
Yes, if you are relevant, admissible submission in reply to the issue we argue.
Exactly. You want to let him stick to the application, which is recusal, not the...
My Lord, I thank my colleagues. The basis of the public participation, and my Lord, when you retire, you look at this. 200,000 Kenyans conducted or went through public participation. 65% of them say that the first petitioner should be impeached. That report is in my client's affidavit. And the reason I'm saying this, my Lord, is that the nexus of this is that the first petitioner has no confidence in all institutions. He has no confidence in 6 judges. He has no confidence in all Kenyans who went through public participation.
Objection.
He has no confidence in anything.
Objection, Your Ladyship, Your Lordship. What is being advanced by my learned senior will be discussed at the merits, including the character and the conduct of public participation. Is it fair for him to go on ad nauseam despite various objections? We strongly object to that line.
I think, my Lord, it is relevant if a litigant has cast aspersions against the court. Some of them he even want them to withdraw. It is only fair, and it is actually relevant, that the court be shown this is a person who picks the candles not just against the court, but against every known agency and institution of the state.
Manager, I was just trying to just be quiet because of this intervention.
Finish. My Lord, I was finishing. And I have been very kind to my learned colleagues. I did not even apply that their pleadings be struck out, even when they were fatally defective. I've said let them remain on record. We are not impugning them. So I am being very kind to my friends. Finally, Your Lordship, if you recuse yourself, you will do a great injustice to the oath of office that you took. the administration of justice, to allow the petitioners to bully you, to forum shop. They have tried to bully the National Assembly, the Senate, now they are trying to bully the judiciary. Will be a great injustice to this country. That is all, Your Lordship.
Thank you. The respondents rest.
Oh, sorry. Presiding judge and distinguished members of the bench, Mahat Somane for the IEPC. I think everyone is in the arena, the independent vote, no one wants it to talk. I think we have something to say about these proceedings. And then the IEPC's position is the Independent Electoral and Boundaries Commission, the 16th respondent to this second cover. The IEBC's position is that the court should stick to first principles when it is determining the issue of recusal. We have been listening keenly to the submissions by the various parties, and our position is that the court has a three-tier constitutional doctrines that it has to satisfy itself. The first one, when the court is determining the application for recusal, is whether there is a reasonable apprehension of bias. The question the court should ask itself is, do the circumstances give rise to a reasonable apprehension in the mind of, number one, a reasonable person, number two, a fair-minded person, and number three, an informed member of the public. So the test is all those three criteria has to be met. The second constitutional criterion that has to be met is the presumption of impartiality of judges pursuant to the oath of office they took must be rebutted, and that with probative evidence, not on aspersions, not on allegations, with probative cogent evidence. The third one, which is also a third constitutional doctrine, is judges generally in our constitutional dispensation have a constitutional duty to sit. They have a duty to sit and to hear all matters. And that duty can only be rebutted when there are valid grounds relating to it. We refer the court to the authority which has been placed before it, Sholei and another versus Judicial Service Commission, petition number 34 of 2014. We refer the court to paragraph 5 of the said decision as it relates to the duty to sit in every matter and not to choose on any allegation that is made on it. We refer the court to paragraph 16 of the same judgment, the very analysis done by Justice Muhammad Ibrahim and the dicta of Ledeni. We refer the court to paragraph 27 as it relates to recusal and reassignment. And if the court applied first principles, the position of the Independent Electoral Commission is the threshold has not been met, the matter should be expeditiously disposed by the court. Thank you.
That is the respondent's case. We have nothing further to submit. My lady and my lords, on behalf of the Law Society of Kenya, our duty is to set out what the law is in view of the facts that are before the court. The law, insofar as recusal is concerned, can be well traced in Kenya in the decision of Rai Group Limited versus Kimeto and Associates. We have exhibited this decision in the list of authorities filed before the court. Permit me to set out what was reiterated in that decision. The real question is whether reasonable apprehension or bias was presented which would make an informed and fair-minded person seized of all the information surrounding this matter and the impartiality required of judges by their constitutional oath apprehend bias on the part of the bench. Now, what is the information surrounding this matter? Let us start with the case of Honorable Justice Freda Mugambi. The charge, in respect of which recusal is sought, is that she was an LLM student of Professor Kindiki Kithure. It has been demonstrated by facts which are not in dispute that the Honorable Judge was not an LLM student of Professor Kindiki Kithure in the Moi University or any university, but instead her LLM was obtained from the University of Birmingham. It is as simple as that. Issue number two, that Madam Florence Oluoch was appointed to a board by His Excellency President William Samuel Ruto. What are the facts? Madam Florence Oluoch was appointed to the board by Soipani Puni. This, my lady and my lords, are the facts upon which information surrounding this matter are to be determined. The next authority which we rely upon is the case of lLIVE Mines versus lLIVE. And the principle set out in that case is as follows. In this context, the reasonable person is not someone who is hypersensitive or unduly suspicious, but rather a well-informed, thoughtful observer who understands all the relevant facts and has examined the record and law. Now, insofar as Honorable Justice Freda Mugambi and Honorable Justice Eric Ogola is concerned, has there been demonstration on the basis of a reasonable person who has examined the record and the law to demonstrate that there is bias, real or perceived? That is the question that this court must answer. What about Honorable Justice Anthony Murema? The charge is that the Speaker of the Senate, the Right Honorable Amason Kingi, attended his wedding. My lady and my lords, there must be meaning to the term learned friends. There are those who have written, including a writer by the name Jess Brailia, a book titled Lawyers and Other Reptiles. And there are those who have also written, including Feroz Norji, practicing an honorable profession. Indeed, we are learned friends. A judge is first an advocate and second, a judge. A judge does not reside in isolation. And if I may just say, for example, I've had a cup of tea with Justice Anthony Murema. I've had a cup of tea with Justice Eric Ogola. I've not been fortunate enough to have a cup of tea with Justice Freda Platy. Well, they are my friends, but I appear before this court and they rule in favor or against me. It is in that context that we must examine. Is the charge against Justice Anthony Murema one based upon information in the mind of a reasonable person who has reviewed the record of the facts and the law? And if your lordships and my lady will return a negative answer as far as these questions are concerned, then you must make a decision whether to recuse yourself or to continue handling this matter. It is my humble submission, based upon what you say, that there is considerable doubt as to whether a case has been made out to warrant recusal. We request this court to dismiss this application. I'll allow my colleague to utilize the remaining 2 or 4 minutes to say something.
My lords and my ladies, Nishuki for the Law Society. My lords and my lady, I will start off by the submission, clarification on the submission that this application for recusal is the court being called to trial. That cannot be further from the truth. An application for recusal is in its very nature a call for the court to introspect. Given that to assume otherwise would be oxymoronic, as the court would be sitting on its own trial, which is what the recusal motion is. My lord, I move on to this duty to sit. That duty is not one that should be carried lightly. That duty flows from Article 159 and the judicial authority that is vested upon you as judges. To not fulfill that duty is to abdicate a constitutional right that you've been granted. Therefore, in making this decision that you're called upon, you must always at the back of your mind have that clear obligation that has been bestowed upon you by the people of Kenya. My lord, we've heard repeatedly from the prosecuting counsels in this issue, and they've referred to perceptions. And it caused me to check what this word perception actually means. Perception flows from a Latin word, which is percipere, which means to seize or to understand. And the dictionary defines this as the way in which something is regarded, understood, or interpreted. That being said, on the facts before you, could they be perceived to put across actual or even apparent bias? That is a question you have to answer. I will discuss briefly what has been said by my colleague, my senior Mr. Somani, on the test that you must apply. That test is an objective test. That is not in question. Therefore, we call it into question the fact that reliance to show the general public perception of this bench was on a tweet by my learned senior counsel Ahmed Nasir. We urge the court not to take that direction, as it would be then turning that test not from an objective test, but subjective test, looked at from the perceptions as they are held by senior counsel Ahmed Nasir. Your Honor, my lords and my ladies, we ask you, please, do not fall into that folly that the applicants seek to drive you. My lord, lastly, I will discuss one of our cases with regards, and this is particularly with regards to the profession, as has been discussed by my seniors, that we are indeed a homogeneous group. We are all advocates. And this is particularly important when it comes to the allegations as against Justice Murima. In the case that we have placed before you of Perry versus Schwarzenegger, it runs from page 62 to 82 of our bundle of authorities, which is duly filed. The court had an opportunity to discuss an issue of recusal that had been lodged as against a judge, simply on the basis that he had a similar characteristic with some of the parties. In this case, the perception of bias is that Justice Murima is friends with His Excellency the Senator, who is a fellow learned friend. And the court said this: in a case that could affect the general public, based on the circumstances or characteristics of various members of that public, the fact that a federal judge happens to share some of the circumstances and characteristics will only be affected in a similar manner because he is a member of the public. This is not a basis for disqualifying a judge. My Lord, having considered the law and the facts before you, it is readily apparent that this application has not risen up to call for your introspection with regards to empanelment in this matter. That is all. Emanate.
My Lord, allow me to just seek a procedural clarification that the right to reply is available only to the persons who, the advocates who filed the application, and not the parties who supported that application.
Let's just clarification at the beginning.
As my Lord, you should also confirm whether it is limited to matters of law.
I said that we made that clarification at the beginning of the proceedings.
My Lord, we could also perhaps confirm whether the reply is limited to legal issues, because if it's another bite of the cherry, we will not have the opportunity then to again come back to redo it.
May I say something, Madam?
The reply will only be on issues of law, nothing else. What the Parliament can say.
May I say what I would say? Yes. I don't think, if I may quote words of Chief Justice Marshall, we are expounding on a matter relating impeachment. Impeachment for the first time. I pray that you allow us to say, you allow me to say something.
I said you can proceed.
Oh, thank you very much. Thank you, Judge. And God bless you.
Thank you very kindly. I will do part of the reply, then I'll pass over to my senior. And I'm amazed at what level the respondents have gone to misconstrue and misconceive the applicant's case. Your Lordship, in respect to the relationships that were drawn, both for the presiding judge and Justice Murima, the charge is that of deliberate failure to disclose the relationship. That my lords, you are aware at the time of the inception of the case that Justice Murima is closely associated to one of the parties, but he deliberately failed to disclose. Equally well, the presiding judge was well aware at the inception of the case that his spouse is greatly connected to some parties in the proceedings, but again failed to disclose.
You should not tell which parties.
May I?
You say clearly, if you can't understand what you are doing, please go to the affidavit and read the affidavit again.
My Lord, I'll then go to
reply on matters of law. I will not allow you to misrepresent facts. You have an affidavit.
And to embarrass the legal profession.
Yes.
Your Lordship,
you have an affidavit, Mr. Negwa. If you can't understand what we are talking about, verbatim, read verbatim from your affidavit.
Your Lordship, may I draw your attention to paragraph 74 4 of the judgment of the ruling in Lavini, the judge says that due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence and the applicants have that will be neutral when it comes to the hearing and the determination of the arbitration. That, Your Lordship, is a confidence that has been eroded. On the question, Your Lordship, on the duty to sit, the duty to sit must be accompanied by transparency and accountability to the parties appearing before a judge. Your Lordship, the duty to sit and the oath of office taken by a judge or a judicial officer must be executed in a manner that brings confidence to the parties that appears before a judicial officer. Lordship, it's our humble submissions that that confidence has been eroded. Your Lordship, the arguments by Mr. Nyamondi that the parties are forum shopping. Your Lordship, this bench was constituted pursuant to Article 165, Clause 4 of the Constitution. And no petitioner herein has the capacity to direct the Chief Justice who constitutes the bench as to which judge to sit in a particular bench. There is no possibility, Your Lordship, therefore, for an argument that parties are forum shopping. At the inception of the proceedings, Your Lordship, we appeared before you and made arguments comfortably. Little did we know that we would be faced with an application of this nature due to the failure of the honorable judges to disclose those material facts. I invite Kibe to proceed.
My Lord, while during the course of, I guess we've been here for about 5-6 hours when this application has been going on, and there are 2 things that have been crisscrossing my mind. My Lord, the first issue is the issues of substance and the issue of perception, the optics. What will be the optics, my Lord? The optics, my Lord, as we sit here in public view, in the glare of Kenyans, some of whom, if you use the reasonable test, are professionals, people who have studied above Form 4, probably half the population. The other half of the population are people who are definitely below Form 4. So what's the reasonable person's test here, and what are they seeing? The first thing, my Lord and my ladies, that they are seeing is that the petitioners appear to be categorical, for good or bad result, that they do not have confidence in the bench. And examinations of the fact may still prove that they may or may not belong. But the issue is, the test as far as when you read all these cases, in matters particularly that are that have some political angles, perceptions is everything. And perception is a big issue. So that, my Lord, the issue therefore would be, shall we proceed on the basis where from the word go, the petitioners clearly have appeared to the rest of the country, they have got no confidence. With the same zeal and spirit, the respondents who are being accused for good or bad result are saying, we have full confidence in them. That should trouble us. Because at the end of the day, it is the declaration of whatever decision is made. It will be done from the prisons, oh, we told you, we knew this, they were going to do this or the other one. In huge cases like this, it should never be that way. I go to the second issue,
the issue of the Honorable Attorney General. I listened to the Honorable Attorney General. The Honorable Attorney General has made an application, one of the applications to set aside the orders. I went back to Article 156. 156, on one hand, suggests the Attorney General is the President's lawyer. There is another clause, I don't know whether it's 11 or something like that. It suggests that the Attorney General is a guardian of public interest. And you ask yourself, the Attorney General, without doubt, when it becomes to the President, he's 100% sycophantic, a President's lawyer. But when it comes,
a new issue, that
which
was
is the
never
issue.
part of the recusal application.
That is not an issue. Let me proceed. My Lord, the Attorney General is the guardian of public interest. What is the public interest in a process of impeachment as we stand here today? My Lord, that public interest must be the country has been treated with an imperfect, I'll not go to the details, with an imperfect impeachment process at the National Assembly and at the Senate. When it reaches towards the tail end of this process, the public will be treated to the fact that in processes that presupposed that you would take about 75 to 100 days were conducted within hours. So that the bigger questions, my Lord, would be that there is a complaint that is being made, a serious one, of the right to fair hearing and human dignity. Rights that are not derogatable under the Kenyan Constitution, even during an emergency. My Lord, if you are faced by an Attorney General who, pursuant to one mandate, their conscience has not been touched, that there is some public interest in looking at these things a little bit from the perspective of the Deputy President and those who feel like the Deputy President, that a fair and square deal has not been granted by the processes that have taken place. Your Lordships, that should concern us. I go to the next issue, the main issue that he cannot deny, he did say. My Lord, you are being told that we are in serious danger, we are in the throes of chaos or something like that, and there is some danger. My Lord, the truth of the matter is, the time that has been prescribed, thank God, by the Constitution itself, they are far from over. And the petitioners here keep saying, and Honorable Mwiti has told me, tell the court that if the court can be able to hear us from next Thursday when all of us have done responses and whatever amendment, we are ready to conclude that issue. We are ready, we know the timelines. So that the connection, therefore, of somebody saying that, oh, the only public interest here, and this is the Attorney General, is that we must swear by hook or crook before the petition has been heard, that also should be a matter of grave concern.
Sure.
Because the people...
There was never a submission like that, and I think the Council must have some respect for the truth. Nobody said anybody must be sworn by hook or crook. Please let's respect the truth.
My Lord, I think the language always in submissions belongs to Counsel, but what Professor Geru Moigari, my teacher, said is this, that we are in the throes of instability, something to that effect, because if we do not complete the process that was started by the National Assembly, a huge power vacuum might arise. And that it is why, when I use hook or crook, it is why the only obsession that we hear, or conservatory order taking out, that is the context. My Lord, I go to the next issue. Who is this who made the oath of office of Professor Ojienda? My Lord, there was the question of CTS. The question of CTS, I believe, had dealt with it, and all those kind of issues, and we pointed out that the issues of CTS, whereas we had talked about them, they appeared for the first time, not from the respondent's affidavit, but from the ruling that the court made. I don't need to say anything about it. The respondents had said nothing about them. My Lord, to Professor Ojienda, there is a question of no, I have to respond. There is a question of the internal memo. The question of the internal memo, again, that was not a matter that was ever placed here in any affidavit, as far as I'm concerned. I think these are not for today. No, these are not for today. No, my lord. If they have a date and I had a different but they would get uncomfortable, let me pass that. In fact, it's not the main guy I have to deal with. About all these issues, we talk about the internal memo. But well, if he says he didn't, then we hope I imagined it. I can't answer it. But that's what my note says. I don't mind. We can't fight over a memo, and as I say, we are dealing with some other submissions. My lord, the My lord, there is a question of Mr. Nyamodi. And Mr. Nyamodi was talking about the issue of the what?
His notes. Will the court allow me to remind him what I said?
No, the only misplacement was this one.
Maybe we should correct that as well, because it's been said 3 times. There are no guides in court. There are
my learned colleague, Professor, the only issue, very frank. Is that the way? My lord, the issue that would require the clarification, let's go to Keroboya. I believe there is no doubt about the issue of Keroboya. My lord, the issue that was raised, and I believe this is the last point that Professor Muigai was making, regarding the issue of where it was alleged that the issue is proposed with regard to the issues of Keroboya that found themselves in the ruling of yesterday. And my lord, first of all, I wish to point out that there is a notice of appeal that is one of the annexures in the supplementary affidavit and raises specific issues about preempting and the issues dealing with matters that were yet to be handled. I need to clarify that is one of the issues when it talks about the issues of res judicata. And when it comes also to the issues of res judicata, it is important, my lord, that it is pointed out what was the subject matter of yesterday's application. It was the interpretation and application of Article 165(4) of the Constitution in relation to the powers of the Deputy Chief Justice. The said ruling, anything else that may have been said that was outside that is direct issue that was before the court, that was not an issue for that ruling. And therefore, dealing with matters that are outside there and you are be told the ruling has dealt with those matters which it ought not to have dealt with, so it has become res judicata. It cannot become res judicata in our submission. My Lord, with regard to the issue of the friendships, I think this is something that they have been preoccupied with. My Lord, nobody is trying to criminalize friendship, not at all. But my Lord, there are always degrees of friendships. When it is alleged, for example, that friendships between Kibe and Ndegwa is of such a close proximity that Kibe and Ndegwa ought to disclose that fact to any other person, it would be different, for example, to my friendships with Harvey, somebody we just meet and do a few cases with. So that, my Lord, the issue at the end of the day is one of degree. To what extent are there interactions between these two individuals? Because, my Lord, and we were saying that you may feel that there are issues. Issues could well be raised. That who was so that, for example, was Judge Mrima from the Kenya Law Reports records, as people would be sending materials to indicate that. The lawyer for Mheshimiwa Kingi during the case with Esposito, again the answer would be yes. So this is not a casual friendship. It is a friendship that is over. There have been client, lawyer relationship, other personal relationships are all there. So that, my Lord, you cannot behave.
Now, how do we respond to that?
Mr. President.
Yes, my Lord.
I intended to explain myself.
Yes, my Lord.
Interjecting in this application. But I think the statement you're making is factually incorrect. In the Esposito matter, I appeared as an advocate for IEDC, not Mr. Kim.
Thanks for the clarification. My Lord, the issue...
I think if we people can respond on issues of law, it would really help us, rather than going back on issues of facts.
Yes, so that, my Lord, there was a question of forum shopping. Forum shopping, I go with what Ms. Ndegwa has said. If this bench recuses itself, it does not mean that we shall choose any of the judges that may replace this bench. My Lords, on the issue of Mr. Moshemi's submissions, my Lord, Mr. Moshemi's submissions, we start first of all from the premise that Mr. Moshemi did not have a replying affidavit. We did not have a replying affidavit. I tried to object in order to say I respond. We want just to draw the court's attention that if you want to take factual deposition, you take somebody else's affidavit that has been deposed to on oath and say, this is not true, you did not sign here, you did not do this, you have not subjected it to any examination or anything. That would be completely to go outside the rules of evidence as we understand them. And therefore, for as much as the issues of Mr. Moshemi is concerned, I urge this court to disregard them. There are two other more important issues that we need to point out. My Lord, using the text of the reasonable man and woman in Kenya, it is a question of splitting hair. President Ruto and Tuya. It's splitting of hair for the simple reason that during even the Senate proceedings themselves, we were treated to a situation in which, and one of the principles was indicted, in which political positions at cabinet, board levels, and others were toss-ups for purposes of political dealings. The average knowledge, because that is the standard that you say, a reasonably informed Kenyans is aware that any new government comes to office with its own appointees to those board positions, permanent secretaries,
Mr. Kibe, you are going beyond what is really necessary for this.
I think you have made your submissions. Respect the court and your colleagues. Reply on issues of law, please. I thought that was an issue of law.
My Lord, I finish with the question that was raised by the one without an affidavit by Michael Moshemi. The issue of Mr. Michael Moshemi, where you are told that for purposes of gauging bias, we should be able to look at the MP for Madeira, who did not, who voted against the deputy president, although he was his father or something in the way. Now, the direct reference to that would also have to be taken from the bar, the way it was also read from the bar, and the direct reference to that is that the wife of this MP.
Well, no, that's a question of fact.
Yes, it's also the same question of fact.
That
was going
to we should understand what we mean by matters of fact. Questions of when, who, where, what happened, who did this, who did that. Those are all matters of fact.
But the only exception, and we said, when we tried to stop, to stand to say that Moshemi is dealing with those issues, you told him, my Lord, you responded. So I asked that to respond to that issue. That's the last issue. And the response was this, that the wife of that Madeira MP is also on record as having said that I voted against the DP Gachagua because he insulted us and said our wedding will not last. It had nothing to do with it. So that we cannot know that is what is happening and it is all public. So that the law can show so that the law can show to me. Yes.
How do I record that?
No, the way you recorded, I think I saw a record from the other side. Yes. Well, I don't know who recorded, but he was allowed to say in open court that even his own MP voted against him. So to be able to demonstrate whatever point he was making. And I'm also saying that from the bar, let it also be made clear that the wife to the she's also an honorable MP, said, I voted because the DP said that marriage was not going to last. Not on impeachment. So that may not the long and short of it, because we've had a long evening, is that I beseech this.
I suppose the marriage still subsists.
It still subsists. and we also hope, my Lord, that when we are that when we are hard with this petition, the tenure of the DP could proceed. So that, my Lord, the last point that we need to get is that there is somebody, I guess, who is a doctor, and something that Dr. Camino has said, a moment of introspection. This moment of introspection is important. Because for you, my Lord, the issue at the end of the day will remain that an important case is up for determination. Besides the information that is here, if the counsels were to show what is it that other things that are coming up in the course of the proceedings, that questions of perception is such a huge issue, my Lord, that if you are to apply the old rule that you are being told to apply, that you have a duty to sit, anybody who does not come with a smoking gun, disregard it and sit nevertheless. My Lord, that would defeat the meaning of let justice be done and be seen to be done, but more importantly, it would also affect my reading of chapter 6, the one that would be said that if there is somebody questioning, like the DP, he has written a complaint, it will be right, it may not be right. And it may be upheld, it might not be upheld. But my Lord, the question is as we await for that day, should any appeal or anything that results from this case relates to the issue that related to the conduct of the judges, or we deal with the issue of the moment. But with those submissions, I urge you respectfully, weighty as an enormity of having to argue this application, hold as we have tried to convince you, there are more than reasonable grounds that in existence, that there would be something wrong if one were to say, I will disregard all these issues of technicalities and proceed anyway. I thank you very much, Your Worship. Evans, oh, sorry, my Lord Evans, there is an authority, been under a lot of pressure that he needed to say something about it. And it's part of me.
What will be, how will others respond to the authority?
No, in his answering, the authorities that were used, cited.
Just note that he has no right of reply.
No, I'm leaving Professor. Yes, is that to refer the application?
Thank you to the court. I am fully aware of the long day that it has been, and we don't take it for granted. Thank you very much. I want to respond to the following issues of the law. Reference was made to the other side, attaching affidavits to lawyers on this side. Affidavits belong to the deponents, the Statutory Oaths and Declarations Act. Conservatory orders are constitutional orders. They are aimed at protecting the substratum of the case. It cannot be weaponized against this side. Third, the diary case. What should concern this court is the pertinent fact and the act that recusal happened, and what the Supreme Court said about that recusal. That's all what this court is supposed to consider. My good friend, my senior, Mr. Nemodi, urged the court to ignore certain electronic material that was presented for the lack of a certificate as required by Section 106. We'll urge the court to take cognizance, number one, of the short timelines, the reflex within which advocates were required to make the returns. In any case, we will endeavor to find the certificate. In any case, I want this court to be persuaded by the decision in BPI that formal rigidities should not supervene, especially in a constitutional context, bearing in mind the exigencies and the demand. Because under the Mutunga rules, we can even submit here on non-epistolary basis. Finally, let us sit to this good cause and we respect each and every of the judges and our colleagues on the other side. 4 things belong to a judge: listen courteously, answer wisely, consider soberly, and decide impartially. Those are the words of Socrates. Thank you, Your Ladyship, Your Lordship.
I think we come to the end of our proceedings today. We will deliver a ruling tomorrow.
My Lord, you said you'd allow me to talk.
The problem is I don't know whether you are talking as a respondent because you had spoken earlier. Is there something else you want to add?
My Lord, may I say this to the members of the court? The matter we're dealing with is under Article 145 and Article 150 of the Constitution. We need to approach this matter very broadly, not to be tied by rules of practicing civil procedure or what and so on. We are dealing with a delicate matter, starting with the security of the country. And if I may say so, I'm going to say so, Your Honor, with tremendous respect. You need the best legal minds and the best experienced people to address you on this one. It would be wrong to stop me from addressing you on this one. This is the first time we are having a matter of impeachment. Oh, thank you very much. Thank you very much, my Lord. Thank you very much. My Lord, on my own, and I believe I'm speaking also on behalf of the people of the Syria. We respect all that. I respect our judges. I have been very privileged in my entire life. I was spent it saying, may it please Your Honor, may it please Your Lordship. I've interacted with the judges, both at my home, eating with them, they have invited me to their homes, and so on. And I had the privilege of working as a judicial officer, as a resident magistrate in the colonial days. And I had the privilege, rare privilege, of even marrying from judiciary. Your Honor, this is people serving as a judicial officer are decent people. We may have some isolated cases of some people who are not what we think they should be. But the people on the whole serving the judiciary are decent people. And as a matter of fact, I've said elsewhere, very loudly too, Kenya is what it is now because of the judiciary. Without judiciary, you would have something quite different in the country. Judiciary has saved the Kenya, has built the Kenya. We enjoy respect that we enjoy in this country because of, or in the world, because of our judiciary. Our legal authorities, by our judges and so on, are cited everywhere now, including ICJ and so on. They are cited with approval that they are good law and so on. We respect our judiciary. But my lords and my ladies, if you look at Article 145, when you're considering Article 145 and Article 150, we have to be extremely careful. We have to be extremely careful. This is a matter touching on security of the country. And you cannot afford just to stick to certain procedural things or certain evidential things and so on. The court is called upon to look at things very broadly, very, very broadly. What you are saying to your lordship and my lady, very, very respectful, is that so far as I'm concerned, there's nothing wrong with you at all. But there is a significant portion of the Kenyan population who believe that you are not, with respect to the right people to sit and take a case. And I'm saying to you very respectfully, there's nothing wrong. Give us a good opinion, a good judgment on what you have respected to you, and you get out of this case. We do not want protests in the streets. People to come to the streets and say, oh, the judges who are biased, the judges who are biased. We do not want that kind of thing. Some of us are too old to leave this country to go to Uganda, or to go to Zanzibar and watch and so on, to stay there. We want to stay here and die here. I have gone through an experience which a number of you have not seen at all. When Amin came into power in Uganda, in Kampala, I saw things that were not, which were not acceptable. And I'm saying that, look, let us try as much as possible.
But not at those points of law.
May I say something? With respect to
Dr. Kamula, we will consider what you have said. I think you are submitted, and we have understood you. You have understood your submission. If you want 2 or 3 minutes to summarize.
Thank you. You always serve me in mind, my Lord. And also, the professor talked about how let me now give him block, which I don't think he knows. My lords and my lady, I'm asking you to apply a precautionary principle. A precautionary principle is a principle of environmental law. But this principle has now been translated, it is used in matters of security. On our part, we invaded Somalia when the party was in power because of this precautionary principle. And I'm inviting you very respectfully that you apply that principle, a precautionary principle, when considering the matter under the Article 145 and Article 150. Under Article 145 and Article 150, having in mind the security of the country, so that we do not have protests in the streets of Nairobi, which will destabilize the country and which will put all of us in an embarrassing position. Your Honor, with respect, I'm asking you again, apply that precautionary principle. And when we ask you to get out of this case, we are applying that precautionary principle that we do not want certain evil people in the streets of Nairobi shouting, Hatujapata justice, Hatujapata justice.
That is a threat.
Thank you very much.
That is a threat.
That's what?
It's a threat. Don't threaten.
What's the threat? Precautionary principle is not a threat. Yeah. Can I sit down? Yes. I would have liked to go on further. No, please. And may I say with tremendous respect, my Lord, may I say with tremendous respect, I'm very well read. Thank you.
My Lord, your leadership is one urgent issue that I would like to draw the attention of the court to before the court rises. Lord, in petition 565, there were conservatory orders granted by your brother, Mr. Justice Chacha Waiter, on the 18th of October. But they expire today. My Lord, the purpose of the conservatory orders were to preserve the purpose of the conservatory orders were to preserve may I continue, my Lord? The conservatory orders preserve the substratum of the petition and the interlocutory orders application in order for the court to have time to consider my Lord,
you're listening.
I was waiting for my Lord Rima, not Monema. To preserve the substratum, to accord the court time to hear submissions of the weighty issue of law of the Constitution. So my plea is that we extend those orders because they were to expire tonight.
May I add something?
Can we get one response? Only just one response.
Madam, very briefly. In relation to the question of the conservatory orders, the court will remember that we also filed an application and a certificate of urgency on the question of conservatory orders. If at all it is now the adjourned position that the issue as to whether they can be extended or not should be brought before the bench, we are willing, ready, and able to argue right now.
So these are orders that have been granted. Where it forces nothing to argue, we have not come to the applications. In fact, there are another 2 applications for conservatory orders. And I assume that the application by the Attorney General, the Senate, and the National Assembly for the discharge of the conservatory orders will be held together with these other 2 applications. No?
I entirely agree.
I am addressing the court, not the bar.
I entirely with the respect of all the performance.
If this court is bad for something, it is bad for everything. Until you have ruled on your own suitability to hear the matter, you cannot address any substance.
You are right, Professor. This will be meeting tomorrow at 1 p.m. for the ruling.
Yes, thank you.
Katika kipindi tunakuletea wasanii.
What's up my guys, I go by the name Rejoinders.
Eti nikipita kwa macho unanipimia na kama sina pesa unguwezi nipimia hapa Shensta the Poet manze.
Ngoma moto moto.
If you wanna show some love, I don't fake it. Hey, kumenya mawazo makuu. Nani anedera shie.